Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
You especially want to go to court if it's bullshit charges because you get them thrown out.
Yes, Your Honor. I'm here for Tony Alexander. He's in Del Rio, filling the court this morning. Trying to make the court know that's where he's at.
All right, is he in Del Rio in felony court for jury trial?
No, not for jury trial, but he's there on other things.
All right, tell him his client is here on trial.
He doesn't know that, so he just wanted to let the court know that there's a possibility he might not make it back. Go late this afternoon.
Okay, tell him he needs to make it back because this is a jury case.
Scratch all that. Oh, that was terrible.
All right.
I apologize.
And tell him his client is dressed for trial in a Nightmare from Elm Street t-shirt. The zombie apocalypse may be upon us.
This police unit is trying to box him in, but instead he just crashes into the tree and away he goes. But let me widen out. I don't know how far this will take him. Yeah, he's basically cornered. Wow, look at this. Off the road and onto the freeway. Oh my gosh, so he is on the freeway, going wrong side of the road here on the 91 freeway, going eastbound in the westbound lanes. This car is smoking. I pray to God that the vehicles that are coming in his direction see this car coming at them and they're able to stop before we see a collision.
Welcome to the Court of Public Opinion. I'm playing DJ up here, just hitting all the sound effects. I hit the wrong one. I'm like, I can't stop it.
Easy.
I can't just cut off Judge Stephanie Boyd mid-sentence. I mean, where's the right point to interrupt Judge Boyd? That's the question. But somebody absolutely nailed the zombie apocalypse sound clip this morning. Whoever triggered that was incredible. That was perfect. It was right after the Nightmare on Elm Street T-shirt. Boom! The zombie apocalypse may be upon us. Good morning. Welcome to the Court of Public Opinion. I am the recovery addict. Oh man, it's a good day. I've got walls in most of my bathroom. That's a good day. It was a good weekend. We got stuff done.
There's a lawsuit.
Rest in peace, drill. By the way, for those that know, I lost my Oriobi drill over the weekend. It was tragic. We had a brief ceremony outside commemorating all the projects I've screwed up or just screwed with that drill, and then laid it to rest in the garbage. So.
Scratch all that. Oh, that was terrible. I apologize.
Yes. Okay. Welcome. We're excited to be here today because it's still verdict watch. Did we bury it in the backyard? No. It's just throw it away. It's like disposable, right? Rest in peace, Ryobi.
I'm not a camel.
Hashtag rest in peace, Ryobi. All right. Let's see. We need. Good thing we didn't get rid of that emoji, says according to Woo. All right, we are...
This is not Burger King. People do not get to have it their way.
Right. I understand. Where was I at? I was doing something very important.
I'm not a cat.
And I don't recall what it was. I think it was welcoming John.
When are we going to break for lunch,
I think I was welcoming John. Let's see. John Link, first in chat today. Congratulations. Welcome, my friend. Welcome. Good to have you here. Orange Courthouse and all. You know the drill. You know that first in chat is not really something you really want to do, but yet you did it anyway. And because of that, guess what? We're going to send it to you with internet ownership for the rest of the day, or at least until we go live again. So the internet is all yours, my friend. Good luck, good riddance, and good night. No, just kidding. If you want to commemorate this fantastic occasion with your own certificate of internet ownership, you can get that on the shopping tab of our YouTube page. Just go ahead and pay the 50-cent fine, and you can download that yourself and fill in the blanks for your name. All right. Are you guys going to be one of those cool people that has a toilet planter in their front yard? No, Lizzie Dog. No.
Is that somebody correct? Just sent me a video of roaches fighting. I don't know who won.
Because we have amazing people. First of all, we have some industrious and creative people who literally drive around our community and pick up items that they feel that they can reuse. And so one of the, it
That
looks
like
like we're
stolen
just
as well.
throwing garbage out by the street, but literally that toilet was in perfect condition, minus the seal on between the tank and the bottom. And somebody needed it more than I did, and so they came and they got it. First, they took the toilet seat, which was one of those soft closed toilet seats, so it doesn't make noise in the night when you're like, bam, and close the seat. Yeah, they came and got that first, and then somebody else wanted the whole toilet, and they took that. And somebody's come, and they've gotten all the wood strips that we knocked out of the wall. They're like 115-year-old wood slats that are beautiful. And so somebody picked up all those. Somebody picked up the windows that we took out of our house. They had the little the shell, opaque stuff. They took that. The only remainder that was left was the broken pieces of mortar, which our crew, our city comes around and picks up all the leftover stuff and just cleans it right down to the dirt. It's like spick and span. So there's no garbage out by the street. It's one thing I wasn't used to when I came here was that you can just throw stuff out by the road and people will come pick it up for you. The Defense Rest, welcome to the gallery. Good to have you here. Welcome. Great to see you with the blue courthouse by your name as well. Let's see. Are we planning on listening to the new Taylor album together, right, Tisha? That's one way to end the channel with a bang. I think we'd probably get, 15 seconds into the first song, and then I would be done. I would be done because Taylor comes down on people like a ton of bricks.
Are we going to address subject matter jurisdiction?
Oh, let's see. Is the tub gone? No, the tub is still in the house, Melissa. I have to get it outside. And right now we're storing all the tools that we use in the bathroom in the tub because that's very convenient. But it's we've got a large landing upstairs outside, because the bathroom upstairs is at the top of the stairs, and then you walk over, there's a huge landing. And so it's decorating our upstairs landing right now. And until my back feels up to it, it's going to stay there.
I was kicked back, taking it easy.
All right. Karaoke. I'm not going to risk it. Okay, what time did the jury leave on Friday? What is the deliberation clock at? Great question. They've had 9 hours of deliberation. They're going to start at 8:30. I've got birthdays. I forgot to sing. Anyway, they're going to start at 8:30 Arizona time, which is Mountain Standard Time right now. So we're going to pick that up in just a minute. But first, we have to sing happy birthday to those people who are celebrating either over the weekend or today. Which those people, according to Sharon McDonald, who is never wrong, is our Kindles, Megan, Tina, Justin, and Dale. So join with me in singing happy birthday to these wonderful folks who have chosen to spend their special day here with us. We'll do that to this familiar tune. Dancers at the ready. Warm up with me. La 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 la. I don't care if you're in a cubicle or in a car in the traffic. Now is the time to belt out this wonderful song for these wonderful people. Now that we're warmed up, here we go. Everybody, blend your voices. Happy birthday to you. Happy birthday to you. Happy birthday, Candles, Megan, Tina, Justin, and Dale. Happy birthday to you. Kendall's, Megan, Tina, Justin, and Dale, have a wonderful day. This is your day, after all. So why not have it be a wonderful one? And make sure you start off by having free pancakes at Denny's, which I think they still do. So whatever you have to do to make that happen, go ahead and do that, because nothing beats pancakes at Denny's, except for maybe the German pancakes my son made for breakfast this morning, which were quite tasty. Wonderful. Happy birthday to everyone who's celebrating a birthday. Realize there are a million places you could be, a million people you could be with. Here you are with us. Thank you. It warms my heart. Thank you. Christine, 27th wedding anniversary here. Congratulations, Christine. That is wonderful. Happy birthday to everybody. Hello, Ms. Nikki Chicky from Australia. Welcome. Thank you, everybody, for joining in. Even if you're brushing your teeth, Tish, it sounded great through the bubbles. Uh-oh, there's another buffer. What was the buffer? Christine Perkins celebrating wedding anniversary today. I caught it. Did your son propose? Okay. They are booking the wedding venue. We have ordered the wedding, we've called the restaurant for the wedding meal. We have ordered, I think, ties and matching ties and stuff for the groomsmen. We've got details, the flower girls' dresses. We have things lined up like crazy. And we found out he has not proposed yet. Officially he's not proposed because the ring hasn't arrived. He ordered some custom ring or something, and it's still being made. So I'm like, wait. She hasn't. Hang on. I thought that was the end. She hasn't said yes yet. We have ordered tickets. We have booked Airbnbs in 2 states. We have scheduled a month out of our life to fly over there, and we find out that he's going to get around to it. I think I'm going to write him out of the will until he gets this done. Because flying 7 people across the U.S. and putting them up in a hotel for a month and rental cars and everything else, not cheap. Let me just say, not cheap. And And he calls me up the other day and is like, hey, I'm not sure if I've got enough money for tuition. I'm like, now you tell me. It's due when? Today? Well, if I hadn't just dropped $8,000 getting to your wedding, which apparently isn't a thing yet. Okay, I'm sorry. Oh. All right. Let's see. Britt Bottoms, thanks for bringing that up. It was going to be a good morning, but now I'm back where I was Friday. So it's going to be good. A month where I don't even know yet. All I know, here's what I know. I know that the place we are staying at for a month, well, for most, I think it's a month somewhere and then a week somewhere else. The place we're staying at for a month, we're out, he's getting married it's by Canada. It's like Idaho. Well, Idaho's by Canada, right? So any part, I can say that because my wife's from Idaho. Anyway, the place we're staying at has fiber internet, and that was my number one thing, because I can't just quit work for a month, right? Court does go on. I can't just stop. So anyway, I think we're going to be up in Meridian area, which I think is near Boise, which is not far from BK, a couple hours, or you could get there in a couple hours for sure. Anyway, so that's where it's going to be. We're going to be, this is also like a vacation for the family because we haven't had a vacation in the last 5 years. And, at least not like a really big vacation. As a matter of fact, this is the first time I've taken more than a week to go on vacation with anyone. My family. My family has never been on a vacation that lasted more than 5 days to this point in my life. Anyway, let's see. Too bad you don't have those travel credits. I tell you. Apparently. AZ, you ask me these questions, and when I don't know the answer, it makes me look bad. I don't know. He's in his 20s, early to mid-20s, I think. When is it? I work in Meridian. September-ish, Denise? September-ish? Anyway, so what we're doing, can I join Vegas? Sure. I'll send you the date. I think it's actually in chat already. Ben, I think I already told you. Anyway, so we have some 2 locations picked out. We're going to go see people we knew before. We're going to basically just go have a lot of fun in a different area than we live right now, and I'm going to miss it all because I'm going to be working. So I'll be going live from a place with fiber internet, and now I just have to figure out how to put all of this in my suitcase and where to buy clothes when I get there because I won't have room to pack clothes. It's gonna be different, a little different. So I don't know the ages. Hey, Karina, in my defense, my daughter came up to me yesterday and she said, "Dad, which day is my birthday?" And I knew it, first try. And there were friends next to me talking to me, and I thought I looked like the best dad ever because I remember her birthday, but she's the only one I remember. She's the only one whose birthday I remember because it falls on a holiday for me. Anyway, there's a confession. All right, what are we doing? We're on verdict watch, which doesn't start for a little bit of time, so we've got some time. Ship your clothes ahead of time. Ship your clothes to your son's address before you leave. He already has my kilt. Not that I was going to wear a kilt, just regular occurrence. would that be fun to wear to court? Just a kilt? Would the judge throw me out? What if your son's girlfriend watches your channel and knows now? Well, we've been talking about it. I thought it was a done deal. I was just waiting for like the engagement pictures and stuff, but apparently it's not. Robin, what trial are we covering? We're still in verdict watch, so we're not ready to take off anywhere. We are going to go back and watch just a wee bit of some of the questions that happened during verdict watch yesterday with the 4-cam solution, because we get different audio and it tells a little bit different picture than what we thought happened when we watched on the pool feed. So let's see. My brother got married on his birthday, so we wouldn't forget his wedding anniversary. Smart man. I got engaged on February 29th. Kid you not. I only have to remember that every 4 years. I think Mrs. Uri is teaching right now, so I'll probably get in trouble later. Let's see, why a month? Big Rig, because my kids miss all their old friends, and there's family we haven't seen for 5 years. There's just a lot of people, and trying to you can't really just show up and expect them to be available the times that you're on vacation. So that'll give us enough time to do some activities, some things we love back there, sightsee, do some educational trips as well, and everything else. And plus, we got a really good deal on the Airbnb if we booked it for a whole month, and it saved us a ton of money. So, did you enjoy seeing all the addicts on Friday like we did? It was a lot of fun. It was very stressful. I was never sure what anyone was going to say, and we're pickles, not politics, and sometimes it got a little crazy. So I was very stressed out, but it was a lot of fun at the same time. Let's see. We have a couple comments I missed that I need to jump over to. If you wait just 1 second. Defense Rest, welcome to the gallery. Great to have you here with the Blue Courthouse. You can never leave now. You're a member. Mrs. Kevin, whoop whoop. Happy to be here. Loading the kids up to go to some doctor's appointments. Yay. Listening like a podcast. Love you guys. I'm excited for today. And Meg Osborne says, wow, 8 months. Love y'all. And it's my 45th birthday. Meg, happy birthday. Happy Earth Day, everyone. Is it Earth Day? Is it Earth Day? That's cool. I missed something, so let's see. Buffer, top market setup. Okay, is it time already? Thank you, Amber. I'll get this set up. This is for the case that's going on in Idaho, which is the Chad Daybell case. So let me get this one configured. Live stream to a top mark. It's day 7. Is it day 7 in that one, or day 8?
The zombie apocalypse may be upon us.
Let's see, it's day 8. Thank you, Ashley. Okay. Just 1 second here, trying to get everything set up.
Squirrel!
All right, Dream of Landry. I love it here. 9 months. Look at that, LSU pride there. Welcome. What trial is next? I'm not exactly sure. There's a couple things happening. First of all, we've got some updates and some other trials I want to cover just quickly. Let's see, where's that last update? We have one. There's an update in Adam Montgomery's trial, and we followed his firearms trial, but not the murder trial. But there's an update in the murder trial, and the reason why I want to cover that is because he did something that we haven't really seen very much before, and he played hooky at his own trial and just didn't show up. So there's an update there. We're going to read the order on that one. how can you just not show up when you're in custody? But he did. So we'll read that. We also have, let's see, today there's a hearing, I believe. Let's see, the 22nd. Yeah, there's a hearing in the Kowalski J. Hatch case that negotiations or mediation fell apart on day one after just a couple hours, ended abruptly. So they have a hearing, and it's a scheduling hearing. So it sounds really exciting. It's like, hey, mediation fell apart, judge orders a meeting. The meeting is to schedule another meeting. So I doubt anything really significant is going to happen today, but we want to follow what happens so that we know what's going to come up and the schedule that's going to happen on. So that's happening. Let's see. Getting everything set up. Let's see, where's over here? Nope, nothing there. Okay. It was fun to watch Judge Boyce bring the hammer down, and he did bring the hammer down on that attorney who filed that weird motion last week in the Daybell case. And when unfortunately we have not been able to find exactly what was in the motion, and the judge has issued a very sweeping seal on what was in there, but we'll see if it comes about. Let's see. Okay, let's present that, share screen, that tab with audio. I might just go live just as soon as the feed comes up. I'll go live. How about that? All right, where else were we at? I found a channel that does Florida high-speed chases, and got to see one from my own neck of the woods yesterday. That was WFLA, wasn't it, Melissa? I think WFLA had a high-speed chase. They don't play nicely with the rest of us, but they had some good video. Chad Daybell's lawyer is pretty good. He's getting his money's worth, especially considering he's not paying him anymore. So Chad's out of money. He's already transferred the deed to his house to his lawyer. He has basically nothing else to give him, and the court has ordered the lawyer that even though he's not getting any additional funds, he has to continue covering the case through the end, which was an interesting setup. Okay. Vicky. Hello, Vicky. Thanks for joining us last week as well. Gifted 5 memberships this morning. Thank you, Vicky. That was super generous. And congratulations, Danny, Christine Perkins, Carla, Janice R., and Christina. All gifted memberships this morning. Thanks to Vicky's generosity. Wonderful people. See, it's such a weird deal, though, when the House had the evidence. It is crazy. That whole case is crazy. Just absolutely nuts. Steal Your Heart, Susan B. Woohoo! 15 months. Susan B., one of our OGs. Scooper. Scooper covers it. I'll have to look for that one. I'm not familiar with that. I think FLA had the helicopter in the air. So he might have been covering FLA's coverage. See, Vicky says, a recovery to say thank you. Your wonderful community hung out with me in my first live over the weekend. I couldn't have done it without you guys. Vicky, that's awesome. I'm glad you went live. And it was wonderful to meet you, I guess, face to face, sort of, through the cameras, and hear your insight and commentary. It was a lot of fun. A lot of fun on Friday. Thanks for all the time you spent. And to say hi to your mom. It was great to meet her as well. All right. I have to just say right now, I'm not sure if Lynn in South Carolina is here, but Lynn, just out of the blue, sent me a package in my post office box, and I ran and picked it up. And I'm like, what is this? I have no idea what it was. And I opened it up, and there's a little note that says from Lynn in South Carolina, and it was a bottle of Heinz ketchup. I'm like, why would she send me Heinz? And then I looked closer at the label, and it's Heinz pickle ketchup. Heinz pickle ketchup. I would show it to you now, but it's in the fridge and it's halfway gone. I can tell you there are many times that well-known brands try to add a flavor to it, and it just doesn't match up well. I am a believer of the Heinz pickle ketchup. It tastes like you're eating pickles with the consistency of ketchup, and you get the ketchup taste and the pickle. If you run out of pickles, on your burger and you use Heinz pickle ketchup, you miss the crunch, but the taste is there. It was fantastic. Selena, Team Minority, gifted 5 memberships as well. Thank you very much, Selena. Great to see you here as well. We're going to rewatch the questions from last Friday. The state's facial expressions are horrible. Deanne, we're going to get that. I think I've got that pulled up right now. Give me just a minute to check. Let's see. Actually, I need to go live. I thought I had it pulled it up. There it is. Let's see. Kelly Day, Trial 16. I think it was that it? Hang on. Day 17 p.m. That was it. We only have like 18 and 33 minutes of coverage. So I think we're going to watch all of Friday's live. But we'll get that as we're still on verdict watch. Court, let's see. Want to make sure I don't miss the Daybell live stream, and I think we're good over here. Denise, you want me to hit the live button right now? I'll go live now, but it just shows the YouTube webpage. Let's see. There we go. Go live. It should be up here probably in the next few minutes. As soon as that picture changes, we can go full screen, and we'll take the court feed for you, all those who are over on Top Mark. Anxiously awaiting the happenings of the Chad Daybell case. YouTube served RA up to me during his very early days, says Red Pen, and I started chatting here during the Aaron Dean trial. You waited just a few to jump in, but we're glad you did, Red Pen. Red Pen's actually appeared on the channel as well, on one of the podcasts. It was wonderful. With Adam Nusky, I believe. All right. Let's see. Question. I know we try to stay away from the child cases, but will we follow the father who shot his 3 sons? Is that... oh, man. Pauline, that's going to be a tough one. I haven't made a call on that. We do follow some child cases. Usually they have to have an element to the case that makes it unique and different than just, unfortunately, the common child cases. And so I'll have to think about that one. That was a tough one. It just breaks your heart. Kenny Peterson says, good morning. Thanks to you, mods in chat. Glad to be on this great channel. That seems really loud today for some reason. Not sure why. Kenny, congratulations on the 7 months. Daybell should be live now. He should be, but they're... Dorman is the 3 boys case. Thank you, Amber. Daybell is... The feed from the court is not live yet. That's what I'm seeing. 7. Judge Boyce has said it's supposed to be live at 10, but it's not yet. So... we'll bring that up as soon as it goes live and get that set up. But the channel over on Top Market is live, and it looks like we have some people over there chatting and just kicking that off. And it looks, Denise, are you going to be in the courtroom again? I know you posted some of your notes from court from the Chad Daybell case the other day. That was really cool to see that. Heidi says, hi, everybody. Member for 10 months. Thank you. Thank you very much, Heidi. Welcome. Austin Girl, so glad I stumbled on your channel. Thank you. We're glad you did too. It wouldn't be the same here without you. Wonderful. Maybe there will be another attorney trying to file a motion. I don't think after what Judge Boyce did to this one, any other attorneys are going to be jumping at the bit to do that. Yes, burner phone number is welcome to text me. I'm gonna bring up some video on, or not video, but some. I'm gonna bring up some postings if I can. Hang on. Oh, well, I need to resize them. And I have to say thank you to the docket on Twitter. The docket, if you don't follow the docket if you are on Twitter and you're a true crime fan, the docket is fantastic at just posting filings as they came out in all the important cases. And I grabbed these ones from the docket. Also, you can find them at As the Gavel Drops Discord page. which is a good friend of the channel. They do an amazing job, and if you ever need to do a deep dive in anything, As the Gavel Drops is the place to go for that. So wonderful. I just happened to grab these right as they were posted by the docket, so that's where I got them from. Let's see. Let's trim these up. Send that to my computer. Okay, still trying to edit this other one. Just one second. I can't edit and talk at the same time. All right. That's good. I don't want to start until we get Daybell sorted out, and the judge is a few minutes late there, so we'll stall for just another minute. Another surreal trial will be the Kinsley Weltley. Can't understand who could be so evil. Wow. I don't know that one. At least I can't remember. My goldfish memory is not functioning today. There was I think there were some updates in the case out of West Valley, Utah, or West Jordan, Utah. That guy who I think it's a SA case or a rape case, where he fled the country, went to Scotland, and they extradited him and dragged him back, and he showed up with a weird accent. I say weird because I don't think he does the accent properly. It's like a bad accent and a new name supposedly. And he's like, "Oh, it's not me. I'm somebody else." He filed a motion with the court that the jail had to refer to him as his chosen name instead of who he actually is. Melissa says, "How sad is it that you realize you call into a YouTube channel so often you save it to your speed dial?" Nothing wrong with that, Melissa. Uber self-defense scam shooting. So many good cases out there. Oh man, Pauline, that is a tough one. Even just hearing the details summarized like that is tough. Jamie, let me jump back and get that message. Just one second. There it is. Jamie says, "Whoa, 1 year with the best channel, mods, chat. Love it here so much." Jamie, thank you very much. A whole year. And an Orange Courthouse to show off for it. Thank you for your support, Jamie. Steal Your Heart, Susan B. came in at 15 months just after you. Defense Rest says, "Thank you so much for last Friday. You were truly amazing." I was stressed out like you wouldn't believe on that. I appreciate you guys being nice to me through that. That was crazy. Kenny Peterson, good morning. Thanks to you, mods and chat. Glad to be on this great channel. Thank you, Kenny. Thanks for 7 months of amazing support. And a yellow courthouse there. Heidi, member for 10 months, says, "Hi, everybody." Heidi, I love your little pooch looking out the window, looking at the weather. All right. I'm trying to see if there's anything else we had to talk about before we start talking about things. Let's see. I've got court feeds set up here. Let's see. We've got Friday. Just wait. What's going to come here? I need my feed from here over there. Okay, we're getting everything sorted. Just one second. This is going to be Santa Cruz on camera 3. There we go. And pause. Okay, we're not going to play that one just yet. Just keep it ready. All right. And that leaves this one open for court hopping, which we might do in the meantime. Do we know if they had a reread of the Emmy's testimony? I've not heard. I did not get to hear from Laura on Friday. I did not hear from Laura. She had some things coming up. And And so we haven't heard yet. I haven't checked the burner phone this morning at all, though, so I might have some messages. Has the screaming goat got a name in chat? It's just a screaming goat. It just does what it does. Let's see, Francesca, you texted me. Okay, I think I've moved everything I need. Sorry, I'm stalling. I'm watching the Daybell case. As soon as the feed stops there, I can sort of focus again. Under your scars, did we do a poll today? We haven't. The last poll was on the length of deliberations, and I think only like less than 10% of us thought it would take over the week until at least over the weekend. There might be trials out of Thurston County. We'll have to keep an eye on that, Josh. Has it started already, or is it old? Let's see. Francesca, we can talk off the air. That would be great. But wait till we get some video going that we can watch. Would that work? Let's see. I think that's all. Okay. Thanks for the lead on the Thurston courts. I really like Thurston, Washington. Something about that court just seems like home. Okay, we've got Chad up. Just 1 second. Make him full screen. We have volume. It's live. Okay, we're set to go over there. So now we can focus on other stuff. All right, so let's start with a couple of the. Let's see, where did I load those? Let's start with the documents I told you about just a moment ago. Bring this over on camera 3. Where's camera 3? So I realize a lot of people do this with one or two computers. I don't know how they do it. I honestly do not know how they do that. I love having 8 inputs that I can work with. I don't know what I would do with any less. Okay. All right, let's do this first. Let's read this. This is the state of New Hampshire, and we're going to bring this in on camera 3. I know it's a little bit small, but I think I can see it, and I'll read it to you. I might turn me off just so you can see. All right, here we go. It says this: order regarding defendant's appearance at sentencing pursuant to RSA 651 4-A. The state has filed a notice for defendant's appearance at sentencing, asserting the applicability of RSA 651-14-A to the instant case and are requesting that the defendant be transported to a sentencing hearing on May 9th, 2024. The defendant has filed a responsive pleading seeking to excuse his appearance. The state objects. This is the state via Adam Montgomery. Adam Montgomery literally skipped his murder trial. He skipped the trial. Just didn't show up, didn't want to be there. And apparently through loopholes in the law, which I think are going to be corrected, they're getting fixed. So the state says in part that before a judge sentences or suspends or reduces the sentences of any person, let me make this full screen so I can see it a little better. There we go. Before a judge sentences or suspends or reduces the sentence of any person for second-degree murder, the victim of the offense or the victim's next of kin, if the victim has died, shall have the opportunity to address the judge. The victim or victim's next of kin may appear personally or by counsel and may reasonably express his or her views concerning the offense. The person responsible and the need for restitution, so they can address the person responsible. The defendant shall personally appear in court when the victim or victim's next of kin addresses the judge, unless excused by the court. So the court has the authority to decide whether he's there or not. First, there can be no doubt as to the applicability of the law to the defendant in this case. On February 22nd, the defendant was found guilty by the jury among other crimes, second-degree murder. The state has informed the defendant and the court that members of the victim's family and others are expected to testify at the sentencing hearing. The defendant now moves to be excused from the hearing, arguing that only that he maintains his innocence on the charges of second-degree murder, tampering with the witness, and second-degree assault. So let's shut this down, get to the other one. And it says, in passing the law, the legislature has made clear that certain types of cases, the defendant should be required to personally appear in court when the victim or victim's next of kin addresses the court. Although the state allows the judge to exercise its discretion to excuse a defendant from this obligation, the court does not find the defendant has raised an adequate factual or legal basis to do so here. The only factual basis the defendant asserts is his contention that he is innocent as to some of the charges. However, the defendant has been found guilty beyond a reasonable doubt by a jury as to those charges, and he asserts no other factual basis for excusal. Additionally, the defendant asserts no legal basis for excusal other than that the statute provides the court with discretion. Were the court to accept the defendant's request, it would be tantamount to excusing the defendant's appearance simply because he did not wish to attend. The court finds that this would undermine the legislature's objective in passing the statute without a compelling basis to do so. Finally, as the state notes in its objection, while the defendant has a right to attend his sentencing hearing, this does not amount to that's a new word I've never seen before in my life. Concomitant right to absent himself from the proceeding. For the foregoing reasons, the defendant's request to be excused from attendance at his hearing is denied. His appearance is therefore required pursuant to the law. The office of Hillsborough County Sheriff shall take all necessary steps to ensure the defendant's timely appearance at his sentencing hearing scheduled on May 9th, 2024 at 1 p.m. So ordered, signed by Amy Messer, the judge. So as frustrating as it was for many people to see that he was skipping his court appearance, he was skipping his trial, he was basically got away without making a showing, never had to show his face. He has to be there for sentencing, and that's going to happen. So that was really cool. Yeah, new word just dropped. Petrified. It was a new word for me. Somebody explain it to me. So that's the judge in the Adam Montgomery case in the murder trial. It was so frustrating for so many people, victims, friends, family, that he just, would sit in court and was like, no, I don't want to go to court today. Yeah, I'm on trial for murder, but I'm not going to court. I'm not feeling it. And it was basically just like him every day, just giving the finger to the court. It was very disrespectful. I think it was wrong. So anyway, the legislature has fixed that by the pass of the law, saying basically the judge can compel him to go to court, and the judge did. Next up, Renee, thank you. Gifted 5 memberships this morning. Paris Chick 97, Cam, Susie Hat 44, Michelle Allender, and Maya, or Mia, all gifted memberships today. Thanks to Renee. Thank you, Renee. Very generous of you. Pronounced concomitant, says Red Pen. Concomitant. Or concomitant. I think that's the root word is commit, right? Concomitant. Accompanying. Why don't they just say accompanying? It's like every profession has their own vernacular, right? Their own special words they use. Like, for instance, when you call a plumber and have him give a quote on repairing something in your house, he has special words. He's like words like 1,000 or 10,000. Those are the words that the plumber uses usually when talking about how much the bill's going to be. But anyway, all right. There we are with that. As you can see, we're okay on Daybell. It's ready to go. Court's going to resume probably in about, 8 to 10 minutes. Plumber words. Yes. Those of you who have called a plumber, you know what I'm talking about. Did you see your message from Red via Super Chat? I'm about to. Buffer, LOL, is the Maya counter gone for good? I don't know if it's gone for good. I could run it, or I could even send somebody the software to run it themselves. My son wrote the program that does it, and it just automatically does the math, and it just it opens a web page on your own computer that has the picture and everything in it. It's pretty cool. The problem is I'm using that feed to do something right now, or I'm using that computer to do something right now, and it would cause some issues. I could bring it back very quickly if needed. So if there was if for instance, the Andersons or Whitney give us a call and said, hey, can we have the My counter again in a heartbeat? I'd do it. Renee, thank you for the gifted in 5 memberships. Adam, Intervenuski. Adam, you make it hard on me. Your ad here. Apparently he's selling his membership chat space, which I'll give you props for the entrepreneurship, Adam. That is really cool. Everyone knows that next month is 15 months, and apparently it's for sale. Just contact Adam and find out what the pricing is. Pretty cool. Let's see. Josh says, if anything does happen today, it will be live in about 2 hours from now because of the time difference. I'll keep an eye on it. That's talking about the Thurston, Washington, which we always love to jump in on. And you said it was courtroom 4. We'll keep an eye on that as well. Now, I think now is a good time to jump in and watch the happenings as they occurred in court in Arizona on Friday, as deliberations went the entirety of the day. And so we just have little bits of video that show the times when people were in court and the judge had questions or had interactions with the jury or possibly just the counsel. So we're going to go back and watch that. It's less than an hour altogether, and it'll be even much shorter than that once we skip the parts where they basically just were at break. So let's do that now, and then we will start. I think we have to start the deliberation counter. See, what time do they start deliberating? 8:30? Is that in 6 minutes? Hey Siri, what time is it in Arizona?
In Phoenix, Arizona, it's 7:25.
So 11:30. Okay. It's 7:25. They're going to start at 8:30 this morning, so in about an hour. And of course, in my infinite wisdom, I once again left the counter running after they were done deliberating. So I'm 26 minutes ahead. We've got almost exactly 9 hours of deliberation, and I have 9 hours and 26 on the clock, as you can see right here. So 26 minutes after they start deliberating, which by my count would be 8:54 or 8:56. Sorry, hard math. We're going to start the clock. Because I have no way, because nobody makes a stopwatch. You can enter the time in that you want to start at. I tell you, I would pay for that app if somebody could do that.
Have them send someone with more.
Right. Yes. Not sure what state you're in, but Michigan, 66-year-old lady drinking at local bar drove 7 minutes to Swan Club. She lived near, drove through building, 5 and 8 years old. Siblings died, 15 injured. The mom was injured for those siblings as well. It's terrible. And there's a video of her just driving right into the building where they were having I think it was a birthday party, and just plowed through a crowd of kids celebrating. Just heartbreaking. Just the decision to drink and drive is such a bad one. But you didn't stop it. I saw you. Easy. You're saying I was confident that it was. It was 9 hours almost on the dot because they stopped at 4:30. Maybe I'm right. I was kicking myself all weekend long thinking I hadn't stopped it. I had gone an extra half hour. Okay, we'll just start it when they start deliberating then in Arizona and say they've gone 9.5 hours roughly. All right, I'm going to get Thurston, Washington. Well, not yet. I'm not going to get them pulled up yet. Let's see if we have. Let's jump over to. Hey, Mrs. R.A., how are you doing? You're live.
Good. How are you?
Do you want to not be live? Okay, how about that? And switch. No, just kidding. Just kidding. Looking good this morning. Guys, the view is fantastic here. She's she's amazing. I love you. What books are you grabbing?
Poetry books.
Do you guys want some poetry? This is poetry?
Well, there's some poetry in there.
Where's... There's no pictures in these books. The Young Folks Shelf of Books. Junior Classics 10.
Oh my gosh, do you have nothing to talk about?
We're on Verdict Watch. Fun and nonsense. This sounds like the podcast. John Gilpin was a citizen of credit and renown. A train band captain eke was he, of famous London town. John Gilpin's spouse said to her dear, though wedded we have been, these twice 10 tedious years, yet we no holiday have seen. Oh, this sounds really familiar. This hits a little close to home, guys. Tomorrow is our wedding day, and we will then repair and tell the bell at Edmonton, all in a chase and pair. My sister and my sister's child, myself and children 3, will fill the chase, so you must ride on horseback after we. He soon replied, I do admire of womankind but one, and you are she, my dearest dear. Therefore it shall be done. I am a lindrapper bold, and as all the world doth know, and my good friend the calendar will lend his horse to go. Quoth Mistress Gilpin, that's well said, and for the wine is dear, we'll be furnished with our own, which is both bright and clear. John Gilpin kissed his loving wife. Overjoyed was he to find that though unpleasant she was bent, she had a frugal mind. The morning came, the chaise was brought, but yet was not allowed to drive up to the door, lest all should say that she was proud. So 3 doors off the chaise was stayed, where they did all get in, 6 precious souls, and all agog to dash through thick and thin. Smack swept the whip. Wow, went the whip. Round went the wheels. Were never folks so glad. The stones did rattle underneath, as if Cheapside were mad. John Gilpin, in his horse's aside, seized fast the flowing mane, and up he got in haste to ride, but soon came down again. For saddle tree scarce reached had he his journey to begin. Then turning round his head, he saw 3 customers come in. So down he came for loss of time, although it grieved him sore, yet loss of pence, full well he knew, would trouble him much more. He wanted the money more than to follow his wife to his wedding. Oh, this goes on for pages. I can't do this. I'm sorry. It didn't say great poetry. It's just said poetry. It is there's one you'll never hear anywhere else. All right. Taylor Swift poetry. Hey, we can't all be tortured poets, can we? All right. All right. Let's go ahead and bring in some court now that all the viewers are gone. Wow, that was a dip. Big dip there. I'm sure it was just a hiccup on the internet, nothing related to what we were streaming. All right. Have you ever thought of doing book reads? Yes, I'll probably get sued for copyright infringement, but I thought about it. Roses are red, violets are blue, and Recovery Addict answers your questions too. Kenny, I do. Thank you for the poetry. The poetry I wrote in high school was never very good. And it was always basically plagiarized from somewhere else. You know, like there are tulips in the garden, there are tulips in the park, but the tulips I like most are your tulips in the dark. My English teacher didn't think that was quality writing for some reason. I thought it was good, but I tortured you. Okay. All right. Let's see. We're going to start court. Why are you guys stalling? Why are you stalling? This is where we're going to be now. So let's get this set up. We're going to pick up with what happened. We've got about half an hour. Well, a total of an hour of video, but some of that's going to be cut out. So just 1 second here. Play on 3. There we go. It's poetry day for our kids. So. This thing on, says the judge. Is this thing on?
Good. Back on the record in State versus George Allen Kelly, CR 2023-026. The jury, for the record, the jury began deliberations this morning at 8:30.
This is Friday.
At 8:30, the court received the following note from the jurors. 2 questions, or 2 things. 1, we need clarification of site visit. Was it demonstrative or an exhibit entered. Second thing is not a question, it's a request. Can we get multiple copies of the jury instructions, one for each juror? All right, let's deal with that one first. What's the state's position?
I don't have any objection to that, Judge.
To the instructions?
Sure.
We don't have an objection.
All right, good. So let's make sure we'll copy off, 7 or 8 others. Just make sure they're all working off the same final instruction. All right. What about the site visit?
It's substantive, Your Honor.
Substantive?
Yeah, I mean, they're allowed to consider what they viewed out there as substantive evidence.
What was their question?
The question was, we need clarification of the site visit. Was it demonstrative or an exhibit entered? Admitted.
I don't know what.
I don't know why it makes a difference.
I think they're trying to determine if what they saw out there was substantive evidence or if it's just a demonstrative, and I think it was substantive.
I don't know what do you have a position? It's the equivalent, well, the parties stipulated that locations 1 through 15, was it, were the locations that were specified, on the map, on the key to the map, or on the key to the list that they got, right? I mean, so that was, I think an answer would be to that effect. The locations that were marked 1 through 15 were agreed to by the parties as being the locations identified in the key to the map, and you can consider that as substantive evidence of those locations.
Well, don't forget, Judge, don't forget that they added another point, and that was that tree. So I don't know if you want to be that specific and just call it, the whole thing is whatever you want to call it, but I think they can consider that location, in our opinion.
I forgot about the tree, but 15 was the last thing that was the other pump house that we drove them out to, and then 16 was the not marked, but it was the end of the border wall, and the tree, the parties went out there and agreed on the tree. So right.
Yeah, I think anything they saw there was substantive evidence. That was the purpose of the visit, was for them to judge distances and what they could see, all that stuff.
I mean, I agree. I just want to hear what's your position.
Yeah, I don't think we need to, personally, I don't think we need to say 1 through 16, whatever, just the site. I mean, it's just, they may consider that.
Okay.
Just leave it vague.
That does raise an issue, though. We had asked that the photos that were taken by court administration be made a part of the record, just for the appellate record, in case anyone ever raises an issue about what happened.
All right, well, that's a separate issue. Let me deal with this.
Sure.
All right. All right. Well, you already have all those copies, right? So okay. We don't have to copy them off. We still have them, I think. All right, so answer 1, you may treat / consider the site visit as an exhibit. It is not demonstrative evidence. Number 2, yes, extra copies of the jury instructions will be provided. Any objection?
No objection.
All right, you can give this to them, and when you bring it back after they've seen it, give it to the clerk, and it'll be made filing, and it's 8:45.
And then can we talk about that issue with respect to putting the photographs in for the appellate record?
Yeah, we will. Not right now. I got something else I have to do.
Okay.
All right. We're in recess.
Please rise.
let me skip ahead.
All right, we're back on the record. Record show the presence of defense counsel and the defendant. The jury is not present. We have another request from the jurors. Who do we have on the line from the state?
Your Honor, Kim Hunley and Mike Jetty from the state.
All right, good morning. So I marked this question came in at 10:05 a.m. Actually, it's not a question. It's a request. We need clarification on evidence admitted for a limited purpose and other acts, parentheses pages 19 to 20, of final instructions where we are missing context.
Your Honor, I would suggest that what the state offered in terms of the limited evidence be read to the jury or be provided to them on the limited evidence issue. And we can talk about, and I wouldn't have an objection to sending them a message with respect to the text messages on the other act evidence.
Judge, I think that unduly overemphasizes that kind of evidence. We would suggest instead maybe something where you just told them at various points during the trial, I provided certain limiting instructions regarding certain pieces of evidence, and your notes and recollections can refresh that. But for example, I talked a lot about hearsay and things were offered for limited purposes. So what you recall about the trial is what that is about.
Right. I mean, but the problem with that is that's what I actually did in the closing instructions, and obviously it's not enough. What I would, and the reason I did that, and the reason it continues to be a difficult challenge to comply with this is that, you know, there are a number of different things that were admitted for limited purposes for different reasons, different types of evidence for different reasons. But I think we should try to respond to the request for information. So what I would suggest is that I write them back a note saying we intend to respond. The information is somewhat detailed and involved. We're working on a response. It'll take some time because it needs some work. And we'll get it to you as soon as we can complete it. Now, I would have the parties see what you can agree to as far as what the evidence was that was subject to the limiting instructions and what the limiting instruction was at the time.
May I get clarity? Is the note asking for which ones, or can we ask which ones are there in question about whether it has a limiting instruction?
I thought, yeah, it does not. It's just as read. Okay, we need clarification on evidence for a limited purpose and other acts. See pages 19, 20 of final instructions. We are missing context. That's all it's saying.
I mean, can we ask if there's a specific question or evidence or a statement made that they're in question on whether it is or not, versus giving them the whole trial of it?
I'd object to that, Your Honor. They've asked generally, and I think we should answer their question.
Well, I think we can do both. I think we can do both. So what I intend to write is just what I said. We intend to respond to your request. We are working on it. It will take some time because of the number of different things that were admitted in trial or for which a limiting instruction was given. However, if you have some specific evidence and you're concerned about what the limiting instruction was or whether it applies to that evidence, please let us know, and we will address that specifically. So let's try and do both, you know. And we can get a response back. If they say it was concerning this particular item of XXX or whatever, then that helps us. But in the meantime, I'd like the parties to work on this, you know, and that would expedite the process and expedite any decisions that the court has to make about how to respond.
Well, Judge, I've already emailed to the parties and to the court what my proposal was with respect to the limiting instructions on Detectives Barba and Detective Rodriguez with respect to Miguel, Ramon, and Daniel. And so I've already sent that language. If counsel wants to take a look at it and see if they want to make some edits to it, we'd certainly be happy to talk to them about that and see if we can come to a stipulation to come back to the court.
That's what I'm asking everybody to do.
My concern is if we're going to give them some, it has to be all. And I'm not sure that's what they're asking for again. But, you know, I think that's a lot of work because the court reporter, I guess, would be the only source of every single instruction. And so I'm just saying is I don't want to do just what the state wants that on. I want all of it because we don't know what they're asking.
All right. Let me craft an answer here. Thanks.
What you see the judge doing here is the way it should be. He brings out the question. He says the jury has this question. He reads the question. The sides can read, they can look at the note if they want to see, if the judge understood it or read it correctly. And he gets input from both sides, and then he makes a decision. That's the way it should work. We're going to see later on a point where I believe the judge gets a note from the jury and makes his own decision about how to respond. And that, for me, was problematic. I've heard that a lot of people who went back and watched this said it's not what we thought it was. It's not that big of a deal. He says he didn't see the numbers before he made the decision. But the fact that he made a decision against one side, against an objection from the state and an impartial defense, was a little weird. So let's see what he comes up with as he's writing feverishly with his pencil or crayon or whatever he uses. So the questions were, the first question was a clarification of site visit. Was it demonstrative or exhibit entered? And the second question, they requested jury instructions for one for each. They wanted one copy for each juror. And they have a question about limited evidence and what the purpose is for limited evidence. This is a replay because this view, we watched this before, but we watched on the pool camera feed. The pool camera microphone picks things up differently. So we miss some of the commentary from counsel, and we also miss some of the commentary from the judge on that pool feed. So we're rewatching. Plus, the afternoon had some interesting moments where the state, at the end of the day, said, "Judge, we've requested a copy of the JAVS recordings, which is the official court copy of the audio video from court," and the clerk says no. And they brought the rule and said, look, the law says if either party requests it, they get it. And so they're filing a written motion, which might be addressed this morning when court starts. But they're filing a written motion to say, we want a copy of these recordings. I don't know why they want that unless they think that there's something on that recording that they need proof of. And it might be something that defense says. It might be something that Ms. Lorthup might have said and was picked up on the microphone. So yeah, the pool microphone, the pool camera has its own what's called a shotgun microphone. And so they'll use microphones that basically hear what you're pointed at. And that's usually, it's pretty good because you're usually watching what you're listening to. But sometimes that microphone doesn't pick up the side conversations that occur off cameras and interruptions. These mics that the court is using have microphones at each location. So they have one at the witness table, they have one on the court, on the judge's desk, and on both counsel tables. So that's where we go. That's why we're rewatching, because I think it's interesting. It might be very telling. Judge is still crafting a response, and he's going to read it once he's done. Let's see. Jury selection still going on in the Karen Reed trial.
Here's what I wrote. The court understands your request and is preparing a response. Two different forms of response, however, are available. First, we can prepare a response that tries to list all individual items of evidence admitted for a limited purpose. We can do this. It will, however, take some time. Second, if there is a particular item or items of evidence that was admitted for a limited purpose and the jury has a question about those particular items, the court will prepare a response as to why that item or items were admitted for a limited purpose. Either response is acceptable and doable. Please let us know how you would like us to proceed. How's that? Ms. Hunley?
Your Honor,
In the meantime, I still want the parties to start working on the more comprehensive response, and let me know what you come up with. So if they decide they want the comprehensive response, then we can try to make that happen.
And Your Honor, we're going to head over as soon as we get off the phone and start working on that with counsel. But I would still like to provide a comprehensive response to the jury as to those two issues, one way or the other. We requested it before. I don't want to waive any objections or any issues with respect to that, and so I think they're entitled to know those two things. But aside from that, no objection to your response.
All right, very well. So I'll give this the bailiff to take back in there, and come on over, get working on that with defense counsel. I assume we'll get an answer back from the jury pretty quickly. And once I get that answer, I'll come back into court and let you know what they say.
Sounds good. Thank you, Judge.
All right. We'll stand in recess. Thanks.
Defense just hung up on the call. It was nice of them. We're catching up quickly. I think we're done with the morning. Oh, there's a little more.
All right. We're back on the record briefly. The jury just told the bailiff they're holding on to the note. They're going to decide how to respond. So that's what they're doing. So in the meantime, keep doing what you need to do. But I just wanted to tell you that's what their response was. So they haven't returned the note. They're working on it, and they're going to decide how to respond. All right?
Is that like the medical examiner? They're still thinking about it.
Do they need the skeleton?
I would like to make a record on it again at some point, so just so the court knows.
Thank you. All right, we're in recess. Thanks.
The judge is like, you want a record? I'm out of here. I'm going to leave here really quickly. Let's see. Let's bring in the next video because that was the morning. Now we're going to go back and watch the afternoon. Let's see. PM yesterday. This one's short as well. There we go. Who's washing dishes? Once again, the state is not present.
Just hold, no, don't open it. Just hold on to it.
Just hold, don't open it. Okay, this is important. I'm sorry. I'm just waiting for the little orange
ready?
up here.
All right, we're back on the record in State versus Kelly. The records show the presence of all counsel and the defendant. About 10 minutes ago, we got another note from the jurors. For the record, I previously instructed my judicial assistant, Jose, who's also the bailiff, that if the jury ever submitted a note that had any kind of tally or numerical representation about what their votes were, he was to close the note and not show me the note. And the reason I did that is I've had this happen in a number of trials before. The jury instructions, the final jury instructions that I gave clearly state to the jurors, and I think I emphasized to them again, if you have a vote and you have a note, you're not to inform the court about where you are on the vote numerically. Well, apparently they've done that. Now, I haven't seen it. I intentionally didn't look at it. I had them staple it and gave it to the clerk. If you would just write on there, Valeria, one that came in about 1:45 today on April 19th. But I haven't seen it, so I don't know what it says, and I don't think it's appropriate under the law for me to look at it.
He's right.
And that's all apparently it's in the note. It just has, from my understanding, it has the counts of the charge and just some kind of tally of where they are. And then they told the bailiff orally, well, what do we do now? And I sent the bailiff back to give them instructions. Any questions for the court have to be put in writing. So that's where we are. But in the note doesn't ask the court to do anything at this particular point in time.
Your Honor, I still don't think we've answered their questions from earlier.
I did answer their questions, but they haven't sent the answer back. So a question on the limiting instruction, I read it, and it says we can do this either way or both ways. We can answer your question. We can provide you with that information, and tell us what you want us to do. And we haven't heard them back. So if they had answered back, then we would have gone forward. But right now, putting that aside, let me hear from the parties. I mean, I haven't been asked to do anything, and so unless and until I'm ever asked by them to do anything, my intention is not to respond.
Well, it's the state's position that we need to give a full response to their request on the limiting instructions. So the state is still requesting that, specifically with request to Detective Rodriguez.
All right, I know what your request is. I'm not going to do it. I already responded to that request. I responded to the request that they gave me. I told them what we can do. I said the court can respond. We can give you all this information. If you have some specific area of concern that you want, we'll answer that. If you want it all answered, if you want us to tell you about all the limiting instructions we gave, we'll give you that detail as well. Put it back in that court. Haven't heard back from them. From that, I assume it's not that important at this point in time. Anything else record you want to make about the note that was just sent out? Other than what you've already stated.
It sounds like you've already responded, Judge? Or
No, there's nothing to respond to. They just sent a note out with a tally about where they were on the various counts, and I haven't responded in any way except the bailiff told me they orally told him, well, what do we do now? And he did not respond appropriately, and he informed me of that, and I sent the bailiff back and said, if you have any questions of the court whatsoever, everything has to be done in writing, and that's where it sits.
They asked the bailiff?
What's the defense position?
I think we can leave it there unless and until they send us something that is in writing. If they say we're stuck or something like that, then we can give an impasse instruction. But I think we need to wait for something from them.
That's what I think as well. But start looking at that. I think generically they're called Willits instructions. There's a Arizona revised.
It's not called Willits, Your Honor.
I mean, that's
Allen.
That's what we kind of colloquially had referred to them. But there is an Arizona revised jury instruction that is recommended for the court to give, if appropriate, under the circumstances when the jury has indicated they're at an impasse.
I was just wondering, Judge, if you wanted to send a note to remind them to not tally
the
up
state's face
on future notes. And I don't know. Whether it's necessary or not, I'm not sure. I mean, we hate to come back with
it. Can't hurt. I mean,
because you don't want another one saying we're hung, we can't figure out what do we do. Here's our tally, and then it makes it where you can't read it.
Can't even read the note. Right.
Yeah.
That's true.
Willits instruction has to do with.
I think that's a good idea.
When the state allows material evidence to be destroyed. The judge was wrong. I think he means an Allen charge.
Right. And I know you believe that I've made my record, but I indicated earlier I needed to make a further record, and I would like to make that further record.
Right.
Which
you
is
can
that
do that,
state...
but I'm trying to deal with an immediate issue right now, so let me deal with this.
Wow. I don't know why he says Willits instruction. I don't think anything in the case applies to the Willits instruction. Arizona does have the Allen charge, or dynamite charge. When jurors cannot agree on a verdict and they report this to the judge may issue a further instruction to them to encourage those in the minority to reconsider their position. These charges are known as an Allen charge, or more casually, as a dynamite charge.
All right, so, and I put April 19th, 2:05 p.m. Jurors, you are reminded not to inform the court, bailiff, or anyone else what your numerical vote counts are on the charges. All right, I'll give this to, any objection from the state?
No objection, Judge. And just for the record.
We'll have the bailiff take that.
And just for the record, Your Honor, I think you meant an Allen instruction.
Yes.
Willits is if there's lost or destroyed evidence.
Yes.
Oh, that's right. You're
Is that
right.
what you
Yeah.
meant?
Yeah. I'm sorry, I forgot that. Thank you for correcting me.
Okay.
Do you have that? Does everybody have that proposed, Raji? We're not there yet. I just take a look at it.
Standard 53, is that what we're talking about? The impasse instruction?
You're right. I think so.
I have it in front of me.
Okay, take a look at that. We're not there yet, but the way things look, we may be soon. For the record, the jury began deliberations at 8:30 this morning. Well, let's go back. Yesterday, they began deliberations at 2:40. It took us a little while to get some of the exhibits back in there. They recessed at 4:30, so that was an hour and 15 minutes. They began deliberations at 8:30 this morning. We got the note at about 1:45, 1:50. They did have lunch brought in. I don't know if they worked through lunch or not.
They did.
But they began at 8:30 this morning and sent the note out at about 1:45, 1:50, and stayed in for lunch. Ms. Hundley, you can make an offer of proof and a record. Why don't you just print something up? I've got other things I need to do. If you would write something and print something up, and then you can file it and make it part of the record.
Well, Your Honor, it's just the document I already prepared and already submitted to the court that I just believe the state is prejudiced without the jury receiving that information. Mm-hmm. And I don't believe they know how to ask for it because they don't know what it is that they need the information on. So I think pitching it back to them is not appropriate. I think that we should offer them the information that they asked for.
Okay, understood.
That's all.
Any change in the position from the defense on that?
No.
All right, stand by. We'll be in recess.
Wow, they're getting testy. Judge is like, I'm busy. I don't want to hear your motion. I don't want to hear your little whatever it is you have to say. Let's see. Let's keep it going here. Skip ahead.
Not unexpectedly, the record will show the presence of counsel, the defendant and defense counsel. Not unexpectedly, we just got another note. I marked it 2:10 p.m. The note reads as follows. We, as a jury, are at an impasse as to a unanimous verdict. We're looking for guidance as to how best to proceed. I'll give a note to the clerk. What's the defense position?
I don't know that we need to give the impasse instruction just yet. I think maybe just another note saying.
I can't hear it. I don't think.
I don't think we need to give the impasse instruction just yet. Maybe another note saying, do your best, see if you can make any progress.
I think when the jury indicates they're at an impasse, we have to give the impasse instruction.
So the impasse instruction, just make sure we all have the same thing. We're looking at the same thing as standard criminal 53, and it reads as follows. This is offered to help you, not to force you to reach a verdict. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a just verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your views and change your opinion if you become convinced that it is wrong. However, you should not change your belief concerning the weight or effect of the evidence solely because of the opinions of your fellow jurors or for the mere purpose of returning a verdict. You may wish to identify areas of agreement and disagreement and then discuss the law and the evidence as they relate to the areas of disagreement. If you still disagree, you may wish to tell the attorneys and me which issues, questions, law, or facts you would like us to assist you with. If you decide to follow these steps, please write down the issues where further assistance might help you bring about a verdict and give the note to the bailiff. The attorneys and I will then discuss your note and try to help you. I do not wish or intend to force a verdict. We are merely trying to be responsive to your apparent need for help. If it is possible that you could reach a verdict as a result of this procedure, you should consider doing so. Please take a few minutes and discuss this instruction among yourselves. Then advise me in writing of whether we can attempt to assist you in the manner indicated above, or whether you do not believe that such assistance and additional deliberation would assist you in reaching a verdict. If we're going to give them an instruction, I think we ought to give them this one because it's crafted to be neutral, offering help, clearly states we're not intending to try to force a verdict, coerce a verdict, or influence a verdict. It's just tell us whether you need help. Can we help you? Is additional time needed, or are you clearly at an impasse?
In my experience with my background, I have found that sending them back to do their due diligence, some note to say, keep trying before they just throw the towel in easily, and then follow up with this has helped a lot where we did get verdicts. It's just my experience.
The state opposes that, Your Honor. We'd ask for the impasse instruction. It's specifically designed for this situation, and as the court indicated, is neutral.
Let me get a formal statement from the defense. You, co-counsel, you can talk together, talk to your client if you need to. It's an important decision. And if you want to involve him, do so. I can step off even, but really the question is whether or not I give this impasse instruction. If I give further instruction, I think it's appropriate to give the impasse instruction because it's crafted to comply with the case law and to be neutral and to be non-coercive.
The instruction is not a concern. We know that's crafted for that purpose, and so that's not our objection. We would just like them to continue trying for a while before they get back and give us more information that they absolutely can't. The same issues may be the same issues in another trial down the road. So I think what I have found by just asking them to get back to work and continue to try, and then maybe they'll diligently try a little harder and then follow up with this impasse note if we get another one down the road.
All right, I understand your position, but if I am going to give a reply, a response, then I'm going to give this instruction. But I won't give it. Well, I'll consider not giving it if the defense objects. I mean,
we'll take a minute.
Okay, I'll come back in a couple minutes. We'll be in recess for 5-10 minutes.
So did the judge say, "Of course you do"? Who said, "Of course you do"? I didn't listen. I didn't hear it. I mean, it was there, but I just went through it. What's interesting here is the judge says, "Oops, we're back." There's another note from Boy Bailiff. Or the bailiff.
Would you go see if the defense people? Go get the defense. Thank you.
Go get the defense. Robe on. He's dressed for work. He only dresses for the jury. Have you noticed that? He snaps the sleeves back on. I think it's funny the state is pushing the Allen charge, but defense is wanting to give them more time. What's interesting is the judge has said that I want to give them this message. So the state and the judge are on the same page. There's defense and defendant.
We're back on the record. Records for the presence of counsel and the defendant. I've been thinking some more, and I am going to. I'm going to do what defense counsel suggested. This jury, as I said, went out at 2:40 yesterday. It took us a while to get the evidence in there, and they did deliberate a little bit yesterday, and they deliberated today from 8:30 to a little bit before 2 with a lunch break. Not sure whether they worked before lunch. It's a 4-week trial, a lot of complex information, a lot of proof, a lot of evidence presented, and there's a lot of issues. I mean, there's no question. There's a lot of facts to be looked at in this case. I just don't think they've worked long enough or hard enough at it. So I'm going to bring them in, and I'm going to tell them, number one, I don't know what their vote count is, and again, they're not to tell me. But it's a 4-week trial. A lot of work and effort's been put into it. I'm not trying to coerce a verdict or influence them in any way, but I think they just need to keep working. Another possibility would be, we are here on a Friday afternoon. I'm always concerned when a case goes to a jury on a Friday and a Friday afternoon, that influences their process. Another option I can offer them is, look, if you want to break today and come back Monday and start again Monday, that's another thing we can offer you. Sometimes that's an effective thing to do, which is just to take a break and come back and start afresh on another day.
For the record, the state opposes that, Your Honor. We're asking for the impasse instruction. I believe it's specifically designed for this situation. The jury specifically said they're at an impasse, and that covers all of the issues.
Yeah. All right.
We're in agreement with your suggestion, Your Honor.
Okay. Then let's bring in the jurors.
Laura V says, hi, RA. I'm a Florida attorney thinking about this trial over the weekend and some of my past trials. I think the judge is frustrated that this got to trial and a plea wasn't negotiated by both sides. Thank you, Laura. Appreciate your expert analysis. And thanks for your support as well. So the judge flipped when he was out. He changed positions, now is siding squarely with the defense. He's going to give something similar to the Allen charge, but not the actual Allen charge. The actual Allen charge, if he does give it, which we anticipate may happen this morning if the jury is still deadlocked, will most likely be read verbatim as he read it off the law, because it is crafted very carefully for that reason. It's very good. It's established as a fair and appropriate charge to be read. Instead, he's going to do something which he has the ability to do, but not. But he's sort of on his own as far as verbally building that what he's going to tell them right now, and it's going to be just sort of his words saying, "Hey, try harder." And I think he does a poor job in doing this. The jury has deliberated for 9 hours. That's not a lot as far as juries go. We've seen juries go several days, and some have gone much longer than that. But they've been here for 4 weeks. This was on Friday. We're watching this in the 4-box version. We watched it using the pool media feed previously, but the 4-box gives us different audio and lets us watch reactions from each side as it happens. So we're just catching up. It's just a few more minutes of this, and then we'll be caught up with this morning. Did the judge say, "Of course you do"? I object, "Of course you do." That might be, is that what they want on a copy of? Like, we'd like a copy of the JAVs because you made a comment that was inappropriate, showing bias.
Please rise.
Casey Smith, we are live, but we're just rewatching what happened Friday afternoon as we're getting set for the jury to show up. They'll be there probably in the next 20 minutes and begin deliberating. No, the defense attorney said, "Of course you do." That's not as bad to me,
All right.
Court.
Yeah, sit anywhere you want, ladies and gentlemen. Please have a seat, everyone. All right, the records show the presence of all of the 8 active deliberating jurors, counsel, and the defendant. Good afternoon, ladies and gentlemen. I've been reading your notes, discussing your notes, and content your notes with the lawyers. It's 2:35 today on a Friday. This case went to you for your deliberations, ladies and gentlemen, about 2:40 yesterday afternoon on Thursday. We took a while to get the evidence together, put it all together so you could have it all available to you in the jury room. Then my understanding is you began your deliberations again this morning at 8:30. You had lunch. I don't know, did you work through lunch or did you just take a lunch break? Work through lunch. All right, that's good to know as well. And then your latest note came in at 1:50 p.m. about the situation. Again, just to remind you, I know I've written it back in the note, do not advise me numerically of where you are voting, okay? I had it stapled up and filed with the clerk, so I don't know where you are. Please don't do that again. That has an effect that I wish to avoid. Now, I have to tell you, it's my opinion that you haven't worked at this long enough. This was a 4-week trial. A lot of evidence was presented, a lot of information, some of it very complex from a variety of different witnesses. I mean, I don't know how many witnesses we had testify, but quite a few, and they all gave important information. So very complex information. I understand the issues are complex, but to come back on a Friday at about 1:50, I don't think you've worked at this long enough. I am not trying to force or coerce a verdict, all right? That is not my intention, and that's not my job, and that is not what I'm doing. But I do have a responsibility, after a tremendous amount of work has been put in to getting this trial to this place, where we are, by the lawyers, by the court, all the resources that have gone into it, and all the evidence that's been presented, to make sure that you do your job, follow your oaths, and to work as hard and long as you possibly can to reach a verdict. Again, I'm not trying to force or coerce a verdict, and if there's things that you need and we can help you with, other information or evidence, that's what we're here to do. But in my opinion, which is the one that matters at this point, you have not worked at this long enough. So I'm going to send you back in a moment to continue the deliberations. Now, also, it's a Friday afternoon, and from my experience, from a lot of trials I've done, sometimes, this is something else for you to consider, sometimes it's good to take a break. I know everyone's prepared and eager to resolve this matter in this case, but another option would, you can be recessed for the day and come back Monday. Sometimes it's good to take a break, step away from it, and come back as a group, again, 8 persons on Monday after a weekend, and start the deliberations again. So that's another option for you. So what we're going to do is I'm going to send you back in the jury room. I want you to keep deliberating, discuss it, keep an open mind, reevaluate your positions if you feel that's appropriate, and continue to work on this case. All right? And if you decide you want to break for today and come back on Monday, as I've suggested, pass a note to the bailiff, and then we'll just excuse you for the day and tell you to come back Monday at 8:30. But I want you to keep working. All right? You're excused to continue deliberations. Thank you.
Please rise if you prefer.
So he slaps them. He slaps the foreman and says, "Quit giving me the numbers. I don't want to know where you guys stand. I don't know what it was. I didn't look at it." The way he told the jury, it wasn't clear, and we heard this from the pool camera only, and it wasn't very clear. Earlier in his discussions with the lawyers, it was much more clear that he had not.
The records show the absence of the jurors. I kind of doubt they'll take me up on it, but if they do take me up on it and decide they want to come back Monday, we'll let you know right away.
I wonder if he saw some body language in their response.
Stand by, and we're in recess. Thanks.
Please rise.
I wonder if the judge saw some body language among the jurors as he said, "You haven't worked hard enough. You need to try harder."
Be seated.
Here we go. It's back.
We got another note from the jurors. I had it shown to counsel just because this juror writes so small. I just want to make sure you have the same reading of it that I do. The way I read this, were the SO reports entered into evidence? If so, can they be shared with the jury?
SO is sheriff's
Is that the way
office.
you folks read it? All right. Let me hear from the state first.
Your Honor, I think we have to answer, they have all the evidence that's been admitted.
That's fair enough, Your Honor.
All right.
I think we can tell them that they can have additional testimony if they request it as well. There's an additional instruction that indicates that and a rule that allows it as well.
And
if that would help them.
Our position would be to not suggest that.
So they want sheriff's office reports. There were several sheriff's officers that were at the scene involved, and they're asking for those reports. Judge is crafting, mouthing the words as he writes. So
we didn't have any reports that were admitted, right, from the sheriff's department?
That's correct.
Not police reports, Your Honor.
Right.
Obviously, that's because we can't admit them because they're hearsay.
All right, so my response is, by rule, the admission of evidence stops at the close of the trial. No other evidence can be admitted. The SO reports were not admitted during trial, hence they are not in evidence and therefore cannot be shared with the jury. Any objection?
Yes, the state objects, Your Honor. It sounds like we could admit them, which we cannot. They're hearsay. And I think that improperly emphasizes that they weren't admitted and seems to point the blame at the state for not admitting evidence, which we're not allowed to admit.
I don't have a position, Judge. I think how you crafted it is fine, but I understand the state's objection.
All right. This is the instruction, or the answer I'm going to give to the jury.
Wow.
And it's 3:15. We're in recess.
Please rise, people board.
She is upset. Off comes the badge. The court lanyard. Let's see. I think we have one more. Here we go. They're just coming back right now. The state was right. And it does sort of put them at a... It makes it look like they made a mistake. Lately, the judge.
All right, we're back on the record. In State versus Kelly, the records show the presence of all counsel and the defendant. It's 4 p.m. I marked this latest note from the jurors, 4 p.m. The note says, jurors would like to be dismissed and to return Monday at 8:30 a.m. Any objection?
No.
No, Your Honor.
All right, so I'm going to write, you are dismissed.
Judge is writing.
Response I wrote is as follows. You are dismissed. Please return to the jury deliberation room Monday at 8:30 a.m. to continue your deliberations. Remember and comply with the admonition of the court.
That works for us, Your Honor.
Yes, Your Honor.
All right, I'll sign it, Judge Fink.
Welcome, Broken Baker.
Hand it to
and
the
all the other
bailiff
bakers.
to be delivered to the clerk. And we're adjourned until 8:30 a.m. Monday morning. Have a good weekend.
Your Honor, could I address one issue first?
But wait.
We've requested a copy of the JAVS recordings of the trial in this case, and pursuant to Administrative Order Number 2007-015, it indicates that if a party requests a copy of the JAVS recordings, they're entitled to them. And I was told by the clerk of court that the court was indicating I'm not entitled to them, so I'm just trying to sort that out.
I understand. It's been brought to my attention. Put your request in writing, file it with the clerk in connection with this case, and the court will give you a ruling.
So we have that
We're adjourned
ruling.
until 8:30.
Please rise, people board.
We have that ruling coming this morning, maybe. Hang on, what'd she say? What'd she say? Back up, back up. Hang on, hang on. She had a little tiny comment right there at the end.
5, it indicates that if a party requests a copy of the JAVS recordings, they're entitled to them. And I was told by the clerk of court that the court was indicating I'm not entitled to them, so I'm just trying to sort that out.
I understand. It's been brought to my attention. Put your request in writing, file it with the clerk in connection with this case, and the court will give you a ruling.
Okay.
We're adjourned until 8:30.
Please rise, people board.
What the? What the? Oh! Oh my goodness. Got spicy there right at the end. Right at the very end. I think it was an H. WTH, not a WTF. Whoa. She moved the mic first. She thought it wasn't going to pick up, but because she moved it, it was pointing at her still, and it picked her up. This is crazy. Yeah, this is what I heard. This is what I heard. But man, so now we have both sides who have uttered things under their breath, caught on mic, that are on these are part of the JAVS recordings. I think it stands to Judicial Audio Video Sound, something like that. I don't know. It's audio videos system. I guess audio and video and sound would be redundant. But yeah, JAVS recording, Judicial Audio and Visual Recording. So it's going to be a spicy morning this morning. I'm excited. We don't have a feed yet from court. We expect the juries to show up and start deliberating in 7 minutes, at which time we will start the timer again. We have 9 hours and 26 minutes and 12 seconds and 92 hundredths of a second for those that are counting the detail set up on how far they've deliberated already. So let me get this setting. Let's see, box 4 is going to be camera 8. Let's do 4 for now, but okay. So there's our timer getting ready to count. It's right when we hit 11:30 Eastern time, which is in 6 minutes. We're going to start the timer to start the deliberation. It's not the most accurate timer, but it gives us an idea of how long they've been deliberating. And of course, we're going to turn on the deliberation time tag as well. Yeah, that's what I heard. That's what I heard. Am I blurry or is it just you? Just you. I'm in focus, roughly. It's f3.2, so I should be in focus. Do you want me to replay and zoom in? The zoom in part is something I'm still working on. It takes a little editing to do that. I have to throw it into Final Cut. I can play it one more time. Give me just 1 second. We just need the very end.
I'm not entitled to them, so I'm just trying to sort that out.
I understand. It's been brought to my attention. Put your request in writing, file it with the clerk in connection with this case, and the court will give you a ruling.
Okay.
We're adjourned until 8:30.
Rise to the court.
That was it.
The court will give you a ruling.
Okay.
We're adjourned until 8:30.
Rise to the court. Rise to the court. Rise to the court.
That was it. So, yeah, I don't think she'll be getting in trouble for it. I'm not sure if she's going to get in trouble for it. But you now have all the Terminator machines to do cool stuff. We've ordered Terminator machines. They should be shipping in May. So, what is the command going to be for that soundbite? Unfortunately, Steve, that one's not going to be on a soundbite. Soundbites have to be crisp, clear, and loud enough. And I could do some work on that one, but it would never be sound bite quality. It was off the record, at least. Well, it's on the JAVS recording. When you realize the judge has switched sides. Okay, I realize the judge says he did not see this. He did not see the count. But the bailiff did. The bailiff has seen the count. The bailiff has been asked direct questions from the jury. Was it not in his charge not to communicate with the jury? And here we find out from the judge that the judge has instructed the bailiff to proofread the questions from the jury and then give an analysis to the judge. So basically, according to the bailiff, the jury said that in the notes, but the judge has not read it. The bailiff knows things. He does. Honestly, my question is, I don't think anything has gone wrong. Well, yes, things have gone wrong. Things have happened that should not happen, right? The the jury should not be asking the bailiff questions about what to do. And the wording of how the judge says that the bailiff didn't respond appropriately or responded inappropriately or something like that. What are they talking? Is he like, well, I can't really tell you. Let me tell you what. Let me ask the judge. Is he giving them any indication whatsoever? Because his lips should be sealed. Like zip key, throw away the key when it comes to the jury. And here now we know that he's reading notes and at least being talked to. Do we need what the Becky says, Mother of Beagles? Do we need another bailiff? This just seems strange. Okay, we've got 2 minutes. Don't let me miss this. We're going to start the timer right at 2 minutes. Right in 2 minutes. Let me actually get the clock running so I can see it. We have 1.5 minutes. Aha. Let's see. Okay. Oh, man. 1 more minute. We're going to start the timer. We've got 55 seconds. What do you think about him saying, what's your reason before? Yeah. Oh, little slip there. You caught that, Fela. When the state was asking for a copy of the JAVS recordings, he started saying, what's your reason? Put it in writing is what he said. So he did say, what's your reason? He was asking, why do you want a copy? And this is not a thing you ask, why do you want a copy? This is something that the law states that if you ask for a copy, you get a copy. Right? And he's like, what's your reason? Meaning he probably knows what it means when they ask for a JAVS recording. Meaning they probably have issue with something that went down and they want an official copy without the transcript, right? Because the transcript is one official copy. And this audio video recording is a very good indicator of what's on the transcript. Okay, 5, 4, 3, 2... There we go. A jury has started deliberating, or at least they should have, so we're going to start the timer. It's now counting. Move that up just a tiny bit. All right. No feed from court yet, but we are watching for that. All right, Slanda says, catching up. So he didn't see the numbers. Slanda, let me go over what we saw. The way we watched it on Friday, we sort of jumped in on the pool camera feed, which has a little different audio, and we missed just the very beginning of what the court had said. But he said that he had previously instructed the bailiff. I'm not sure when, because I don't remember this in the charge to the bailiff when he was sworn in for his job. He had previously instructed the bailiff that if the jury gave any sort of indicator as to where they were tally-wise, to sort of intercept that and inform the judge before he gave him the note. So the judge doesn't inadvertently read the tally, which he should not know, which might be an immediate mistrial if he does that. That might be some, that we can't progress from there, right? So he says, I've informed the bailiff this previously. The bailiff informed him that this note does have a count to show that they are not unanimous. So instead of reading it, the judge says, I've ordered it. It's been closed and I've ordered it stapled and kept shut. It's going to be in the file. It's going to be in the court record, but I have not viewed it and I don't know what it is. And then he told the jury, knock it off. Don't do that again. And after he slapped them for doing that, he immediately said, and by the way, you're doing your job poorly. You need to try harder. Try harder. And whatever the jury did in response to that, the judge, once he had given them that try harder thing, once they left the room, he said, I don't think they're gonna take me up on that. So they might have given him the stink eye. They might have rolled their eyes. They might have been shaking their heads. They might have shown some sort of emotion that gave him indicator that the jury was hung, or they're not happy with the go back and work harder, try harder. You haven't spent long enough. It's been about 24 hours since they got the case. That was it. Let's see. All right. Samantha, thank you very much. We can watch that here in just a second. We've got some stuff we can watch if we're continuing on verdict watch. We just want to wait for just a few minutes and see if something happens from the court. Did he say you're doing your job poorly? He said they're not trying hard enough. They need to try harder. It was not an actual Allen charge. It was very closely worded to it, but it was not the Allen charge, which is usually given verbatim. So I think he still has space legally to give that Allen charge again, which, wow, how do you tick off a jury? Tell them not working hard enough, keep sending them back to do the same thing over and over. He said not long enough, technically. Did they say what the jury count was for? No, all we know it was not unanimous, and that they believed they'd reached an impasse. It was a pre-Allen charge. I heard other judges do the same thing. I think it's in his wheelhouse to do that. The only danger is he's when the jury starts deliberating, his role changes dramatically, right? He goes, the jury is in charge, and he is like just the go-between in many ways. And he has to be very careful that he doesn't give something to the jury during their deliberation period that would indicate a preference one way or another. He needs to be entirely impartial. And when he's crafting his own, I just want to make another, I'm going to insert this here. While they're deliberating, that's a risk he runs. And I think had he used the word proof, that would have been one. And he used the word proof when he was talking with the counsel. He did not use it with the jury, but he said there's been so much proof that's been offered. Proof means that you accept it. This means that that's true, right? Proof is something that's true. Evidence can either be accepted or rejected, but proof is fixed. I've proven something. If you prove something in science, we know it's true because we have done the proof. And so I think if he had used the word proof, that would have been grounds for mistrial. But he took the risk of giving them the admonition, and to their credit, they went back, and they're still working. They're still working at it. Yeah, let's see. I feel there's a difference between working hard enough and working long enough too. But did you feel that the jury would be insulted by what he said? Do you want to talk? Yeah. Okay, put on your headphones.
Okay. Oh, my
Mrs. R.A. is here.
So I was trying to chat something. I feel like I need to tell everybody the kids are doing school. They're doing an independent part right now. But I was trying to chat something, and I just don't have enough numbers and letters to be able to say it. I am concerned that the fact that he did a fake Allen charge, and then there's going to be a real Allen charge, that essentially they said twice, we really can't do this, and both times he says, get back and get it done. It's just highly likely that they're going to say, all right, I'm going to do compromise. I'm going to give up. It's not going to be what they really want it to be, what they really feel is the right thing to do, because he did it twice. It's just going to create a situation where they feel like we're never going to get out of here unless we come up with something, basically. And I think that's really, really wrong. I don't know. Did I explain that right? Did I explain that well?
I wasn't listening. I was doing technical stuff. I'm sorry.
Okay, listen this time.
I'm all ears.
Because so here's the deal. When you do an Allen charge, that means that the next time they come to you and they say, we can't figure this out, you have to, by law, say, okay, it's a hung jury.
You dismiss them, yeah.
Right. By not doing an Allen charge, that left it open for him to basically twice tell them, you have to go back and figure this out. By doing that, it creates a scenario where unless one of the jurors knows that the Allen charge is the last time, they're going to feel like they're stuck in some sort of sci-fi loop where they're not able to get out of this jury room unless they come up with a conclusion. And as a result, I think that we're going to get a verdict that is
probably lesser included.
Yeah, I think it's not right. It's better to be hung than to force the issue like this.
I agree. A lesser included is probably more likely after an instruction than I would say this. It seems like it would be a big stretch for me to have the jury come back with a conviction as charged if they have a holdout who is right now not able to find guilt in anything, or not able to find guilt at the level that the others want to find guilt at. I just don't think that they're just going to sway that one person. I think it would be more likely that the people who are guilty would be more willing to compromise and say, we'll go for a lesser included where the penalty is not quite as high. If you'll step up, let's meet in the middle.
Yeah. And again, that's my problem with lesser included is that instead of saying it's either not guilty or it's guilty, you're saying it's not guilty as one thing. And then you have these 4 or 5 options of guilty. And so it puts the weight on, we're probably going to choose some version of guilty. And it just shouldn't be that way. It should be more than 50% not guilty just by virtue of we are innocent until proven guilty. And so I think that by forcing this issue, it is more likely that they'll find some version of guilty.
Yeah. Ashley asks, can he decide not to do the Allen charge? No. That's basically the law. And I think the law was designed to save the state money, honestly. The expense that the state and defense goes to put on a trial and go through all the expert witnesses and the legal work and the billable hours and the courtroom and everything else, it's very, very expensive. I'm sure on Mr. Kelly's front, I would be surprised if he didn't have a bill somewhere around $150,000 to $200,000 for his defense in this trial for 2 very competent lawyers for 4 weeks, and not even counting what led up to this. But it's a ton of money. And so the Allen charge basically gives them a chance to one more time try to not throw all that away and have to start over from scratch, where all those charges will then, or most of them, would be incurred again. Typically, you don't evaluate all the evidence one more time and send it back to the lab. Those usually you begin with the results you got back before, but you seat a jury again, and you start the trial with opening statements, just like this one started. And those are expensive as well.
They are, but you're talking about an expense that gets to take its money out of everybody's pockets, as opposed to the defense, who has to pay for it on their own. Now, I know this was crowdsourced, but that is really hard to do. I don't think he's going to be able to do it twice. It is definitely a bigger deal to have a hung jury or to have, or to even be found guilty for the defendant than it is for the prosecution, because it may cost them money, but so what? Raise taxes or whatever. It's not their money.
So let's see. Adam Fox Alpha. Sorry, Alpha Fox Adam. I cannot speak today.
Whoa! Sorry, keep going.
It says, what rule or admin order or case of statute indicates that it can only be instructed once? I'm looking at Standard Criminal 53, the instruction 53. This is from the Arizona Standard Jury Instruction Template, 6th edition, 2022 was when it was printed. And 53, that's what the judge read, basically saying this is offered to help you, not to force you to reach a verdict, all that. That was word for word, and he read it precisely. I followed along on this side. When a jury has not, before giving an impasse instruction, the trial judge must determine whether the jury is at an impasse because prematurely giving an impasse instruction may be a form of coercion.
Ooh.
Where a jury has not reached a unanimous decision and has notified the court, the trial judge should ask the jury whether it is at an impasse and needs assistance from the court. If the jurors didn't indicate their decision is final, the impasse instruction is not appropriate. Where they say,
well, how are they supposed to know these are the words that we have to say?
They don't. And basically, these are just the guidelines for the judge because each situation is a little different. I think it's intentional that the jury doesn't know that those are the words they're supposed to say.
I agree. I think that also plays into when they're like, wait, you do what for a living? No, you can't be on the jury. You know too much.
Let's see, they have reconstituting a jury instructions here, jury polling.
While you're looking at that, Vicky has a comment. Justice for a victim should not be injustice for the defense. I think this is a really great insight. Of course, there should be justice for the victim in any case all the time, but it is just against the United States Constitution, the way that we're set up, for us to say someone's got to pay. Hey, you're available, right? That's just not the way to do it.
Still no feed from court yet. We're watching for that right now. I need this parsed slowly, Judy. It gets so confusing. It really does. And honestly, the law is confusing. There are lots of moving pieces and parts. And you think of the law and what is legal and what is not, as what the police will give you a ticket for or arrest you for. And then once you get to court, there's not just law, but there's procedure and a precedent where you have to know what happened last time this issue came up and it was appealed and it went to the Supreme Court and a ruling came down. And so it gets quite complicated. And some of these jury instructions have been crafted because of all that precedence and because of the law and because they ran into problems before. And sometimes we reach a situation where we're sort of in a unique situation. Think of like the Apple River trial or the Crumblies trial. It's like, hey, the rules we have, the laws we have were never crafted with this situation in mind, and it's sort of unique in that we are coming at it from a different angle, and suddenly what we normally say, this is the rule, this is how we do it, it doesn't apply quite as well. At least the shoe doesn't fit, but we're still trying to shoehorn everything into the how we normally do it. So I think this case, I think the judge has not caused a mistrial. Just my take on what happened. It's raised my eyebrows a couple times, but interesting. Let's see what happens. We're waiting for anything for court. If it happens, it looks like the jury's probably gone straight into deliberations because we've had 15 minutes now go by. They're 9 hours and 40 minutes into deliberation total. We need to first of all be able to understand what a reasonable person is by definition. Until then, we can't understand the law at that level.
Yes, most of us have not met a reasonable person for a decade or so now.
Except ourselves.
Right?
Yeah.
I'm the only reasonable person left.
I honestly, every time I hear that instruction, in my head, I hear, what would I do? That's the reasonable person test. Would I have done that? Would I jump to that conclusion? Would I have said, yes, this is my only resort? Would I have said, this seems like a good idea at this time?
Yeah, that is so true. I never at any point am I like, I wonder what Bob would have done. He's a reasonable person. Like, I never think that. I always think, what would I do?
Yeah, I would do this, but I'm not very reasonable. So,
so I have nothing to judge by. We're screwed.
I don't know why YouTube is kicking people out. That's not us. I'm going to inform YouTube that we have reserved seating here and people should be seated and not messed with, but apparently it keeps kicking people. I am the reasonable person. Can you read this one for me?
Yeah, okay. Let me just go write that down and stick it on our wall.
Maybe we should have it cut out in vinyl and have it like big letters in every room. Oh, man. If you want expert advice, ask yourself.
Yeah. I talk to myself all the time. Excellent conversation.
Yes. If you want to talk to a true intellectual.
I speak to the voices in my head.
What do you guys think of the judge flipping? And we've seen this twice now, right? He's sort of been on a pendulum, and it swung two directions. At the beginning of the trial, I would say he sort of favored the state, but it was slight. The state has the burden. I think the court is naturally inclined to favor the state in cases like that. As far as the beneficial doubt the benefit of the doubt when it comes to like the judgment of acquittal, things like that, it all swings the state's way. And then with defense, right before the defense took over on their case, the judge sort of swung far on the state's side and shut down defense on cross-examination, which is, if you watch The Lawyer, Peter said that was a huge issue. And then from that moment, like over the weekend, he drank a magic potion or something and switched. The pendulum swung the other way. And since then, he seems to be more and more upset with the state, being more and more short with them, even to the point where the court, when they say the court, they're talking about the judge.
I know.
They're not talking about the court clerk who refuses to do her job and give us a copy of these videos. The judge has said no.
I know. And they're bringing it up too. They're like in his face. Hey, you need to do this, and you didn't do this.
I think the judge is bipolar, says Karen. You might be. But he swung the other way, and I'm hoping we get to hear this morning a response, or maybe it'll be filed.
I hate to say this word because I feel like I would hate it if anybody used this pejorative on me, but man, that guy is moody. Sorry. Mm-hmm. That's what it looks like.
Okay.
Yeah, Yeah, you don't get to say that about me.
I can't say that.
But I'm just saying.
I can't even agree. I can't.
I'm not talking about me. I'm talking about the judge.
I need this cord to be like, there we go. That's a little better. All right. The silence. Yes. I wouldn't change my vote with an Allen charge, says I wasn't born with thorns. Fellow jurors would have to show me what evidence I missed.
Yes, and this, this is a personality thing, I almost feel like, that we get to a point where, like, I'm done listening. I'm done participating in this conversation. I've made up my mind. The end. And I don't know, that's probably, maybe it's a problem, but at the same point, if you couldn't do that, like, you'd never get a verdict. You have to get to that point sometime.
Brybear says the judge probably ran into his judge friends at the club over the weekend, and they said, what are you doing? You can't do that.
Just so you know, the internet is talking about you.
I will say there have been many times, and maybe probably the best example of this was Zachariah Anderson's trial, where I would say mistakes happened, errors happened in court. Things came out that shouldn't have been. Things were discussed in front of the jury that shouldn't have been. Things were blurted that were not allowed. I've never seen so much an incident where it looked like, and I used the example during that trial, it looked like we had, Roadrunner style, run off the proverbial mistrial cliff.
Yeah.
And our wheels were spinning in the air, and we were just waiting for gravity to take hold and plummet us down. And time after time after time, we managed to retrace our steps in the air, get back to firm foothold, or at least get our fingertips on the edge and claw ourselves back up before we fell to our deaths, or fell to the mistrial in this case. And it seems like in a couple instances here, especially with the judge shutting down cross-examination, the judge has been doing that. And we see that in his willingness. He's like, oh, by the way, defense, remember how I said, I'm going to let you call that guy and take as long as you need to talk to him and get those questions in that you couldn't get in before because it's the right time to do it. So just make sure I'm on board with you guys. Go defense.
I've put my white hat on.
Yeah. It seemed like he was trying to fix something that he knew. There we go. Freezy, right? You guys know I'm on the other side of that one, but I do feel that he deserves a new trial.
That trial
mistrial for the reasons we just talked about and many others. But I do agree with the jury on that one. Craig, we did vote on an outcome, and most of us feel that either he is not guilty or it is not proven. But the vast majority felt that way. I think it was over 75%. Let's see. Sarah Boone case got pushed off again. They just keep pushing it off.
Man, she just needs her day in court. Why did they push her off this time?
I think they're just not ready. Defense has just barely hired some experts, and I think they sort of need the time as well.
Did they get experts?
Yeah.
Oh.
Of sorts. Are they going to call? They can
like
call that
Letitia
detective
Stout
dude?
level
No.
experts?
No, worse.
Oh man.
The guy who, what is he? Is it Prison Break Investigations?
You've got to be joking.
Yeah, he's on board. So good stuff. But they've also got another expert to testify as well, and I think she needs time. New attorney as well. New attorney isn't ready because they had that last minute change.
Which one was that?
I am Dave. I didn't come to the reasonable doubt side. For me, the DNA in the back of his van, there is no, in my mind, there's no way that could exist. That without him being involved in that crime, it just didn't make sense to me. All right. Her lawyer got experts, and they asked for the time.
Do you know, I can't actually read that very well. It's something about if we are 75%, then apply that percentage to the 8 jury.
Well, that would mean 2 holdouts.
Yes.
It would be a 6-2 with the 75%.
It is odd. We do not actually represent the jury accurately very often.
Amber calling in.
Oh, okay. Actually, I hear the kids talking, so I gotta go. Gotta homeschool.
Okay.
See ya.
All right. Bye. Hello, Amber. You just missed my wife, just barely.
I know. Crap. up.
She saw the phone ring and she's like, I'm out of here.
I know. Had nothing to do with hearing the kids chatting.
What's on your mind?
A couple of things. So I just checked the docket for Sarah Boone. No letters have filed yet, and just so everybody understands, they can actually backdate the docket. So I actually go backwards to the very last letter and make sure I'm not missing anything in between. But it looks
that
like
court particularly, it can be almost. I've seen documents show up 2 weeks after they were written by Sarah Boone. They've got filed. So.
Yeah, it's tricky when you're following that docket because you never know when they've uploaded something old.
The judge finally handed it to the clerk and it got filed.
Yeah. The other thing is I just kind of wanted to make a disclaimer. YouTube is doing something funky with people in chat, with slow mode, with anything and everything. We're not sure what it is. We have lots of different inquiries on the Facebook group page and in some of the chats. The mods are not doing anything, I promise. It's not us. It is YouTube. And just for everybody that doesn't understand how moderating works, we can actually see what's removed, who is booted, when, why, all of that. And there's nothing in the log for that. So we're not doing anything to boot you guys out of the live. That's something that YouTube is doing, and we haven't figured out why yet. There was other thing to that, and I don't remember what.
Just a warning that if you do something wrong, we will boot you. No, just...
I wasn't going to go there because I think you scared everybody from the mod.
No, honestly, YouTube has been, to varying degrees, it's been having a lot of trouble. Sometimes you see it often in the like counter where you'll see somebody say, how can there be 1,200 people here and only 3 likes? And it just doesn't update. Or why is chat going like a mile a minute and it only shows there are 10 people in chat? It's doing some weird things, and it's not on our end. Just hit a refresh if you need to.
It's happening across every channel. It's not just an us problem, it's a YouTube problem. I remembered what my other thing was. Can I say it now? Mm-hmm. When you're trying to tag people in chat, you cannot tag like the traditional tagging people with an option menu to pull up and select who you're trying to tag. That only happens if you're on a computer. If you're using a mobile device, even an iPad or a tablet, it's not going to pre-populate for you. So unless you specifically type things verbatim, it's not going to tag the person you're trying to tag. That is also not something that we can control. If you're trying to tag the mods, please understand, we're not ignoring you purposely, and neither is Scott, but we don't see every comment.
It can go fast. But I appreciate it. I try to read them, especially if you like Lady Atara here tagged me at the beginning. That does help me. It stands out on my screen because it looks like, let's see. It looks like this on my screen. This is how I see. Let me just show you what it looks like. Oops, that's wrong. Littlest is doing schoolwork. So let me clear this. So this is my view, and I'll show you how it updates here as you guys type, and it just scrolls through. And if I miss a super chat or something, I can actually go back and see what happened over here. So I can see that Joyful sent a super sticker that I forgot to say something about. Thank you very much, Joyful. And I can pull that up. Cooper's mom, member for 11 months. Thank you. And Laura V came in with that analysis as a legal analysis as a lawyer or as attorney. So thank you for that. Appreciate that. But I'm not trying to skip anyone intentionally. Steven says, my eyes are up here. Yes, thank you. Anything else, Amber?
No, that was it. I see a lot of feedback coming through on some chats on the Facebook group and frustration, and we get it. Trust me, we are just as frustrated because we can't fix it. So just kind of hang tight. As soon as we know something, we'll let you guys know, but we're not intentionally ignoring anybody.
No. Thank you. Appreciate that. You guys are amazing, by the way.
Thanks.
Alrighty.
I'm hanging up now.
All right. Bye. Coley, I do apologize. This is a program that it's the best program I've found for showing comments on the screen easily. And it's a formatting I can't change, so I can't make the background appear properly. I need it to be rendered differently. So especially the yellow super chats have a hard time, especially if there's not a dark background behind it. All right, let's see who's in charge of the internet today. Who do we give that to? You know who you are. I don't remember. Somebody will remind me in chat. It's just working, so I haven't. Is it John? John Link? I think it's John Link. What if you put a banner permanently? Like a banner across the screen? I think I could probably do something with a key and a fill that could work, but it would get complicated and it would require a couple buttons to click everything. Yo Mama, a member for 12 months, says 12 months already. Time flies when you're having fun. Thank you, Yo Mama. Appreciate that. Love the Orange Courthouse as well. Still no information from court. I'm just looking here. We might go check out the sentencing for a case we followed with Judge Boyd. If you give me just 1 minute, let's see. Judge Stephanie Boyd. Let me find where she's at here. I see a couple people joining on the Facebook page. Just make sure when you send your request, you've scrolled down to answer the questions at the bottom. Otherwise, we can't accept you because there are so many bots that try to join that that just look like. Let's see, they look like a normal person, but they jump in and they just spread junk on the webpage. So you have to answer the questions. That's our bot filter. So please do that. And if you get rejected, just invite again and answer the questions the next time. All right, April 8th, Judge Stephanie Boyd, morning. Oops. I think it's this one. Let's see if this is it. Was it 55 minutes in? Not sure if this is the one. I think it is. Okay, we're gonna jump over. Oh, DSN, thank you very much for the super sticker. You are number one. Thank you. Appreciate that. We're gonna jump over to Judge Stephanie Boyd here briefly while we are waiting for action from court. So I'll keep the deliberation timer running. See if this is the right one.
It is made. When he tenders the offer to you, I want you to internalize it.
We're just done with that one right here. There we go.
Complaining witnesses are on Zoom for a PSI.
All right. Where's Mr. Lozano?
This is the guy who stole the $300,000 trailer theft, right? Mary Kay, 15 months. 15
All right, everyone,
months.
please have a seat.
Thank you very much.
If you're not on this case, court is calling 2021 CR 7016, State of Texas versus Jose Lozano. Can I have the parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Raymond Martinez for Mr. Lozano.
And are you Mr. Lozano? All right, we are here for sentencing. A jury found you guilty. Just one moment. And they found you guilty of the offense of theft, $300,000 or more as charged in the indictment. Have both parties had a chance to review the PSI report? State.
We have, Your Honor.
Defense.
Yes, Your Honor.
Any corrections or additions to the PSI report? State.
No, Your Honor.
Defense.
No, Your Honor.
All right. State, what are you requesting?
Your Honor, we're asking that you sentence the defendant to 15 years in the prison.
15 years.
And the reason?
Your Honor, the defendant was convicted of a first-degree felony offense in this case. reading the TAP evaluation, he's shown no remorse for his actions. He doesn't say this was the result of being under the influence of drugs or alcohol. His story about how he says this happens is just not credible. Doesn't jive with the evidence that we saw at trial. He says that someone offered to sell him $300 worth of items, over $300 worth of items for $600 to $800. He says his friend brought the trailer to him. The evidence that was elicited at trial indicated that a window of the truck was broken. So it's pretty clear to me that he knew these items were, the very least, he knew these items were stolen. But Your Honor, what he's convicted of is theft. And I guess the other part of this, the TAP evaluation, they talked about his home life a little bit. He says he has regular contact with all his kids, but evidence elicited at the trial was he's not paying any kind of child support to Edith Serrano. That was one of the victims, you may recall, Your Honor. Or I'm sorry, one of the witnesses at the trial, Your Honor. I know you were presided over this case, Judge, so you remember the testimony, but Terry Kirkbride and his wife are moving from California to Florida, and they lost almost everything as a result of this theft, Your Honor. But what Terry said on the stand is what really stuck with me. And what he said is the hardest part about this is that he lost things in this theft as a result of this theft, as a result of the actions of the defendant that cannot be replaced. So the hardest part of that for him were the photos that are just gone forever. The things that he inherited, the things that his wife inherited, they're gone forever. Items from his military career that are gone forever, damaged or lost. And so that's what I want to emphasize to the court. And the other part of the thing I want to emphasize to the court, Your Honor, is we're asking for this sentence to protect the community from these types of thefts. This property crime, I think, especially folks who are involved in the criminal justice system, we can get sort of jaded and think, well, nobody died, right? But these crimes are very serious, and this is the victims in this case lost nearly everything that they own. And so, Your Honor, we're asking that you protect the community from these types of crimes and sentence the defendant to 15 years in prison.
All right, defense.
Judge, if the court will recall from the facts of the case, I think Mr. Lozano's explanation is perfectly plausible. There was absolutely no evidence presented by the state in the trial of the case that he was present when that truck was stolen, or that he ever drove that truck, ever had contact with that truck, it was ever on his property. His suggestion that the guy brought the trailer to him to see if he wanted to buy it is consistent with somebody who did steal that property, trying to go and pawn it off on people. Him paying $600 or $800 for what was the contents is because all the valuables were already gone. All that was left was a bunch of stuff that after whoever stole it poured through it. He admitted, yes, my print is on the trailer because he showed it to me, and he wanted more money than I could afford, and so I didn't buy it. He offered me the other things that were there. The complainant specifically testified in his testimony the things that were at Mr. Lozano's property that they recovered were of little or no value, right? If you look at the PSI report, when they go to the restitution, it says approximately $300,000. How can you approximate that when he's already been found guilty by a jury? Well, this court knows why. It's because her math was a mess. The complainant testified in the trial of the case that he agreed in writing a contractual agreement with the insurance company to settle for $240,000. The theft statute is very, very clear. It's the value of the property at the time it's stolen, not what you paid for it years before. So when you read their exhibits, and the jury obviously never did, they put no attention to the real evidence in the case. They felt bad for complainants. I feel bad. We all do. They suffered a great loss, but they didn't prove he was the one who did it. They proved that he was a party to being in possession of some of the stolen property. That's why we had a jury charge all the way down to a state jail. That was the appropriate charge. This case is ripe and full of appeal issues, especially on the issue of the value and sufficiency of evidence. This case does not merit a day in prison. I get it. It's a big loss. But if you look at the exhibits, and I was going to bring it to you, but it's in the court's file or court board's file. USA went through an exhaustive list, and he says I spent months and I kept updating it, telling them all the things that I lost. They put the retail value, they depreciated it down to the actual cash value at the time of the loss, right? He signs an agreement, accepts the check saying $240,000. And that included the truck.
All right, so just so parties know, I'm not going behind the jury's verdict.
I'm not asking you to,
Yeah,
Judge.
all
I'm just saying the punishment should fit the crime. The jury did what they did, and that's for another court to look at, whether there was sufficient evidence for their verdict. But my suggestion is, if they've proven that my guy drove off with the truck and the trailer and he had gotten rid of everything, I can see that this is a different case. There's absolutely no evidence that was presented to suggest that. And his explanation fits squarely within the facts that were presented in this case. So I get it that there's restitution. My client is going to have a lifetime consequence because of his resident status of potentially being excluded from this country. So he is going to get punished severely by this court and probably another one. So all that being said, Judge, we'd ask the court to sentence him to a term of probation. We'll pay restitution to their number as best he can, as long as he can.
Eternal probation.
But that's the appropriate sentence. If we're going to start locking up every person who goes to a flea market and those people that come into property illegally and they get it in their possession, we're going to start sending them all to prison. We don't have a big enough jail for that, Judge.
All right. Is there anything you wish to say?
All right.
Yes.
All right. You want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand, state your name for the record. All right. And make sure you keep your voice up so the court reporter can hear. Who's the name of the friend that gave you these items?
Who's the name? I don't know his name. They called him.
Well, I mean, you say he's your friend.
Well, yeah, but
And you say you received a phone call from a friend.
yes, should have wrote it down.
All right. So here's my other question. The items, because there were some items that were related to his military career. When you saw the name of a person's name on military paperwork, what did you think?
At the point already, I had the stuff in my house. I didn't know what to do with it, didn't know where it was there. I bought it. It was in boxes when I bought it. By the time I got to open it, I saw the stuff.
So how much money did you pay for this stuff?
About 800, whatever was in the trailer where I got it off, about 800 and $900.
Did you look through everything before you paid 800 or 900?
Boxes.
So you just take a boxes sight unseen, sort of like Storage Wars?
Oh, yeah.
All right. And so you don't know your friend's name who phoned you. According to you, it says that you were home asleep on this date and you received a phone call from a friend.
They call him Chaparro, but I at the top of my head, I can't remember his name right now. I'm sorry.
Oh, no problem. I just wanted that cleared up. All right. This is what the court is going to do. Court is going to sentence you to 6 years in the prison, give you credit for any time served. With regards to the amount, the court does not deal in approximations. So for the court, there is no restitution because there is nothing here to suggest a restitution amount. It just says approximately $300,000. There's nothing I can do with that. And this trial was on March 21st. I'm sorry, just one moment.
Nobody on Storage Wars
Yes,
pays
March
$800 for
2024. So by that time, there should have been some amount to the court. So I'll give you credit for any time served. Is there anything else with regards to sentencing, state?
Judge, is the defendant's birthday May 1st, 1998? Is that right?
You can ask him.
Okay. Is that? And Judge, would you incorporate the evidence at trial as to the value? Would that be something you'd be willing to do?
No, because again, the amount that's listed in the PSI report is approximately $300,000. And then defense counsel is correct with the amount that the complainant settled for. And I know how insurance companies do sometimes.
Probably
the amount, yeah, the amount the insurance company settled for was $240,000. So this is where we are.
If I could, just one last thing on the record. I just wanted the court to be aware, the record to be clear, that approximation comes from the complainant. The PSI officer called the complainant to ask him that number, And that was his response,
Yes.
even after his testimony that was presented to the court.
I'm not ordering restitution unless there is some sort of deductible, which the court has not received any information on a deductible amount. So the court will sentence you to 6 years in the prison and give you credit for any time served. Is there anything else with regards to sentencing?
No, Your Honor, we just have victim impact fees.
I do, Judge.
Yes.
We will be filing notice of appeal and a request for an appeal bond. Do you want to take that up today or?
Oh, you have to file you'll have to file the motion and the court will take that up. So if you could have him fill out the trial court certification.
Well, they're going to be filed today. That's why I'm asking if he could be kept in court today so we can address it, or do you want us to set another
It's going to have to be another date. All right. Once if you could have him do the trial court certification, so I could do that now, please.
They're going to appeal. They got a 6-year sentence instead of a 15-year sentence, and they want to appeal.
Well, do my magic backwards.
Yes.
They allowed him to be cuffed in front so he can sign. He says he didn't steal it. He was in possession of it. Man, Pauline, you're asking about some really, really tough cases.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? All right, you have a right to an appeal as this was a jury trial. And counsel, once you file that motion, Ms. Ferguson will give you a date.
Yes, sir.
All right, you said there's brief impact.
Yes, ma'am.
The jury
right.
convicted him for stealing.
Are the parties here
They didn't
on
convict him of
Lozano?
buying
If you could
stolen
start your
goods.
video, please. Who's going to be the person?
It's Terry Kirkbride, Your Honor.
All right. Mr. Kirkbride.
Yes.
All right, you may begin with your impact statement.
Okay, I had no idea what to expect in this matter, but I see the sentencing's already been done. I'll just try to keep it short. I think the court's already heard most of our story, but I'll just go down the quick history. I mean, when we made our decision to move to Florida, it was to be near kids and grandkids. It was a pretty tough decision. I lived in California all my life up to that point. Sold our home, gave away pretty much all of our possessions that could be replaced, like furniture, refrigerators, that type of thing. All of our most precious items were packed up very carefully. It took us almost 3 months to get everything properly packed and wrapped. And I bought a 24-foot enclosed trailer, and that's where we packed everything in. On our journey to our joyous move to Florida to start a new life, we made it as far as San Antonio. And of course, from that moment forward, December 4th forward, it's just like our world was turned upside down. It derailed our whole joy of the move. And what was supposed to be looking for a home right away turned into almost an 8-month endeavor because we were dealing with all of the aftermath of the theft. I'm a combat veteran. One of my diagnoses is PTSD. So I was already dealing with that. And then this just totally derailed me and my wife and left us kind of in this state of like, what next? As we put the pieces together, keep in mind, it was 3 years, 3 months from the time of the theft to the time of the trial. And they had some 22, 23 resets. Each one of those resets represented to us is we had to juggle our lives around the schedule of the court. Gave up family vacations, gave up visiting sick family members. We did a lot of things during those 3.5 years, 3 years, 3 months that just kept this thing going. And now we're here at the final part of the sentencing and all that. And I feel for both sides. I feel for Mr. Lozano and how this must be for him, but I also got to understand what it was like for us, these weren't just things that you go to the store and buy. This was our life. My wife is a Native American studies. She had all of her research that was in those boxes that are gone, all of my VA records, all of our photographs of our family from the past, videos of the kids, all those things that cannot be replaced, along with all my military accolades that are gone. The impact was great. And I am glad that we're finally at a point for us anyways, where we can just kind of turn the page. I think that's enough said.
All right, thank you. And Deputy, you can take him into custody. What is his client's name? All right, Marco Antonio Vasquez. All right, Marco Antonio Marino Vasquez.
We're ready, Judge.
All right, come down, sir. Yes.
We're gonna need the interpreter.
Okay, so we're gonna bail just on that.
No, she's here.
There we go. So he got 6 years. Remarkably, he did not get any restitution, even though the jury convicted him of stealing $300,000 worth of goods. Will not be paying a penny in restitution because I would say of an error on the state's part, where instead they just said it's approximately worth this value. Had they listed at least certain items and listed their exact value, I think he would have got all that restitution. But also, one thing to be mindful of is that he did get reimbursed by the insurance, which might be viewed as restitution for that. All right, we're going to do a little more court hopping. Oh, wait. We have a feed from court. Hang on. We're 10 hours, 15 minutes into deliberation. 10 hours, 16 minutes now. Just barely got a view pulled up. I'm not sure if it's just warm up or what, but if everything happened according to schedule, the jury's deliberated for about, whoa, that hurt. Let me fix that. That was incredibly painful. Need a limiter. Were you all deaf too? Wow, that was bad. Okay. That was quick reflexes on my part. I heard that and immediately cut away when they sent static. So we'll keep an eye on this. Buffer C last comment. No place for victim shaming, name calling, or race baiting on this channel. 24-hour timeouts issued for that nastiness. Thank you, Amber. Is my mic audio low? Tiny bit. Boost it a little. Is that better? Daybell is getting spicy again. Let me keep an eye on what's happening in Daybell. Let's see. Is it too spicy for our channel over here? If we're going to drop in and see what was happening. Yeah, I got blasted as well. I haven't heard anything from Laura yet this morning. Let me check the burner really quickly. See, that's quieter this time, right? A little quieter. Go here, put that up there so you guys can see we are watching that. And once there's motion, we'll take audio. He can't get a double recovery. His insurance paid him, so no restitution. Vicky says, you said people can reuse your streams on Topmark, but you haven't put any notes on attribution. I haven't required anyone to attribute it to me because this is a public court feed. It's not one that I own. So I'm not, is that what you're asking? And because it's public, I don't need to attribute something the public already owns. Paid for by all those who pay taxes in Idaho, including myself. Insurance might sue the defendant? I wonder, possibly. I wonder if they do that. See if they can recover something. Yes, they can. If they can, they will. I mean, if there's something there. All right. Let's see. Laura says, nothing to report yet. We'll be a little late this morning. Nothing to report yet. We'll let you know that when the judge brought jury in to encourage them to keep going on Friday, jury 11 was nodding head yes in agreement, though she has typically nodded whenever the judge has spoken to them during trial, so not sure if that was noteworthy. No other outward expression from the rest of the jury. No looks of frustration, etc. Same old stoic jurors. So juror number 11, who was pro-defense, was nodding. I put the word emphatically on there. Noticeably is probably a better word. Was nodding when the judge was saying you should go back and try harder. So it sounds like she's fixed on her position, but we're trying to convince other people. Josh, thanks for keeping an eye on Thurston County District 4. If something pops up, let us know. That's a fun one to drop in on. We found some just real gems up there out of Thurston County, Washington. Haven't followed Judge Cedric Simpson this morning. I think we have some coming up. I'll have to check the calendar. He's got some things happening. Melissa says, Thurston County makes me anxious. I worry about my niece because people are crazy up there. Vicky doesn't know how to read that. It's our opinion that juror number 11 appears to be pro-defense. Laura sent that this morning, or just barely, moments ago. Nothing to report yet. We're going to follow Karen Reed. Here's what we're going to do. Probably when the trial begins, Brandy Churchwell is following that trial live. She's been doing a lot of work on that. She's got a podcast specifically about that trial that she's put weeks and weeks and weeks of effort into. She's probably going to follow the trial. What I would like to do is follow like a highlights in the evening, and I'm not sure exactly how to make that happen, but this is my goal. Highlights in the evening for that trial, so we can recap just a little bit. But for daily coverage, I'd suggest going over here to Brandy Churchwell, where she's going to be following that. If you want to follow that, minute by minute. Brandy's sick today. Oh, bummer. She posted the most beautiful pictures of the beach last night. Emily Baker also following Gavel to Gavel on Karen Reed. Another great place to watch. An incredible legal analysis. Brandy and Melanie Little are splitting coverage. Wonderful. It's a tripod fidget spinner. No, this is a gavel. It's a little gavel. All right, Brandy's on number 23 of her podcast in USA as of Friday. She was interviewed by Law and Crime, I believe, about the Karen Reed trial. I'm not sure if that's aired or when it airs, But I know she did an interview. I think it was last week for that one. Let's see, Sade Robinson out of Michigan. Send me the details on that one, Jamie. I doesn't ring a bell off the top of my head. I love how many of the LawTube people are neurospicy. It feels like they are my people. Got good stuff. Let's see. Looking at Judge Wolf. I don't see Judge Wolf live right now. Nope, he's not currently live. Any Maya updates? There's a meeting today. Already aired, was a short clip. I'll have to look for that. If somebody can send me a link, I'd like to watch it. Played on Crime Fix. Maya updates, they have a meeting today that's more of a scheduling meeting. The judge has ordered everyone to bring their calendars. So they're going to talk about what they're going to talk about a little bit. So it might be a little bit of a teaser, but that's it. So we're just watching for the new dates, which will be a little spicier. Sade Robinson is Milwaukee. Sophia, honestly, by and large, all the members of LawTube and the LawTube adjacent communities are amazing people. I'm sure you can find some bad apples in the group, but I've just met incredible, generous, thoughtful, insightful, smart, witty people just at every turn. It's wonderful, including you guys. So, Melissa P., it takes some research. Very few judges actually stream on YouTube. It's more common to find a court that has a publicly viewable live stream. But statistically, only a small fraction actually stream on YouTube. Had a great weekend. Got a little drywall hung, all but one wall. Let's see. Let's see. Planning on being out there sometime? Yes. Bought tickets, Eric. And good to see you, my friend. My son's getting married. It'll be up in Meridian, Idaho, but we're spending a month in the region. So, I think we'll be there pretty much all of August and under the first week of September or something like that. Thurston. Do we need to check out Thurston really quickly? Is that courtroom 4, Melissa, Angela? Thurston County Courts. Oops. Thurston County Courts. We're going to take a quick peek at what's happening over here in Thurston County.
Mr. Holcomb, have you seen one?
I have not, Your Honor. Plea negotiations have been ongoing over the past 2 days and hours. So I have the state's final position on negotiations, but I don't know if they've been agreed to as of yet. Thank you.
We have confirmed that our cat is also someone else's cat. And it was their cat first. So he comes and visits us often. But they're the owner.
And Ms. Rowe, you're Mr. Pogue's counsel as
friends
well?
With benefits.
I am. And do you have a plea form there?
No, Your Honor, that is going to be an amendment to an infraction.
Okay. Okay.
Yes, that is correct, Your Honor.
Okay. Well,
expecting that he will be joining on Zoom?
He is present.
We're going to be live.
It's weird when I can't see everybody else.
Sorry. We've rented an Airbnb for the time that we're going to be, traveling. And it has fiber internet. We got it just for that reason. I'll take my studio on the road. So I'll be working. My family will be on vacation. Sorry, it's in Zoom. Oh, man. Wrong court. Angela, which court is it? Is it which court number? Because there are several that are live.
Thank you.
This is Zoom right now. Is it like court 1, 2, 3, 4? Thank you, Rebecca.
See what the original charge is.
Melissa, he told us he had asked.
Nope, it's not.
201. Let me see if we can find. So it's not this. It's not this judge. Court 2.
Today, and we will be continuing your matter to a future dates. Let me just make sure.
Let me back up and see what this is.
To strike the trial and reset dates. I believe this case is going to resolve, but we're waiting for her to complete an assessment so we know what we're signing up for. So if we can do that, I can send a waiver over commencing today.
Okay, Mr. McClellan, what's the city's position?
There's no objection to that with a waiver. I think this is the initial trial setting date from the charge in February. So yeah, if we get a waiver, no objection. I do think this case will resolve.
Thank you. So, Mrs. Scarborough, your attorney and the city is also in agreement with your attorney's request to continue. We have currently set trial to begin on May 1st. We will be striking the panel for that, and you don't have to appear for that. Ms. Langley, what will be the commencement date for the new waiver?
Today.
Okay. So we'll accept that, and hearing no objection from city, I'll grant the motion to continue. And then new dates will be reset. Mrs. Scarborough, let's just make sure we have your current address and phone number. My Japs is not open.
Okay, we're going to skip out on this one. This one does not seem spicy. Court 1.
All right, so I've asked you to make a written statement as to what you've done wrong that makes you guilty, and we're going back to October 5th of 2016.
Ooh, homework.
When you were in Thurston County, you're saying that you drove a vehicle in willful or wanton disregard for the safety of persons or property. And I'm taking into consideration that long ago we made a probable cause finding to driving under the influence, but you're pleading guilty to a different crime called reckless driving.
Not double parking.
Is that, do you accept that as what you did wrong that makes you guilty?
Yes.
Okay. Now, has anyone threatened you with harm or made any promises that have caused you to plead guilty?
No.
All right. Well, any other questions of your attorney before you and I continue?
No, ma'am.
All right. Well, how do you plead a reckless driving then?
Guilty.
Okay. Well, I will accept your plea, Ms. Myers, and I'm doing that finding you know what you're doing, that you're doing this voluntarily and intelligently and doing this understanding the consequences of pleading guilty, and your statement there supports your plea. So I'll hear from the lawyers now at sentencing, and I'll turn to you. And then first I'll start with Mr. Thompson from the prosecuting attorney's office. Mr. Thompson.
Thank you, Your Honor. The state would ask the court to accept the plea and sentence her to the agreed upon recommendation. To be clear, I went through and I did not negotiate this, but I did look at her ADR and saw that she does have the 3 other DUIs, it looks like 2018, 2020, and 2021 out of Oregon. This case is likely to make her a risk of a felony at any state in the country based off the number of priors. So, and that's for the next couple of years, minimum. Other states, I'm not aware of a single state that doesn't have 4 priors as, or the 4th one being a felony. So I want to caution her that she can't drink and drive. And the fact that it's on her ADR, and that's the only place that the state currently has, it's going to follow her for sure. So I would caution her that she not drive going forward for probably the next decade.
Don't drive for the next 10 years. She also has
an ignition interlock requirement out of Washington State for at least 6 years, based off the imposition that they've imposed a 1-year and a 5-year. And I don't believe they run consecutive or concurrent. They think they run consecutive. So she does have to have an ignition interlock under Washington's obligations for the next 6 years. And that means that can be fulfilled in other states, even if she's not in Washington State. So if she wants to drive in Georgia, she needs to have an ignition interlock.
Mr. Stillwell?
Thank you, Your Honor. As I mentioned before, part of the agreed recommendation here is based on some of the good work that Ms. Myers did while in custody, understanding her history here. Just to briefly highlight a few, she completed a program that was run by a licensed mental health professional called Mindfulness and Anger Management, which in addition to other things included programs on impacts of drug and alcohol use and how to deal with some of those chemical dependency issues. She got her GED. Coffee Creek sent over her diploma, which I shared. She also completed a program called Women in Recovery. She completed a litany of vocational and higher education programs. So, she was proactive in contacting our office, the office up in King County, to resolve these cases. I worked with her counselor on getting, again, just a mountain of certificates of completion for the good work she's done since being at Coffee Creek. And I've also spoken with her father in Georgia, who's, sort of explained that she's going back home and will have that support system when she's back. And so, taking into consideration the comments made about her history and some of those issues and what she'll have to be cognizant of moving forward, I think she's spent her time in Oregon DOC very well, very constructively, and sounds like she's got a really helpful support system once she's out.
Good. Well, Ms. Myers, anything else you'd like to add?
Just that I am continuing to learn and educate myself to be a better person.
Good. Well, I'm glad that once you do get back home, that you've got the support system there and that you've worked hard and made your time useful while you've been there in custody. I'll go along with this. I think it's sensible. You'll think after you're done with your time for Oregon, you're now done with this reckless driving. I've just accepted your plea. I'm closing this case. And you'll take it from there. So when you get out and move back home, no matter where you are, just be really careful. Your licensing, you won't be allowed to drive yet. You'll have to talk to whatever state you settle in. You may have to recontact Oregon and recontact Washington, and just really work hard to do the best for yourself, which sounds like being sober and living a life that's better for you that way. It'll make the community safer and won't endanger you on the roads. So just hang on to those lessons and move forward in a constructive way, all right? Great. All right. Well, good luck for the next year. You're done with us here. And anything else for your client, Mr. Stillwell?
No, Your Honor. Thank you.
Thanks. All right. Thanks, Ms. Myers. Thanks to whoever's helping you meet with us today.
All right, thank you.
On your way.
Thank you, Ms. Myers, and anyone there at DOC. Thanks for coordinating.
Okay, thank you.
Before I jump to Mr. Buck, at the 10 o'clock calendar, I understand there's just a motion to file. We understand from Mr. Holcomb, so I didn't want to waylay any attorney who might be filling for Ms. Lesh at 10 o'clock. And I didn't know if that was you.
We're going to bail on this one really quickly and jump right over here.
I understand that the state has, its own duties and its own obligations that it has to meet. But
and we're going to back up just
it was just my understanding.
Let's see what's happening here. Let's get rid of this guy. Okay, there we go.
Of $150. And if you want to work that off in community service, I will allow you to do so. And that would be an additional 7 hours of community service. You want to pay that off in community service as well?
Yes, sir.
We're going to let Eric finish up. And
that's now 17 hours of community service. And I'll now give you until the 1st of August to get all that done.
Okay. Who do I turn that into?
Thurston County District Court. What you have to do is you have to either go online and get a copy of our community service form, or you come into the court and get one, and you take it to whatever nonprofit agency where you do the community service, and they fill it out, and then you bring it back to the court so we can make sure you get credit for those hours. If you don't, then you don't get credit and the fines are there.
Okay. Thank you.
Okay. All
so
right.
We're covering the judge, but he's going to move here in just a second.
Bye-bye.
Thanks, bye.
And Ms. Rowe, are you ready to go to trial today on the Thomas matter?
I am, Your Honor.
All right. And Mr. Holcomb, is the state ready to
pool
proceed
media
on the
feed.
Thomas matter?
Yes, Your Honor. My understanding is that both the Thomas matter and the Armin Basic matter are both on for jury trial, and the state's ready on both.
All right. Thank you. And Mr. Smith?
Yes,
Come.
we're ready on basic.
Okay, thank you. So rather than flipping a coin, we actually have a process, and that process is pursuant to our court orders. We go by the filing date, and filing date on the basic matter was December 8th, and the filing date on the Thomas matter was November 20th. So the Thomas matter is the matter that will go. So Ms. Rowe, if you'll step back, we'll have Mr. Smith come up. And is Mr. Basic here? Okay. So Mr. Basic, come on up with Mr. Smith.
Hang on a second.
Last minute words of advice to his clients. Don't screw this up. That's all he says. Don't screw this up.
And Your Honor, for the record, Derek.
So you missed it by this much.
Yeah.
Mr. Smith, good morning.
Your Honor, for the record, Derek Smith for Mr. Basic, who's president court, seated to my right. Can the court tell me when the next slots are for trial?
Yeah, we're running trials every Monday and every Wednesday. And I need to give the state time to, are all your witnesses present, Mr. Holcomb?
They are not, Your Honor. I didn't ask them to come until tomorrow because that's when testimony is heard.
Okay. All right. So do you know availability of the state witnesses?
I don't for the next few weeks. They're all lay witnesses, actually.
Okay. You don't have any law enforcement witnesses?
There was a former Deputy Perrick, but he's no longer law enforcement as far as I'm aware. Okay. At least he doesn't work with Thurston County.
I'll let you know when there's some action out of Arizona. Currently nothing.
Smith, let's see. And are the parties confident that this matter is going to trial, Mr. Holcomb, on behalf of the state or city?
Yes, Your Honor.
Okay, and Mr. Smith, you feel the same way about this matter?
We do, Your Honor.
Okay. All right, so we probably don't need another confirmation date. If I put this out 2 weeks for the state to have time to get their subpoenas back out, I guess maybe.
Your Honor, I would ask for 3.
Okay, so that would be, we could go either on Monday, the 13th of May or Wednesday, the 15th of May. Mr. Smith, does one date look preferable to you?
The 15th would be far better of those dates.
Okay. Then I'll treat the matter as confirmed for trial on the 15th of May at 9 o'clock, right back here. And
we haven't heard. That's with Judge Wolf. I've just not heard. They might have settled out of court.
That date and time, and we'll give you a copy of that.
Thank you. Hopefully the court should have all of our jury instructions and stuff from, we wouldn't need to resubmit them then.
You do not.
Okay.
I had reviewed them over the weekend, so I know we have them.
Thank you, Ron.
Yeah, and I'll get you a copy of that order here shortly.
Franco, I think everyone's going to have something to say about the Karen Reed case. I'm not going to cover it gavel to gavel. I might do just a highlights video or commentary on things that happen. Brandy Churchwell is going to be covering it. Melanie Little, Emily D. Baker, and probably a host of other people.
In Your Honor, Mr. Thompson has a sentencing matter, so I can handle preliminaries.
Okay, thank you. And Mr. Smith, if you want to come up, we'll get you a copy of that order.
I will.
We have jury selection in this one. Oh, we love jury selection here. It's so much fun. We get to see the jury and often hear them as they're getting chosen. If you haven't sat through a Thurston County jury selection video, you are missing out. Yes, we showed a pro se trial. Was that last year already? Might have been last year. And the defendant in that, there's a pro se. We showed a trial here where the defendant actually joined us in chat afterwards. So it's transparency PNW or PNW Transparency, I think was his name. So they'll have an afternoon jury selection in this trial.
Seating chart point. Seating chart.
Yes.
When's Mr. Thompson potentially coming in?
Well, he has to finish the sentencing hearing. I can ask him what it's like over there.
Does your office force witnesses to go forward even if they don't want to?
Yes.
They do.
Yes, if we have to. We really do not like to, but if we have to.
That's my understanding.
Does your office force witnesses to testify if they don't want to? Yes.
Mm-hmm. So,
all right, Mr. Thomas, come on up.
How far? This will be
the seat there at the table.
See if the court, says I'm going to force
you
to. Yeah. So I guess we'll see.
Yeah.
Mr. Thomas is here. No word from Laura yet on any activity in the court. So we believe that the jury is just deliberating without having appeared in court at all this morning. No, Mr. Farag.
And is Mr. Thompson going to be the trial attorney, Mr.
He's
Holcomb?
never been back.
Okay.
Josh, thanks for your work on this one. This one looks interesting. Let's see what happens here as it gets ready to kick off.
And Mr. Holcomb, the state's proceeding on one count of harassment, domestic violence.
Yes, Your Honor.
And the asserted offense date is the 20th of November.
Harassment, domestic violence in 20th of
Verify
November.
the police report really quick.
Leading up to Thanksgiving.
The incident date is 11/20/2023.
Thank you. And Mr. Holcomb, the names of the state witnesses, please.
Yes, Your Honor. The state's witnesses are Travis Andrew Thomas, April May Kerwin.
Okay, let me catch up to you here.
Yeah, they called her April May.
You want me to spell?
Travis Thomas, April Kerwin, Kerwin.
It's always fun.
Kerwin is Kirwin.
Okay.
And Deputy Rhodes.
Deputy Rhodes' first name is?
Benjamin.
Thank you. And Ms. Rowe, for the defense, any additional witnesses?
No, Your Honor, we will not be calling any additional witnesses outside of Mr. Thomas deciding whether he's going to testify or not.
Very good.
Ms. Rowe, we've seen her in court before. She won. She won with PNW transparency.
I will impose the normal time limits in this case, 15 minutes for each counsel on voir dire, 10 on opening, 15 on closing. Is Mr. Holcomb any objection to those time periods?
No objection.
It's a quick
Okay,
case.
and on behalf of Mr. Thompson, you wish to reserve 5 minutes on closing, is that?
Yes, Your Honor.
Okay.
What are the time limits, Your Honor?
15 on voir dire, 10 on opening, 15 on closing.
It's so quick. Can you imagine if they had that in the Arizona trial?
And Ms. Rowe, any objection to those time limits?
No, Your Honor.
Okay, thank you. And I'll let you know when there's 1 minute in any applicable time period left.
Thank you.
And do counsel have any exhibits they wish to pre-admit? Start with the state.
I do not at this time, Your Honor.
Okay, thank you. And Ms. Rowe?
No, Your Honor. Thank you.
Okay. And both council submitted proposed motions in limine, and my memory of those is that both are standard motions in limine, not necessarily case specific. So I'm just reviewing them now to make sure I'm correct in that regard.
I'll just keep that window open there so you can see we are monitoring the court out of Arizona.
And that's the case for the state's motions. Ms. Rowe, any objection to any of the state's motions in limine?
I don't believe I have any objections, Your Honor.
All right. So I will grant those. Looks like Deputy Rhodes is the officer involved in this case, and he will be allowed to sit at council table. Otherwise, witnesses are excluded.
Rule has been invoked. Angelique, 3 months officially, been lurking for 4.
Defense motions
Thanks
in
for all you do.
limine.
Amazing mods. Don't forget to hit the like button. Thank you, Angelique.
The defense motion in limine is to exclude prior bad acts. I don't see any other history for Mr. Thomas. Mr. Holcomb, are you aware of any either prior criminal history or other bad acts that the state intends to attempt to introduce on its case in chief?
I do not believe so, Your Honor. I'll just double check the criminal history in this case, but I don't believe that the state has any intention of submitting. Yeah, the defendant has no criminal history. We won't be submitting any prior bad acts or character evidence.
Okay, thank you. And so does the state have any objection to the defense motion limine?
None, Your Honor.
Okay, that motion is granted. What I will say, Ms. Rowe, is on some of this, and particularly because Mr. Thompson, trial attorney, is not here right now, if something comes up by way of a proposed question, which you believe calls for inappropriate evidence, you'll need to make the objection at the time.
I would just say that.
Okay. All right, then both standard motions in limine are granted. Mr. Holcomb, for the state, anything further?
Nothing further, Your Honor.
All right, Ms. Rowe, for Mr. Thomas, anything further?
Your Honor, this will be something that I have not addressed in front of the court, but I'm just, it likely will be needed to be addressed when Mr. Thompson gets here, probably. I'm not sure how the court deals with uncooperative witnesses.
But I'm not, explain what you mean.
It's my understanding that the state's witnesses did not wish to have this case proceed to trial.
Mm-hmm.
I understand that the state has, its own duties and its own obligations that it has to meet. But it was just my understanding that the state's witnesses did not want to go forward with this case.
Okay. So,
and Your Honor,
I'll get to you in a moment, Mr. Holcomb. So I'm not sure are you asking for some determination by the court in regards to that?
Like I said, I haven't practiced down here long enough to see how the court addresses this type of situation. That's all.
Well, I mean, at first blanch, listening to what you just said, if the state chooses to go forward, state still has the burden of proving its case. I don't think and they're going to have to examine the witnesses and see what the witnesses say under oath, assuming the witnesses appear. I don't think it would be an appropriate either examination or cross-examination to ask what the witness's opinion as to whether the case should go forward. That's not something, the jury's not going to hear that evidence. Their only evidence they're going to hear is anything the witnesses have to say about the event itself. So does that answer your question?
Yes, it does.
Okay.
Thank you.
All right. So if you want to have a conversation with Mr. Thompson and let him know you're going to try to convince him not to go forward on the case because he has some reluctant witnesses, you can do that. We do have a jury coming in at they're actually coming in at noon
action
to
in
be
court.
Instructed, and we'll have them back here. Pardon me, at 2:00.
Let's see what's happening here out of court. Let's see what we got. Let's see if something's happening. Give me a second. No audio yet, but they are moving. Still hung jury. We're there's some talk about a verdict, but it's not in a format that I trust as a result yet. That's all I'm going to say.
I've been just focused on the Arizona thing.
Okay. Yeah, there's nothing confirmed here. Hopefully that audio blurb disappears. I don't know what's causing that, but it needs to stop, because if it happens during the whole thing, it was going to drive me nuts. It's white noise, so it can't be filtered out. Or it's like pink noise. Just checked in with Laura because there's a news website that put up an article with a link to a verdict in this trial. Just talked to Laura, who's sitting outside the courtroom, says nothing that they've heard of. So she's sitting outside with the defendant, basically, in defense. Still really quiet there in the background. Photographer's getting instructions about the judge being really picky about showing the jury. We might have that burst of sound periodically. Okay, I'm gonna turn the audio off. We're gonna go back and watch. We'll watch for any action. Just because Laura's in the courtroom, we have a court watcher watching this, and they're saying there's nothing happening. I don't think we're there yet. So we'll go back to where were we? We were on this one. 2. Here we go.
So if Mr. Thompson's going to make that decision, he needs to make it very quickly. Okay. And Mr. Holcomb, did you have anything else based on that?
The only thing that I would add at this time is that I have just confirmed with DPA Thompson, we expect our witnesses to show. We don't think that a material witness warrant is necessary at this time.
Okay. All right. Then we will adjourn until our jury selection at 2 this afternoon. See everybody right back here at 2:00.
Thank you.
Thank you, Your Honor.
Thank you. We'll go off the
Jury
record in this
selection.
case until
I'm excited for that one.
2 p.m. our time here.
Okay. I think they're done. They are. Let's see who else is live in Thurston. Bodie sounds great. It's awesome to be a court watcher if you've never done it before. Jim Bob, the duration. Normally, when it's like a cell phone signal interruption, it makes a different sound. It's like a da 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 type rhythm to it. Sounds like an officer keying his mic. They might just have a really bad connection somewhere. It's still happening. It's coming in at full, like 0 decibels, which is full volume. George said he believed he was going home today for good. I'm praying for him. We'll keep an eye on that for just a minute. All right, let's check again with let's see, Judge Wolf. We like to watch him. Let's see if he's in today. While we court hop, waiting for a verdict. Judge David Wolf. He is not live today. Well, he hasn't been live for over a week. What happened to Judge Wolf? He's the busiest judge in America, and he hasn't been live for a week. Judge Cedric Simpson. Don't think he's live either. There he is. He just barely started. He hasn't come live yet, but his Zoom is up. We'll keep an eye on that one for just a minute to see if Judge... Oh, there we go. As if on command. Here comes Judge Simpson. Yes, my one of my 2 drills died. I still have my my hammer drill, whatever it's called. Works well, but my drill was gone. Sad day. Warrior, I see you. Thank you for having me on Friday. I had a great time. Check my uploaded videos, and thanks for pushing me to do it. I love it here. Love y'all. I have to say, Warrior, I didn't realize what your name meant until later, and I can't put your comments up very much. We need to get you to have a different name on here. It sort of violates the other standards we hold on the channel. So we might need you to just say Warrior B or something like that. But it was great talking to you, though. Love it. And thanks for the super chat. It was great. It was great to have you on. It looks like Judge Simpson is just getting started here. He's probably already... No, I don't think he's been live yet today. Simpson went live this morning. Was supposed to have 2 bench trials, including Mr. Bond, if you remember him. However, the people were unable to proceed. That happens so much in his court. I'm curious as to why. Tyrone has his own YouTube channel selling merch. Awesome. Is that how he's funding his? Well, he's pro se.
County, Washington State of Michigan is now back in session.
May be seated. Court does call the case of the people state of Michigan. Well, this is in Slater matter in regard to counsel. State your appearance.
Good morning, Your Honor. Tiffany Hughes, P79762.
All right. Ms. Hughes, and just so that we're clear on the record, this was a show cause hearing originally set by the court regarding your failure to appear for Mr. Slater's preliminary examination. I further indicated to you that it was troublesome for the court that this got sat, and that at the time that it was sat, court is aware that you knew that you had taken employment elsewhere, and that Mr. Slater appeared for a preliminary examination, in effect with not, I won't say without counsel, but without counsel that was ready to proceed regarding his statutory right to have that hearing. Further, that ultimately the court was also informed, at least by Mr. Slater, that he had not been communicated with by you except for the initial time, had not been communicated about your impending departure when he then appeared before the court. Since that time, I will also indicate to you that because of this, and I'm only dealing with the Slater matter, but there were other instances during the same time, one being in 15th District Court, and I believe one being downtown before the Circuit Court, where you were counsel of record and did not appear for those proceedings.
Lawyer just didn't show up to
I will
trial.
say also specifically
Several
regarding this proceeding, that on the date and time set for the preliminary examination, that this court, through my office, tried to contact you numerous different ways, and we did not receive a response. The ultimate thing in that is that Mr. Slater's preliminary examination, which I believe was ultimately waived, but he did not have his preliminary examination, and his proceeding was delayed by, I believe, approximately 2 weeks. So the court has issued the show cause to see why the court should not hold you in contempt and issue sanctions.
So, Your Honor, I did inform like the people that assigned me the case, I did inform them and I let them know what case I had outstanding. I was then contacted by the attorney that would be subbing in for me, and I gave him all of the information. I sent it to an email as soon as he contacted me. It was almost like simultaneous. So,
but what day was that?
the day it was, so they contacted me, like the sub attorney, they contacted me on March 8th, and I sent it on March 8th. Substitution attorney was Bernstein.
Yes.
And I sent him all of the discovery, everything that I had on Slater.
And
beforehand, I went to the special counsel office and I just gave them a list of everything that I had outstanding.
But counsel, that your obligations under the court rule are to still appear. I mean, because the preliminary examination said that was on the March 8th. That was a Friday. Preliminary examination was set for that Tuesday for Mr. Slater. And Mr. Slater had not been informed when you were doing all of this.
And then I spoke with his mother and I informed her, and then I gave her the new attorney's information with Mr. Slater's mother.
Why would on February 29th, you have set this for preliminary examination when you knew that you would not be counsel, that you had accepted other employment?
I thought that another counsel would sub in for me in time. Because like I said, I informed special counsel who assigns this, I informed them, so I thought that another
On what day did you inform them?
This was February 22nd, I believe. February 22nd, I believe.
Then why do I not receive a motion to withdraw until March 11th?
I don't know, Your Honor.
Well, you're the one, counsel, you can't just say I don't know, because you're the one responsible to withdraw from the case. Regardless of the fact that the MAC office is the one that gives your name, it is your obligation. It's not their obligation. You would agree with that. I mean, you're the attorney of record.
Understandable.
But if you knew on the 22nd of February that you were going to be withdrawing from cases, I don't, on this matter, I don't get anything until March.
My apologies. I didn't know. Like, they said they did all the motions to withdraw for me, so I thought they would have got it sooner. I did inform them February 22nd, and I thought that substitution counsel would be in before then.
Ms. Hughes, if that's true, then why on February 29th, this would have been a week after, do you appear and set the case for preliminary examination?
Because I thought...
And not inform the court, not inform the defendant, not inform anybody that you won't be counsel of record?
Again, I thought that it would be substitution counsel, so I really thought that it would be a counsel would be substituted in, and that
doesn't even make any sense, Ms. Hughes. If on the 22nd of February, you know, and you say you informed them of that, you appear on the 29th of February, do not do anything to withdraw, do not do anything to place your client in a position where they're not worse off. What you do is you set him for preliminary examination at a time you know you're not going to be counsel. So that doesn't even make any, what you're telling me doesn't make any sense. So why didn't you do something on the 29th?
Okay, I was still trying to get all of my other ones in order, not just this court, but just all of the other courts that I was trying to tie up those, and ball got dropped.
He's going to have to sanction her.
It doesn't make any sense to me, Ms. Hughes. And I want to give you the benefit of the doubt on this, but if you're telling me on the 22nd of February that you knew that you had other employment, that you informed, you're saying at that time, without turning this into a full-blown hearing, but I'll bring them down, that on the 22nd, that you informed the MAC office. You appeared then on Mr. Slater's case on the 29th, set it for a preliminary examination, say nothing to the court, nothing to Mr. Slater or anyone, that you will not be the one handling the preliminary examination. You are still the attorney of record. The 12th comes along, because that's the date it got set for March 12th. You do not appear on March 12th. We sent you various communications during that day. You didn't appear before the court on the 12th and just did nothing. In fact, counsel, you don't know on the 12th that other counsel has been appointed to represent him.
I did know on the 12th. I sent the other counsel the info on the A. So it was my understanding that was his other counsel. If he communicated to me and asked me for the discovery,
you are not released from an obligation until the court releases you. You do know that, don't you?
This is like law school 101.
yes, and I thought that with him calling me and informing me that I was released. My apologies, the ball got dropped.
The ball didn't get dropped. I don't have an order even to sign if I wanted to. But I don't even get an order to me that I eventually signed until, which is your obligation to withdraw, not the MAC office obligation to withdraw. I don't get an order until the 12th, the date of his prelim. And then they have to adjourn the proceeding out. Anything else you want to say?
No.
What's she doing? Her laundry?
And Ms. Hughes, I'm just going to let you know, I don't appreciate also that when my staff reaches out to you, when this court reaches out to you, irrespective of anybody else, we got no response from you. None. We sent emails, we made phone calls.
I didn't get a phone call.
Oh.
We did not get a response.
The judge should call her number right now and see if it rings. He's filling out the paperwork. Sanctions incoming. Page just crashed. YouTube just kicked me out.
Anything else you want to pay? I was trying to find a way where this was not something that I should sanction misuse, but I don't see that. Anything else you want to say?
Nothing further.
I'm going to sanction you to $500. That's to be paid to the court. When can you get that paid to the court?
Need about 2 months.
Pardon?
I'm gonna need about 2 months.
Whoa.
Is that something I can pay online or?
You'll have to ask the clerks up front. That's to be paid by June 21st, 2024. Thank you.
Okay, so the Cameron's playing with the camera down there. Wow. Wow. She's gonna need 2 months to pay the $500 bill. Okay. Why did my computer just lose all connections to the internet? Let's see. Go ahead and pause that, pop that out. See, it's not just you guys. YouTube hates me as well. I will tell you, I think she went that she got let off easy. I think that was a pretty light punishment, especially considering the fact that there were other courts that she did the same thing to. That at the same time she just walked away from all her clients and did not see through the withdrawal process, did not notify properly. She even, after she knew she was leaving, she didn't even tell her client when she met with him, set dates for a future court appearance with the court, didn't say anything to the court, and then just walked away and says, well, I sent this guy the file. I thought he was going to pick it up. And then she has a wee bit of an attitude, just a wee bit of an attitude in front of the judge. Could be $500 per case. I think $500 is pretty light. I mean, when it comes to attorneys, think about billable hours, right? How many hours do you have to work to pay off a $500 fine? 3? 2? 1? I guess it depends on the attorney. But, wow. No contempt there. Didn't find contempt, just sanctioned. But yeah, I would be concerned about having her represent me. Maybe the bar will do something. Never know. Okay. Let's see where we are. Daybell's in break. We're waiting for Arizona to come in. Let me just listen and see if we have any noise on Arizona again. That's not what we want. Let's go here. Listen for that buzz, that chirp. Hopefully it goes away. Pamper Glamper, there it is again. Oh, scared the daylights out of me. What's taking this jury so long? It is taking a long time. Chat isn't on screen. I turned it off because the computer crashed. Sorry. That's terrible. That's terrible. And we're going to have to listen to a verdict through that? That'll be terrible. Pamper Glamper, thank you for the 14 months of support. Wonderful, wonderful to have you here. Box source. Let's bring this in for. There we go. 11 and a half hours of deliberation water under the bridge. Not sure if the jury's going to be able to reach a unanimous decision in this one. 8 members have been deliberating for about a day and a half now, overall. Daybell's in recess until 1 p.m. Mountain Time. Good to know. If you can, or Mandy or Ashley, if you guys can give me just a buzz right when it's about to start. I want to make sure that the live feed starts at the right time. Sometimes it pauses after a long break like that. How many hours do we think after the Allen charge? I think if they come back now, Brybear, if they come back now and say we're hung, this will be the second time they've been, potentially the third time they've informed the judge that they haven't been able to reach unanimous decision. And once they give them that, I think it'll be no more than 30 minutes between that and a hung jury. Marilyn Skoll wouldn't want to do this with anyone else. Thank you, Marilyn. 14 months as well. Awesome. The last time they deliberated through lunch. They deliberated through lunch in Arizona last time. Thank you, Ashley. You're doing a wonderful job over there. Let me update the... it's already updated. You guys are on it. Kelly posted bail. He did. We could go back 40 minutes, Mark, on The Simpson when he was live this morning. I didn't see his live feed from this morning. Let me take a quick peek. No. 3 hours ago. Let's take a quick peek and see what he was doing this morning. Give me a second to get it pulled up. Patricia Cisco, welcome to the gallery. 7 months. Thank you, Patricia. Love the Tweety Bird as well. Big fan of Tweety. The morning witnesses went faster than they expected. That's the reason for the long lunch break in Chad's case. I think perhaps the reason that the jury is taking so long is that they requested the testimony of the medical examiner, but didn't specify which part. Just my opinion. I didn't hear they ever got it read back. They were told, tell us what part you want. And then they're like, okay, we'll get back to you. And then there was nothing else. Courtney Meek says, yeah, she worked in the MAC office. She doesn't have any money. She was a public defender, huh? It's not necessarily the highest paying job out there in lawyer land. Braxton, pass my A+. Thank you for the support. Braxton, you've got the cert. That is awesome. I love that. Knew you would do it, though. You knew this already. It's probably easy for you as well. Glad you passed it. Congratulations. I hope that brings many wonderful returns to you. I'm looking at the live stream from 3 hours ago, and there's like nothing. Oh. There's just a couple minutes right at the end from their last live stream for Judge Cedric Simpson. We'll watch that. Because why not? This was from this morning in Judge Cedric Simpson's court. Lucas says, thanks for always streaming good footage and thanks for the great community. Love all you people. Happy to be here 7 months as well now. That's great. Judge is getting all his devices set out. Thank you. Thank you, Luca. Wouldn't be the same here without you. Do we have other spicy things with the judge we just watched? Oh, this judge can get spicy. Judge Simpson can really light a fire under you. You don't want to get on his bad side. Because he can give you a verbal dressing down that you will not forget. Does Judge Simpson's pro se guy have a hearing this week? Let me check. Let's see. See where are we at? We're on April 22nd. I'm not seeing where that guy is. Do we miss him? That was John Torres, right?
You may be seated.
Braybear, thank you for gifting the 5 memberships.
I would have been out earlier, but it took Emily forever to say that you guys were ready. All right.
Throws Emily under the bus because he's late.
Yes, ma'am.
Crystal Ray, love being here. You're a great RA. Thanks for all you do. Thank you,
morning,
Crystal.
Mr. Russell.
Thanks for the kind words. Appreciate you as well.
Court does call the case of People versus Christopher Bond.
Morgan Burroughs on behalf of the people.
Your Honor, good morning. Joe Simon on behalf of Mr. Bond. Mr. Bond, state your name, please. Christopher Bond?
It's the date and time set for a bench trial this morning. We have made all necessary attempts to ensure that our vital witnesses and victim are present. However, they are not in attendance and we are unable to proceed.
Move to dismiss, Your Honor.
I don't know if I like Simon that much, but but I will. People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor. Now request that Ms. Burroughs, when you prepare the order, should check the box on bio data. Thank you.
What?
Just never mind. I was.
Never mind my conversation in your courtroom. But
Peter says thank you and that he enjoys watching you on YouTube.
Well, thank you, Mr. Simon.
AZDCS oversight. Thank you. We don't have any
Thank you,
updates
Emily.
currently from the courtroom in Arizona. There are some other
Court does call the
cases
case, People versus
in that
George
same
White.
courtroom this morning, they say.
Prosecuting attorney Morgan Burroughs on behalf of the people.
Right here on Stephen Barker, P3603, on behalf of Mr. White, who approaches to my right.
Okay.
Your Honor, the date and time set for this trial. At this time, the people have made all necessary attempts in order to ensure that our vital witnesses and victim are present. However, they are not in attendance and we are unable to proceed.
Move to dismiss, Your Honor.
For you, yes. People being unable to proceed, this case is dismissed. That's without prejudice.
Brilliant argument.
Yes.
And as far as the YouTube, who's she?
What?
Now, as far as you being on YouTube, now who is Judge Judy?
Thank you. Thanks, sir. Take care.
August, I'll be
Oh,
in Idaho,
really?
Utah in August.
I have nothing to do.
That's all he had. That was it. It was just 2 dismisses. That's what we were talking about in Judge Simpson's court. I see that more than anywhere else, and maybe it just works out that way. But it seems like so many times it comes to the day of trial, and the people aren't able to get either the witnesses or the victim there, and they have to dismiss the charges. And it's done without prejudice. When they say without prejudice, that means they can refile those same charges. It doesn't mean this guy's whoever the accused is scot-free and gets, not go on about his life without worrying about any of their future ramifications. They could, the next, in 5 minutes later, refile those charges against him and then have to go through that same process for court again. But why are they, when there are so many cases that end that way, it makes me curious to say, are they overcharging and hoping they get a plea? Hoping he takes a plea? And then every time they say, no, we're going to fight it in court, they're like, well, we can't get a conviction, so we're just going to drop it the day of. Is that the norm up there? If somebody understands that a little better than I do, I'd love to know. Nothing from the jury yet. D-Nick. I love how you're like, Judge Simpson can really give it to you, and then it's 2 clips of him being a golden retriever, basically. He can be the funniest and nicest judge, but man, don't tick him off. I'm surprised he went so light on the attorney that just didn't show up for court without being released. Carolina, they don't require you to appear for a dismissal. Happens a lot with domestic violence cases where the victim doesn't want to go forward. So, Donna, I understand that, and it's sad because in a lot of those cases, it doesn't mean that the accused was not guilty of the crime or didn't commit the crime. It means that the state can't prove it because the witness, for one reason or another, won't participate in the prosecution. And oftentimes this sadly results in that victim being victimized again. It's very sad. It's terrible. But my question is the state doing this hoping that they just get them to take a plea deal and they get an easy conviction, or why don't they drop it sooner if they know they don't have cooperation? All right. No word from Laura. Well, I've talked to her, but there's nothing happening in court yet. AZDCS, nothing happening in court yet. Sometimes the victim says they'll be there and they just don't show up. Yeah, this seems like it happens more. Ooh, look at this. I have lunch. Lunch brought in with, I have to show you this. This is from Lynn in South Carolina. Heinz pickle ketchup. And yes, that's how much I ate since I got it on Saturday. It is so good. Oh my goodness. It's like having pickles in your ketchup, but no crunch. All the taste, none of the crunch. So I've got some, looks like, did he make these? Yes, my daughter made me some fish sticks and some French fries because she's aware that I'm on a diet. So just the healthy food, right? No. You guys can't do that. You have to try it. If you like pickles and you like ketchup, you have to try it because they nailed it. The flavor is there. It's so good. Let's see. Bodhi says, more needs to be done to make innocent accused people whole again. If they just go on to the next thing and leave us swimming in their wake. It's frustrating. Look at, say for instance, let's look at Mr. Kelly. If he is found not guilty by this jury, he gets to walk out of court a free man, vindicated, his name cleared, but all the press that's out there is still out there. All the stories, all the stress, the years of his life, and what, $250,000 went to his defense, and he just walks away. And that's it. Karen, I didn't know it was a thing. It's actually pretty good. This is not ketchup relish, or ketchish. I think that's what it is. Or relchup. I think it's not relchup or ketchish. This is ketchup with pickle flavor. Neighbors don't see him the same. Let's see. I doubt they'll bring a civil case. I don't see a civil case happening in this one. EDB has a whole rant about government overreach. She despises when the state government overcharges and abuses their power. Roman Adiasisi. I don't know how to say your name, Roman. Pronounced, if I read this, it will actually tell me in the message. Pronounced Roman ADCC. If you love pickle ketchup, try Trader Joe's pickle mustard. It's amazing. Thank you, Roman. And thanks for the pronunciation guide. Roman ADCC. ADCC. There we go. What if he'd sell the ranch and move somewhere else? I think Martha, if he gets a hung jury, he might have to sell his ranch. He literally could lose his ranch, his property, basically everything he's worked for, in his own defense. No words of any new questions today, Digital String Theory. It's been quiet. HP brown sauce? Sounds intriguing. Is it like steak sauce? Not everything that's flavored like pickles is good. The jelly beans were not, just for the record. They were not delicious. The pickled jelly beans were not delicious. We gave them to our friends who came and visited because they had a daughter who thought they were good. But the parents were not fond of that. Boston Bruins says, what's the meaning of Recovery Addict meaning? The naming. I chose this name when I built this channel initially for the purpose of sharing my metal detecting recovery videos. I was addicted to recovering artifacts from the ground as a metal detectorist, and I still am. Love it. Did find out pretty quickly that not many people were also interested in watching me metal detect. I guess digging in the dirt is not that fascinating for some people, but so I had this channel and I just live streamed on it when I started live streaming. But when it actually comes to recovery and addiction, I do have a story on that as well. I was addicted to electronic gaming, computer gaming, nearly lost everything because of it. And so here we do celebrate those that are on their path to addiction recovery, wherever they may be, whether it's their first day or 20 years. So we call ourselves addicts here, and we're addicted to true crime. That's what I'm not trying to recover from, but that sort of sums it up in a nutshell. What's the coolest thing I found? $5 gold coin was pretty fun. That was up there, but I've firearms. I like to find stuff where I like makes a difference. Like I like to find those unspent ammunition rounds that you always find in children's playgrounds in your city parks. I kid you not. Almost every time I'm at a playground, I find ammunition, spent and unspent. Of course, I've also found like bongs and pipes and needles. That's scary. But favorite. It has to be the gold coin, $5 gold coin. 18 years sober, says Love Heals. That is awesome. Thank you for sharing. Congratulations and keep it up. HP sauce is slightly spiced brown sauce. We have it mainly on bacon. On a bacon sarnie? Intervenor greeners, I see. See what you've done there. That's just wrong. All right, still no movement from court. We've got till 2 o'clock this afternoon before, so I guess that's 3 hours before we have the jury selection in Thurston, Washington court. Tara says, I'm new here. RA, do you have a background in law as a career? I have a background actually in media. That's where I started. I got a degree in communications, electronic media, worked for television. I've filmed law enforcement. I've done a lot of close work with law enforcement, both with drones, with metal detectors, with video, with cameras, and just always been interested in the law since probably when I was in junior high was when I started studying the law and reading up on different things. I've been on a couple different sides. I've been in the interrogation room for hours on end with police officers yelling at me, asking questions, and me without a lawyer talking like crazy. I've been there. That involves finding a bomb, and apparently the police think that's a big deal. And they thought it was unlikely enough that they thought I had done it, and that was not true. But they tried to get me to confess to something I hadn't done, and I held out for 3 hours, and finally they believed me, and then arrested the people who were actually guilty of it. Let's see. Need more details. Lot happened there. That was a lot one. I started being interested in rules and the law, and Nichols, you found a bomb. I did. I found it when it was, if we do the timeline and go back through when the people who created it were trying to set it off, I was standing next to it when they were trying to set it off. And the only thing that saved me from dying and it from going off was the fact that they had not calculated on the resistance of about a quarter mile long of electrical wire. And so they didn't have enough current to set off the charge to set it off. But what type of diet are you on? A good one, I can tell you that. But we'll tell that story sometime. Hey, Mrs. R.A., do you want to talk while I can eat? That would be awesome. Mrs. R.A.'s here. You have to put on headphones, though.
I don't actually have anything to say. I just come in here because I thought he looks hungry, and also if I'm not in here, I have to be organizing all of our food storage and preparing a presentation that I'm giving on Saturday on how to find your talents. And I was like, no, I'm just going to go talk to people. That sounds so much easier. Except I don't have anything to talk about. Scott, give me a subject.
Well, we're in verdict watch. We've had about almost 12 hours of deliberation in this trial. The jury twice now, to my knowledge, has given some form of indication to the judge that they cannot unanimously reach a decision.
Twice?
Twice.
So did he give him the Allen charge?
No, he gave them the summation of the Allen charge, but in a non-formal way. So he still has the Allen charge available to him.
Okay. So then was that the first time he gave him that one?
No, the first time they passed him a note saying, here's our score on a voting.
Nice.
And we can't agree.
Nice. Excuse me. I'm not sure if what way this means that the jury is leaning. Homeschool Ground Zero. What is your favorite subject to teach? History. I love history. In fact, what I was doing just a second ago, I'm planning our trip going to Utah, and for our summer, what we do is, okay, guys, we're now switching from Scott's topics to mine. For our summer activity, oh no, they're giving me buffer, saying please stop talking about your subjects. No, they're not. Actually, yeah, they are. Everybody clothes are in the dryer. It's Monday. We do a lot of laundry. Anyway, so we do a little program where we say make it Monday, ticket Tuesday, wet Wednesday, thinking Thursday, and field trip Friday. And so that sort of organizes how we do our whole week, making sure that we have enough focus on, what?
See, all I do is I do hump day and no pants Friday. I guess podcast Thursday, so I just have 3 things.
Slacker. So I'm looking at all of the things in where we will be staying in Utah, what we could be doing for those things. And it's just fun. Just usually I like to leave the house once a week, and every other day I like to stay at home and sort of spend the time in books. But in the summer, I'm much more willing to get up and go because I just feel I have less obligation. So lots of activities, lots of things that we're going to, like Dinosaur Park, and there's lots of museums, lots of art museums that I want to get to. But anyway, history. I do love history. There's a lot of history here where we live. There's a lot of history in Utah. And so in organizing our summer activities, it's a lot of times around historical locations and activities. I'm going to film my presentation. I actually already filmed this idea of how we organize our summers, and I did it last summer, and I'm just sitting on it. I have not yet edited it. Okay, that's a hard word.
It has like 7 D's in it. Edited it.
Whatever. I haven't gotten it ready to print, and so maybe I'll use that, or maybe I'll create a new one, because when I made that one, I didn't know that we were going to Utah, and so I created everything for North Carolina, and now I'm sort of shifting a third of our summer is going to be spent in another place, so gonna be fun. Can you tell us more about that famous lawyer, Cicero? Adam, stop abusing me. Dinosaur Park is 3 blocks from me. Nice, Brian, unless you mean Vernal. No, I haven't been to the one in Vernal, but we have been to the one in Ogden several times, and the kids really enjoy that. Mrs. Grade, I'm sorry, I can read. Mrs. R.A., what grade to stop homeschooling? What grade to stop? Kind of I never stop. Officially.
High school, when they graduate high school.
When they're done, so it's usually 16 or 17 years old. It's not very hard to get all of the requirements to be able to fulfill, say here we've done all of the things we're supposed to for high school, and then they can move on to college at that point. Usually my kids will do college for a couple of years at home so that they can get used to the academic part of it before they move on to also living with other people and managing their own finances and everything. So we sort of do it in a 1-2 punch on that. And it's way cheaper to do college when they're still high school age, so that's a benefit. So I don't know. We've got one who's going to be that old this coming year, but he's not excited to start college yet, and I'm not going to push it, so I don't know.
Can you see the comments on the bottom?
Not really. Your stuff's in the way.
That's
okay.
my piling system.
Your sorting system. Mrs. Ari, do you teach only the U.S. history, or do you include European history? All world history, actually. I love Australian history. I love Chinese history. I love African history. I love lots and lots of history. I use the Well-Educated Heart system, where I will have most of my resources will come from there to be able to get some stories and some backgrounds and activities around that. Mrs. Ari, you should have gone over how to propose better in school. Okay, there does seem to be a distinct deficit of this skill. Like, why? He knows the time. They know the time. They've chosen out their colors. They've chosen, they've given all of us assignments. You're the ring man. You're the flower girl. You're all these things. And they haven't, it's not official yet. I'm like, guys, oh my gosh. Oh, I'm sorry. I am talking fast. Sorry.
She only has one speed.
I know. This is the speed I speak at. Sorry.
I listen slowly, so sometimes I have to go back and...
There's a lot. Yeah, so on Saturday, Scott and I are driving, and it was like, we were in the car together for about 3 hours, and I was reading him something, and he was like, stop reading to me. I can't do it. I was like, okay. And so then we hit the audio book version. He was like, oh my gosh, I love listening to books. Because he didn't like how fast I was reading it. He was like, it's so fast the way that you read. I just can't focus that hard. And I just struggled when we were listening to the audiobook. I was like, oh my gosh, I have like a chapter's worth of thoughts between every word they say. It's so slow. So we're just different. It's fine. It's cool. How do I enroll in Mrs. Ari's class? I want to retire from adulting. Oh my gosh, me too. I can't see those words. Sounds way more fun. Yeah, I choose to do the fun version of most learning. For me, learning is fun, but also we do learn in fun ways. So I don't want to be miserable for the rest of my life. I want to have fun. So we do a lot of fun learning. I listened to Mrs. R.A. video on her channel once at 2 times speed. And it was wild. Yeah, sometimes I can't listen to myself 2 times speed. It gets a little fast.
Okay, so you guys have to realize, when she is just consuming YouTube videos, in-depth, deep thought, advanced book study type videos, she'll start the video, she'll turn it up to 2 times speed. She chooses 2 times speed because that's the fastest YouTube will let you play it. She'll shrink it down into the corner, and then she'll open something else that she also is watching and following, so she can do both. And then she probably has a book next to her that she's flipping through and perusing during the down times while her brain is not busy, consuming all that information.
I don't think I consume super fast, but I think a lot of people speak really slowly, and yeah. I wanted to see how fast it was. It was so funny. Yeah, I talk fast when I'm about 2 times speed. Current book that you're reading. Okay, I am reading Israel, A History by Martin Gilbert, and oh my gosh, I need all of the list. I'm reading a couple of nonfiction books, and there's a spy book that I'm reading, like Spies Without a Country or something like that, and that's the Israel spy story, the beginning of Mossad. And I'm doing 4 Loves by C.S. Lewis and some Aristotle and Oh, what's that guy's name? Oh,
Notice she's not saying and then. No, she's saying and because she does all these at the same time.
Well, because I can only focus on it for a minute, and then I'm like, I need something else. Like Aristotle, he's a lot. But do you know, I know all of you are just, wow, please help me out here. But seriously, what is that guy's name? He's this Christian guy, and he's, I can't remember his name. Anyway, Thomas Aquinas, there it is.
I only read court filings. I don't read books anymore.
I can't read that. That hurts my brain. So Thomas Aquinas has this whole big stuff, and he's giving all his philosophy on Christianity and on just philosophy in general. And he's referring to Aristotle all the time, that he's like, well, the great philosopher said this, and this is his take on what brings us joy, that it's virtue as opposed to what Socrates thought. And I was like, I had no idea that Thomas Aquinas was just kind of reacting to what Aristotle said. So I'm grateful that I chose to study Aristotle as well, or I'd be like, who's the great philosopher? I have no idea. Anyway, sorry, I know that's really boring for a lot of people, but that's what I'm doing.
She has a lot of fun. She has her own channel on YouTube.
I know. You don't have to listen to me here.
Where she talks slower.
I do. I actually really focus, not only on talking slower, I really focus on being almost no personality on that channel, that I feel like I don't want my personality to get in the way of people trying to understand what I'm saying. So I try to be a little bland on that one. Mrs. R.A., was there any meaning to the name Homeschool Ground Zero? Yeah. What does it say? How did the name come about? Okay, so when we were first deciding to name that, I wanted something that was a little flippant, that showed that it could be kind of a double entendre, that it could be the ground zero, the very bottom, the basic, you're just getting started, and at the same time, it looks like a bomb went off here, right? This is ground zero for that science experiment, and so I wanted to have that, both the fun and the reality of we're starting at the bottom and building up. So Scott came up with it, actually. I'm still talking fast. Sorry. You know what, though? I remember one time this door-to-door salesman came to the house, and they knocked on the door, and they're from New York, and they were talking, and she was just this sweet girl, and she just talked so fast, and I looked at her, and I was like, you make me feel dumb. Like, stop talking so fast. But then she was so sweet. She sat down with me and we talked about her stuff, and it only took me like 2 seconds to look at the stuff. I was like, nope, that's not for me. I'm not interested. I'm not going to buy that. But then we spent the rest of the day just talking and discussing. We made cookies together. It was just
Can you not? She invited a door-to-door salesman into our house, made cookies.
Yeah. Well, she was hungry.
Just hung out.
And we discussed stuff. We talked about Anna Karenina and socialism. It was because she was coming from a socialist country, so it was interesting how she felt about capitalism, and so we just had an interesting discussion and made cookies, and I bought nothing from her, but she talked fast. Wait, no, so she was, I don't know where she was from. She was from a socialist country. There was another one who was from New York who spoke really fast. I don't remember. I know, I don't drink Mountain Dew. This is me on water.
Yes, I had a Mountain Dew this morning, but I only have one more left.
Why are you looking at me like that?
Because you're the one that goes to the store. Thank you.
Oh, that's funny. You would fit well in Northern Ireland. We talk really fast. I know. Well, you guys sound amazing, though. I know. No coffee either. This is just me.
It's just high speed. All go, 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 go.
Not all the time. I hit about noon, and I'm like, all right, I'm done. He does talk fast. Peter Lawyer, he talks fast. I really like him on 2 times speed. I love that he speeds up his videos.
Did you hear that? Look, Peter talks fast. I really like him on 2 times speed.
Yeah, because he speeds up his videos. So I'm like, now we're cooking. Now we're getting going here. How old are all of your children? I don't know. Don't quiz me. I don't know.
Yep.
I'm about to be on Dateline. Oh, don't say that. She was a sweet girl. It was a really fascinating conversation. And, she was doing her sales pitch. And then after a while, she's like, I like you because you're real, because you're nice. And then we were just chatting with each other. And it was interesting. Have I ever considered auctioneering? Every morning. How many kids do I have downstairs for breakfast? I've got 2 kids. Gonna have 3 kids. Gonna get all 3 kids in this room at the same time.
Who'll give me 4? Yeah.
Yes.
All right. We need to do something on your channel. It's been a while. We have to do a live.
No, but
do you have a topic that you're gonna invite me on to?
I've already told you. I'm
I
gonna
remember now.
succeed or fail on my own.
You have headphones on too? Can you hear this? Yeah.
You'd fit well in her cult. Thank you. What do I sound like at 0.5? I don't know. Boring. You speed movies? I do too. But do you know what? I find that movies are actually much faster. People speak faster when they have a script and when they know what they're anticipating. So they actually speak a lot slower when they're having a conversation. So I don't. Plus, there's a lot of body language to watch. This is probably boring for everybody. What do you guys want to talk about?
Well, we just passed the 12-hour mark. Thank you, Jessica, for the update on this, on the deliberations. So that is officially a day and a half of work time, but it's been stretched over a 3-day period. And so far, I don't have anything from Laura. We got something from Steve, which is really cool. Nothing yet from Laura. She is there in the courtroom. She's waiting. They're waiting outside the courtroom, but there's nothing yet. So we're gonna. I mean, when there's something, we'll bring it to you. I wonder if the jury has an expectation in their mind. They said the judge said we didn't do this long enough. We didn't try long enough, right? We're too quick to come back with the mistrial, basically, with the hung jury. I wonder if there's a date in their mind. They're like, I guess we have to be here for a week. And they're just like sitting there,
checkers.
Glaring at each other. It was like, well, if you would just change your mind, we could get out of here. But
yeah, well, and I think that is one of the reasons why they're not allowed to force the issue, because there does come a point where it's like there's not actually any progress being made.
Yeah. Now they're napping. Slight snoring coming out of the jury deliberation room. Yeah, we did a little court hopping this morning, looking around. I don't know. There's my remote. Looking around a couple courtrooms. We have one in Thurston, Washington. We're going to be returning to in just a bit. Well, actually, it's 2:00. Hey Siri, what time is it in Thurston, Washington?
It's 11:10 in Thurston County, Washington.
So we have 2 more hours or 3 more hours until the jury selection in that case. That's obviously it's West Coast, so that one goes pretty late. So we'll have something to watch there. It might be a very, very quick trial, like all done in the same day.
Lizzie, when your parents say you're not allowed to leave the room until you own up to something, I know you'll make the right decision.
One of you did this. Yeah. Watch the video about how animals experience life at different speeds. Dogs here are slowed down. Cats sped up a bit. Other animals different. Very cool. Flies. To flies, I move very slowly.
Yes.
Because I always miss. Except now we have the bug assault.
Not only that, but in North Carolina, they say that everything, it moves at a slower pace in North Carolina. They're not kidding. I can almost Mr. Miyagi these things. It's like, you are so slow, fly. In Utah, they zip around like they're all hyperactive. They'll hit you.
I have the hiccups now. Puget Sound, Washington here, says CBD. So that would be right in time with you. You wouldn't mind a late day. Wendy says, I was about 20 feet away doing laundry, and you said, hey, Siri, and my watch activated Siri. Sorry. Let's see. I would have studied a little harder if Mrs. Ari had been my teacher. I mostly got in fights with my teachers. Not like physical fights, but just like battle of wills.
But do you know, Scott, do you remember your favorite teacher? Do you know what subject that was? Criminal justice. Do you remember that?
Oh, he was really good. He was actually a judge.
I think it's because this subject appeals to you.
The first class I ever took in college was a criminal justice class. And the judge basically said, this is a lecture class. I'm going to lecture through the entire semester. And you are going to take notes through the entire semester. And at the end of the semester, there will be one assignment. It will be a writing assignment, and you're going to write down everything you learned in class. And I wrote down nearly verbatim everything he said.
Scott thought it was a note-taking class.
I had, I don't know how many, just pages and pages and pages of notes. And then it was time to write. And I missed one day. I missed one day in that class. In that day, they discussed the assignment, okay, about what this end assignment was going to be. This is my first time in college, okay? I had not gone straight to college after high school. I took a break, And I had no idea what the expectation. I didn't know that a 101 class meant that it was usually pretty easy on the assignment level. Here I am. I'm like, this is college. This is the real deal. I'm thinking I've got to treat this like my master's thesis. And I bust out my notes and I create a narrative, rewriting this all in my own words, starting from like Hammurabi's code all the way up through current, Supreme Court rulings. And I wrote a 62-page.
It was so long. I think we had to go get ink to like halfway through the
62-page
printing.
paper. Thinking, I need to pass this class. I need to pass this class. Everybody else wrote 3 to 4 pages. 3 to 4. My intro was longer than that. I got an A. And somehow, yeah.
That's funny because I went to college and I had a teacher who was like, it was a religion class, and he said, I want you to summarize the book of Mark. I was like, summarize the book of Mark? It's one of the Gospels. I was like, oh my gosh. So I turned in this huge paper summarizing it, and he wrote back, he's like, too long.
Summarize, underline 3 times. Warrior says, can you recommend a metal detector for a beginner who is poor? I can. Warrior, let me tell you this. I can recommend a metal detector, but if you get the cheapest ones out there, and there are some very cheap ones, I'm talking like $50 or less, you'll be very frustrated. And I think that's not fair for 2 things. It's not fair to you and it's not fair to the hobby, because this is really a fun hobby. And most people, if they're willing to say, hey, I want to get a metal detector, they probably have enough interest that they deserve to have a good experience with it. That being said, I would try to get a used model of something a little bit more expensive than buy a cheap model just to get your hands dirty, because the cheap models, they can't discriminate. And discrimination is a bad word in everything except metal detecting. Metal detecting, that means your detector is telling the difference between what is in the ground, because you think, oh, I just want to see everything that's there. No, you don't. It's nails. It's nails. There are a billion nails in your yard. It doesn't matter where you are. New property on the Wild West frontier, it doesn't matter. There are a billion nails, bullets, and bits of lead in your yard that have zero interest or value to you. So unless you're actually looking for those, you need a detector that has a tiny bit of discrimination or the ability to change some settings. I recommend about the $250 range. If you can find one in that price range from Garrett, they're really good. Garrett's a great brand. The Nocta Macro, it's a newer brand, an import, but has a lot of cool features that you find usually in higher value metal detectors. Pawn shops, if you go to a pawn shop, the benefit is you get to test it before you buy it, right? But just realize that a metal detector is very sensitive to large metal objects around. So if you're on like the tool aisle with a metal detector, it's going to just be singing like a symphony, because there's 3 feet away, there's a toolbox, and then there's, everything else on the shelves. So anyway, if you really want a recommendation, I can send you a couple. But I do like the Nocta Macro because it's waterproof. It has a light built in. It can do a vibration mode where it just buzzes instead of beeps. That works for people who are hard of hearing. It has several different modes. I said waterproof already. It's rechargeable. It's just a pretty good system, and it's about $250 for that one. But that's about the cheapest I'd recommend. Nocta, Nokta Macro. I can send you a link if you want one. Your grandfather's metal detector is probably amazing in its day. The technology, Tracy, has come 1,000 miles since then. And I mean, now with my metal detector, I can literally tell you what's in the ground before I dig it up. I know where it is, I know how deep it is, and I know what denomination of coin it is before I dig it up. The technology is so good. And that's using my
I don't know. We have like 30.
Equinox.
Oh.
Equinox 800 is what I use. I can't remember the brand name for the life of me. I love it. It's my favorite detector, and it's gone. But old timers is setting in.
So just so you know, when we go to the beach, which is not far from us, going to the beach, when we lived in the West would be like a huge deal. But for here, it's just super close and very convenient. So we go pretty often. And when we go to the beach, we set up our shaboomi, we get everything out, I've got my books, and then Scott disappears for hours. Metal detecting, like he will literally walk miles away, but he always comes back long enough to get in the water with the kids for a little while, and then we go home. So that's the metal detecting that he mostly does around here.
I love metal detecting. I love my kids, but don't make me choose between the two. Lizzie Dog says, flies experience life super slowed down. Trick to catch them is to move slowly because they will see slow-moving hand as if we watch grass grow or paint dry. Liz, let's see. I sent Jessica, I saw a picture of you as an MP. Thank you very much. It's on the burner phone. I appreciate that. I just got that a minute ago. And I can tell what coin a kid swallowed. We did that, John.
Yeah.
We did. Hopefully we're past that phase with our youngest being, 8.
Our 10-year-old had something in their mouth today. I was like, what are you doing? Get that out of your mouth.
Is it food? No. Is it a toothbrush? Then why is it in your mouth? We've had this conversation a million times. All right. Bridget says, are you saying on those gold prospecting shows when they use a metal detector and they think they've found gold, but it's a nail, they're tricking us and they already know it's not gold? Bridget, yes. I'm saying yes, they are. If you're watching a metal detecting show, unless they're on a gold field where they're really pulling out nuggets left, right, and center, gold is very different as a metal. It reacts very differently to metal detectors than, say, iron. So if you're pulling up iron and thinking it's a gold nugget, either you don't know how to use your detector or you're lying. It's one of the two. Or you have a bad detector. I mean, you can have that.
Which do you think it is?
Lying. I think they're lying. I say that because I've sort of been involved with a couple people who have been literally
lying.
No, literally working, doing a show about finding gold in,
Yeah, you probably don't want to give away
I can't say much more than that, but I can tell you that the production team that was pushing them, the gentleman's a friend of mine. He's great. He quit. My friend quit because the production team wanted them to do things that would make the story better for TV, but not authentic at all. And they left. Have you met Aqua Sugar? Yes, I've been metal detecting with him and actually filmed for him as well.
And they really, really do get that dirty. Yes. They walked in my house looking that dirty. I was like, oh, welcome to my house.
Bo was a great guy. Love Bo. He's unique. Bo's unique. I mean, he is, first of all, he's a great YouTuber. He goes by Aqua Sugar. But he is one person who is just happy as a lark to be completely on his own in the most desolate of place. I mean, he'll go out in the Mojave Desert on his own, just on his truck. It's like, hey, I'll be back in a month. And he's cool with that. He takes risks that I will not. I've seen him crawl into collapsing mines head first that we're literally lowering him down into because he can't. I mean, it's just a vertical drop. And he's like, yeah, let's see what's down there. And he's a different breed of person, but he's a really nice guy, really, really nice, and he has a lot of experience, a lot of fun. Really, he loves history, really loves history.
Yeah. Yeah, they were both, and the other guy that he was working with found a whole bunch of cannonballs, some of which still were live. I was like, where did you find these? Oh, you found them around here? That's fun.
Yeah, we went. I went on an overnighter with them, with Bo and some friends. I went as the cameraman, and I had a detector as well, but we're filming. We're on an old gold claim, and in a corner of North Carolina we can't disclose, but I'm filming this, and the four-wheelers, it was so rugged, and I'm trying to film a shot, so I'm sitting on the back of the four-wheeler as we're just driving downhill through trees and over logs and stuff, and I'm trying to get a shot of Bo right in the four-wheeler behind me, and it was crazy. We got some good shots there, but all right. My favorite thing is, do you see it? Do you see it? That's Bo. All right. Where are we at? We're at 12 hours and 19 minutes. We've sort of been sidetracking.
I know, sorry.
Thanks for letting me eat my lunch, though. Thanks for joining us here. Becky says, so do the court watchers see anyone moving about anything going on? Not yet. Laura,
Becky's like, may I just subtly remind you that the channel you are on is a law channel.
Laura is our court watcher. She's there in Arizona right now. She's been there through the entire trial. She's actually got to know the Kellys fairly well, and is with them, waiting in the hall for action, which we have a little bit of right now. Let's see if we can.
He didn't even leave for lunch, guys. This is impressive.
Okay, we have some adjustments. We're going to have some loud clips of audio, and I apologize. I'm sorry. Just know what's going to happen here. It's got a limit on it, but it's going to be like full volume, just static periodically, unless they fixed it. I don't see anyone in court, so maybe the cameraman's just playing around or getting some B-roll.
Or messing with us.
Oh, there we go. Who's that? Is that bailiff boy over there?
Nope, that was my arm on right here. Scott, you're seeing my reflection.
4 hours, 46 minutes is where we're at. Thank you for that. Boiliff is in the room. Boiliff should be outside the deliberation room, not reading the jury's notes.
Okay, but let's be honest. What's so bad about him reading the jury's notes?
Well, in one case, he read a note that the judge, and then told the judge what it said on it, and the judge has not read it. That just seems weird to me.
Yeah, it's probably against the rules, but I mean, the judge could just look at the note, right?
I don't know. The judge has told him he's supposed to read them, so we'll see. All right, no action there yet, so we'll keep watching with the small window. Hey, little RA, you all right? No? You dislocated your foot? But now you're walking on it? Well, that's why you have 2 feet.
You could hop like your
You use the other good one while the first one's getting better.
Sorry you got hurt. That's so fun.
All right. Let's go back here.
Oh, there was somebody who just walked on there.
Just
and
barely.
is taking out the garbage, I think.
It's our court recorder coming in to grab something. Okay. So she's there. She's still skipping her family vacation. Her family went to like Bahamas, and she stayed here to record. If this is a mistrial, what a waste.
I kind of think it's a
all
waste
gets
anyway.
thrown away, and they have to start again.
Yeah. Yeah, the cameraman is laughing at us. He's probably watching us right now. Look what I can make him do.
She's stealing the garbage.
The camera is watching.
Okay, we have... Who is poking their hand up on the left?
Okay, that was me. I'm sorry. It's if I go like this, then like it creates shadows and stuff, and then that looked just where it is on the screen. It just looks like it was the bailiff.
Can't drag her into the camera.
She's throwing away a note from the jury. She comes in, lights it on fire.
Windy Horse says, hung jury equals mistrial? Yes. Mistrial is what they call it when they are not able to proceed and reach a verdict, whether that's through something that happens during court with information that happens or things that are presented to the jury that make it no longer possible for them to reach a fair verdict, or if the jury themselves is not able to do their job, which is their one job, is to reach a verdict. But if they are unable to reach a verdict, the judge will thank them for their time anyway, even though they failed, literally, in the eyes of the court. They failed to reach a verdict, and then the court is then, and the state has the option to try again with a new jury.
I have a question. Did the court ever make a ruling on asking for that video coverage from the state? She wanted all the video.
We were waiting for that today. It was Friday night when the judge told the state that they need to file a written motion if they want to get these videos. And the state, I assume, has filed the motion, but the judge has not responded, at least on the stream yet.
Why would he not want to do that? Because it makes him look bad somehow?
It could be that they're used to allege in a filing that the judge did something wrong.
But again, I don't see how that helps the state. So say they come back guilty, the state won. Say they come back not guilty, the state can't do anything about that because of double jeopardy. Like, I don't get it. What advantage is there to that? Somebody who knows more than me about the law, what could they possibly gain from being able to say, hey, as the state, whether we won or lost, the judge messed up and we can prove it?
I don't know.
I'm pretty sure one of the rules of this channel is don't ask questions I don't know the answer to.
No, ask questions. I just need somebody else to answer it.
Okay, you guys are on. What possible motivation could the state have for trying to catch the judge in doing something wrong?
Okay, I've got an answer now.
Okay.
Let's talk American football for a minute.
That makes sense.
Sometimes the coaches, after a call, will get out there and they'll yell at the referee. They'll yell in their face and they'll be waving their arms and being basically saying, "You're not calling the game fair. Let them play. Let them play." I think that has a psychological effect.
That quote was from Remember the Titans.
It has a psychological effect on the referee, who then tries to even it out a little bit. So if you tell the judge, "Hey, you're not playing fair. You're not calling balls and strikes the way you should," that just alleging that may influence his decision down the road in your favor on the next one.
Playing
That's
the
my
human
thoughts.
instead of playing the game.
It's the 4D chess version. Kathy Keller upgraded membership to jury. Kathy, you now have a padded reserved seat.
Nice.
Yes. No more sleeping tush. Those hard benches, they can get uncomfortable, but not for you. You get a better view and a padded chair. Congratulations and thank you so much. I think the state feels they are losing. They want a mistrial.
Well, they might get one.
I think the state has been watching the jury very closely. I've seen, especially watching the 4-camera views, the prosecutors have been watching the jury's reactions quite a bit. And if we know that juror number 11 has been adamantly nodding in agreement with things that are favorable for the defense, I think they know they have a holdout.
But that would cause a mistrial, which then the state has to either say we're going again or we're not. So they didn't win, but they didn't really lose either. The only way the state loses is if it comes back not guilty. Balls and strikes for your football metaphor. Stretch it. Use all the sports.
Greeners, yay sports, go team. That's all I can do.
I'm totally going to go off topic again. I don't think we've told this story, but oh my gosh, it was so bad. So we went to, we were in Asheville, and there was some sort of huge game that was going on. It was a football game, and we're all of us packed in our car, and we're ready to drive to our hotel or whatever. And as we're going out, it is just tons and tons and tons of these fans. They're everywhere. They're like just mobbing us basically. And Scott rolls down the window and yells out at them, "Your team's gonna lose." I was like, we're gonna die.
You make it sound like I'm one of those rude people who drives around and yells people out of the car windows.
Yeah, no, you totally did. I was like, okay, kids, duck and cover. Remember how we practiced? We're toast.
If I remember correctly, both teams were present when I yelled that.
So you were equally
there were people
insulting.
from both teams. So everyone could just take it like I was yelling at the other team. I thought I was covering my bases, sort of like joining in the revelry for the celebration.
Yeah.
And at the same time doing it in a respectful way. I wasn't no fingers were waved like individual ones. I didn't say anything crude, crass, or rude. I was stating what I believe was true fact. One of the teams is going to lose. I was just stating it to two people just to hedge my bet. And then I drove away.
We were stuck in traffic, like all these people around us, and we're just stuck here, and he's yelling, trying to incite them. I was like, great. This sounds fun.
There were a lot of drunk people there. I will say that. It probably wasn't the best idea. No, you made everyone mad at the same time. It was, I forget who it was. What town were we in? Charlotte?
Oh, that was Charlotte, yeah.
Was that in Charlotte?
Yeah.
It was like a UNC and somebody else. I forget who
it was a big deal, though. They were coming from
it was like
West
a rivalry
Valley.
championship something.
Not West Valley. Hang on. West Virginia.
Yes. Yes, they did. I don't even know who won the game. We left before it started.
No, we did. We watched it. Remember? Later that night, we were looking on the
I still
TV,
don't know who won
and
the
we were
game.
like, "Oh my gosh, those are the people that almost killed us. I wonder who's going to win."
Yeah, I don't remember. You could have yelled, "Our team's going to win," but no, you chose violence. Mountaineers versus Tar Heels. Heather, who won? Clearly, you know it's a rivalry. Don't overshout that, Scotland. No. European football. They take that seriously. I could probably Google that and see who won because it was the last game. It was just a couple of months ago.
Yeah, there's some sort of Mayo championship going on at the same time because we saw the ads for that, and I thought that is disgusting.
Was it Hellman's Mayo or?
I don't know, but they like dumped it on someone. I was like, okay, guys, at some point, do you go home and say, maybe I've just sold my soul?
I'm not sure if it was the losing coach or the winning coach they do this to, but they dump, sometimes they do like Gatorade or like ice water. They did Mayo.
So gross. It was just like, how do you even breathe through that?
I can understand Miracle Whip. I would be like, okay, that's all right. But Mayo is like.
That's where your line is.
Nope.
Yeah, it was gross.
Duke's. It was Duke's. Yes, it was Duke's Mayo. Of course.
Oh.
Because Duke.
I don't know.
All right. This was only a couple months ago. I know. I should probably remember these things.
I know. It's not like we're talking about years ago.
Eric's got a legitimate question here. Eric says, what things do you use the Elgato Stream Deck for? Eric.
Oh, that's legitimate. I thought it was something about court. No, stop. Let's talk about electronics.
Well, it's tangled up. I can't bring it over any closer. You can see right here, right? Hey, there's Mrs. R.A. Don't unplug it, whatever you... No, you're good. It's woven into the
fabric.
The Stream Deck. This actually has about 72 pages of buttons. Each one of these blue buttons enters a new area where I can then, like, say for instance, I can use one button to go and review all the media, like the still images I've saved that I can pull on screen. This one is an actual switcher where I can have standby and what's live. I can switch that. I can adjust audio with volumes and everything else for every single channel. I can run macros. I can do transitions, my upstream key and downstream keyers, which handle like words on the screen. Say, for instance, upstream keyer number 4. If I push 4 over here, helps better when it works. I don't have to do that. I can just turn it on and off, which makes. Did you unplug anything? No?
Maybe.
Well, it's not working. Oh, there it went. It went away. Upstream keyer number 4. There we go. It can turn on off the text on the screen. I can do all my keying, my outputs, as far as stopping and starting the stream. I can run from here. Starting recording on hard disk drive. If I want to save copies, I can build my super source, which is how I look at a lot of different things on the same screen at once. So if I have like an image up here in the corner and I have an image down here, like over me, and I have me over there, I can build that with super source. And it's all basically anything I do on my stream, I can control through that box. And this app costs $50 and it runs. It sends a command from here to my laptop, which then sends it to the switcher. Which
is that one of the few things that is coming with us on our trip?
Yes, definitely.
Okay. So I'm just gonna. Oh nope, it's gone.
What?
Somebody made a comment. It really is gone. Something about he refused to take a plea deal, and that's why the state was so mad at him, and they came harder. So I'm just gonna drop an unpopular opinion here. He just muted me. My unpopular opinion got muted. I believe that what are those called again? The plea deals are unconstitutional. You have a constitutional right to have your day in trial, and by taking a plea deal, you are accepting the punishment for a crime that you do not ever have a trial for. Unconstitutional, and it's often something that you didn't even do.
Is that the boy bailiff?
I don't know, but I like that color of shirt.
It looks like the boy bailiff to me. Looks like he's setting stuff out for the judge, getting things ready. He's supposed to be watching the
notes.
The jury. That is Boiliff for sure.
Is he an adult? Is that like for real?
We're not sure. I know he's got a little bit of a mustache. Nosy Rosie reminds us that we have the best equipment. It's shared ownership.
That's true.
Yes. That's Boiliff. There is movement in the courtroom. We're watching closely here right now just to see if something happens. Looks like the judge is getting, or the boy, I feel bad. His name is Jose. Okay, his name is Jose. Jose is getting the judge's area ready. He took the judge's drinking mug, probably going to fill it up and bring it back, is my guess.
With what, though?
Whatever the judge requests at this point.
He looks really quite young. Is he for real? Is he like a student doing something there?
No, he is the bailiff. He's the sworn bailiff to take care of the jury.
See, I'm going to talk to my kids about that. You can get a serious job at the age of 16.
I'm sure he's over 21. He just has the that blessing of eternal youth.
Yes. And, chutzpah, whatever. He's out there. He's doing stuff. He's getting stuff done.
Let's see. We have another poll on deliberation time. Basically, we all missed it, Britt Bottoms. So you guys want a redo? I'm always perkier and happier and peppy when Mrs. RA is around. Of course.
That's because I talk so fast. He is a man. Okay. Well, he just looks really, really young, which I think that's great. That's really wonderful. I just thought that maybe he was a student or something.
Okay. Somebody asked, Jen, they asked if when your birthday was.
It was many, many years ago.
My wife's name is Jen.
You outed me. I'm just
they
kidding.
don't know it's you. Just kidding. And she does have a birthday. She has a birthday.
I do every single year.
I will tell you this much. She lies about it on social media, so I'm pretty sure she doesn't want it out there publicly.
Yeah, I lie about it
Many
everywhere.
of her closest friends call her on her non-birthday and wish her a happy birthday because it's wrong on social media.
My dad did.
Mm-hmm.
And then my dad's sister was like, that's not her birthday because her birthday's the same day as my daughter's birthday. And my dad was like, oh, whatever. Happy birthday sometime.
How many years have we been together?
What year is it?
2024.
Okay, so 24 years.
Yep, we got married in 2000. So 24. That's like 24 years of you being patient with the world's most amazing man.
Right, yes. That's exactly how that went down.
Not hearing anything from our court watcher, and we're seeing a little bit of movement, but not much. There's one person who's in court over there in the corner, and he's sitting over by the translator's table. So it's his head we see sort of behind the podium, but I'm not sure what he's doing or what his role is.
Before married, we actually only met
6 months.
Is it 6 months?
Yeah, it was pretty quick. She knew I was like a catch
7 months.
from early on.
We got married 7 months after meeting.
Yeah.
Don't get mad at us. We've been married a long time and we're happy most of the time.
It works. Fella, I saw that. You don't have to do all caps. I saw that. That is the head. I don't know who he is. Richard says RA should have taken prison. He would be out by now. No. What are we going to do for our 25th anniversary?
Go to a son's wedding. Hooray!
It's gonna be next year.
No. Oh yeah, no, you're right.
Dry Bear says 36 years here. Sinbad 44 years in September.
Way to go, guys!
That is awesome.
Are you still like super happy about it? Just say yes.
Yes, of course you are. Or is it like at this point it's not worth? No, just kidding.
Don't fight about it. It's fine.
28 years in July. That is cool. I
Sweet.
tell you, there is nobody else I would rather go through with the highs and lows of life and adulthood than my amazing wife.
It's pretty funny that often I'll look at him and I'll sort of unload, this happened, and this person's struggling, and this person's whatever, all these things. Courtney. And I look at him and he just kind of looks back and goes, but we're going through it together, right? It's still fun because the crazy is a part of our story.
Oh, you guys are 57, 55, 30.
That's awesome.
28, 13, 36,
13 years
27,
not married.
46. That is just awesome. 52, 34, and still in love. 30 years last November, still best friends.
That's awesome, you guys. That story needs to get out
Megan's
more
like,
often.
I'm like 10 years in married and I'm over it. what are you guys talking about? Megan.
Wrong podcast.
Oh, man.
Oh, that's funny. Congratulations, though. That's awesome.
25 years divorced. Hey, congratulations. This is inspiring. That's really cool.
Yeah, it really is. That's awesome. Oh, I'm sorry, but I'm glad you still love him.
Horsefeather has a really important question.
Mm-hmm.
What shows do you let your kids watch on TV?
We don't have a TV.
Next question. We honestly don't. We don't have a TV. We instead.
But like we have Amazon Prime.
Yeah. We don't have Netflix. We don't have Hulu. We don't have Disney Plus.
So it's just, I don't have certain ones that I allow them to watch. It's more like when I've had it, then I guess they like, what is that magic show? I can't remember. Where they cook stuff together and it makes magic. I don't remember.
Those kids.
Yeah, it's a kid show. Sorry, I don't know.
A couple girls, they bake magic recipes. Everybody knows what this is.
Denny, I'm sorry, Danny. Danny, my eyes are shot. Sorry. I have to tell you a story about this. This is so funny. This is something that one of my son's teachers taught him. We homeschool, but a lot of times I will outsource specific subjects. So this teacher was just kind of giving life advice about how to de-escalate things. And he said, when you're married for a long time, what you find is that if one person is feeling very strongly about something and is escalating it through, they're just kind of wrapping themselves up and getting really, really into this subject. He says the best thing you can do, just add magic. I saw that. Yes, that's what it's called. The best thing you can do in that situation is to just escalate it way more than they are. So he says, what I do when my wife is like, oh, I'm so mad at this person, this situation's so bad. And he's like, all right, honey, I got some golf clubs in the back. We can take care of this. There's a big old pond over there. They'll never find the body. Let's do it. And his wife will be like, whoa, honey, just chill out.
See, I've got a different philosophy, and I'm usually quiet, but there's a saying that my mom had on the wall by the kitchen sink that says, to keep a marriage full of love, when you're wrong, admit it, and when you're right, shut up.
Yep.
So I'm just quiet a lot. a lot.
Ah, I see how that works.
Yeah.
I do remember one time being quite upset and just kind of getting all wrapped up in my upset. And then I just had this impression. It said, do you want to be right or do you want to be happy? And I thought, I want both. I was like, okay, I'd rather be happy. And so then I just let it go.
Jessica says, homeschool ground zero. I want to open a rage room for people who want to break things. I only heard about this a couple years ago, and it's a step. It's right up there in the same category as the axe throwing.
I don't think that's a good idea.
For some reason, the axe throwing always goes with a bar. So they sell alcohol and you can throw axes, but they go together. But no, a rage room. And correct me if I'm wrong, Jessica, but you basically just rent a room and you're like, well, I'd like the deluxe model with the old TV and something that looks like my husband's Xbox, and you go in there and they give you, a bat or a rock or, steel-toed boots. I forget what it is. And you just destroy the items. And then when you're done, they're like, hey, how was it? And you're like, oh, it's good. I feel better. And I'm like, oh, cool. And they're sweeping it up and they set it up for the next person.
Is this really a thing?
It's a thing. It's a thing. I don't know where you get all this stuff.
My kids' rooms.
It's but it's got to be like a liability. I mean, half the stuff that you smash are probably going to be electronics, right? Let's face it. What else do we get more frustrated with than electronics when they don't do what they're supposed to do, or people are doing what they're supposed to do with it when they're not supposed to do it? So like kids and consoles or computers and things like that.
I get pretty frustrated at recipes. What? It's not supposed to be like this.
Okay, you can't walk away right now because Amber's calling. And
oh,
if
okay.
you do, she will never forgive you.
Oh, I wasn't walking away from her.
Last time she called you, like, oh, I have to go.
That's because the kids were like going crazy in the other room.
Okay, She's holding that story, Amber. Do you believe her?
Sorry, Amber, what's up?
It's okay. She loves me. We have this bond. I just have to say, yes, the rage room is a thing, and there's actually one in Virginia Beach.
Okay, so the people coming out of this rage room, do they feel more calm, or is it like duck and cover? They're fully angry now.
I don't know. I have managed to stay away from that place because I'm pretty sure I'd be thrown out.
There's a limit even for them.
But I have donated materials to the rage room.
Oh, can you like donate your kids' stuff? And then this is like another side business. Imagine this: you rent out the room for people who just want to smash stuff, but then you also have the option for people to pay to have a live stream of their kids' stuff or their husband's stuff be smashed by strangers.
And then you can
so
sell
they're
the
like,
smash stuff.
"Hey, honey," and he's like, "Where's my Xbox? Has anyone seen my controller?" And you're like, "Yeah,
And
let me
just
pull it
give
up on
them
the
the
TV
address.
right here." And there's some guy out there just wailing into that with a bat. This is an idea. Guys, don't tell me I don't give you $1 million ideas, because this is there. This is out there. You're making money twice. Plus,
Hey,
it
Scott.
solves your sourcing problem. You get plenty of good
Scott.
stuff.
Yeah.
Yes, go ahead.
I think that would lead to more court cases to follow.
It's a win-win. It's a win-win.
Oh, man. But yes.
And then we watch the murder
I
trial.
have donated. Well, that escalated quickly.
Yeah. Wow.
But yes, I've donated TVs like the old gosh, what did we call them? They were the dinosaur TVs, tube TVs. There we go. The tube TVs that I want to say it was like a 55-inch tube TV. It was huge. Nobody could pick the thing up by themselves. It sat out on my curb for like 4 weeks for the trash man to come get it, and they didn't want it.
Let me go back. This is the best business idea ever, because literally you can charge like 5 different levels at every point. You can literally charge and have everyone run this for you. Imagine this: you have people out there who are very big into recycling, and they will collect the goods for you so they can be used again, right? And then you have people who just like to clean. Believe it or not, there are people out there who just like to clean. You can offer them the opportunity to clean up just this disastrous mess. Where else do you get a chance to do this?
Cleaning therapy.
Clean it into the recycling, which you can sell, okay? Because precious metals and everything else that's in the electronics, you can sell that. So you charge the people on the front end who go and gather the parts for you. You charge the people for the live stream of them smashing their husband or ex or husband's, golf clubs or anything else. You charge them. You charge the people who are doing the smashing, and you make money when you sell the. I've never seen somebody use the microphone like that.
I
You're
don't
literally
have a
on the floor and it
chair.
reaches you.
I'm sitting on the floor.
Okay, what are we going to name it? What are we going to outrage smash therapy in town? Is what it's called. We have to open this. We have these derelict buildings downtown in town. This is like perfect
I don't know,
for
but
this.
I'm pretty sure Rage Against the Machine is taken.
Well, maybe they could play the music in the background at least. Rally around the family.
Maybe.
No, that's a different one. My sister does cleaning therapy. I'm telling you,
Really?
this is rage cleaning is a thing.
Oh yeah, that's what I do when I'm like, I'm done with this. Everything gets thrown away.
We keep doing your channel too. I'm going to live stream the smashing and narrate everything. Up next
Paula
is
says that she's been to the one in Virginia Beach I mentioned, and they walked out feeling amazing, quote unquote. So there you go.
Can you imagine me doing my golf commentary voice over somebody literally just beating the daylights out of somebody else's prized possessions? I think this is.
I think I would pay money for that.
That's what I'm saying. I could charge you for it as well. It's like 6 people.
I've got that song, "Cause You've Had a Bad Day." It's in my head now, just picturing all these people smashing stuff. "Cause you've had a bad day."
Oh man. I love that idea. That's great. Smash therapy.
Like
Rage.
Hulk. No, you can use that.
No,
Disney.
Disney would sue you.
Hulk
in a heartbeat.
smash.
Yeah.
Yeah. Hulk smash is trademarked.
Britt says I do the dishes when I'm upset. This is sort of like undoing the dishes, and finally,
Permanently doing the dishes.
Wait, do you break the dishes or are they all
everything.
still intact when
Everything.
you're done?
Husband's like, my wife keeps telling me to do the dishes. I brought all the dishes. We're taking care of this. Give me the bat.
Target practice.
Can you bring your own
Dishes are
stuff?
done.
Yeah, make them sign a waiver that says that they own everything. And everyone's going to sign, even if they're lying. And you're like, hey, I did my due diligence. You can't hold me accountable. Would you like a complimentary video of its last moments?
I can imagine. Don't they have like burn parties where you go through a bad breakup and you take all the stuff that they wrote you or gave you or whatever and burn it all?
That's what they do out in the desert. Burning Man.
I grew up in the desert.
No, but Burning Man's like that.
But then other things are found in the desert. It's not a good look for anybody.
That's true.
No, seriously, Burning Man, amongst everything else, amongst the celebration and a little bit of craziness, they have the man they burn. Like, I think it's like a stick it to the man type thing. I've never been. I've got some friends that go. But then at the end, they also have like the temple they burn. And the temple they burn is like everyone puts all their, they spill their soul, and, and put notes in or whatever it is, something they're trying to get rid of. And then it's very cathartic for them just to burn it all and leave the ashes in the
I
desert.
feel like I've seen this in a scene from Mean Girls.
Maybe.
Rand Dizzle says the jury needs to come back ASAP because this waiting is getting expensive. Now we're opening up a whole new business.
Yeah, but it's expensive for other people. We're going to make money.
I mean, I'm just saying, Mrs. R.A., don't kill me. I'm just saying there's only one in Virginia Beach that I'm aware of. So I'm sure there is room for there to be another one between the two of us.
Plus, do they offer live streams?
Right.
I mean, we can set that up.
Yeah, I would be all over that. I'd get like 6 different camera angles in slow-mo. And that if you ever just need a little more satisfaction watching your ex's prized possessions be destroyed, you can watch it, one frame at a time on your big screen.
Nice.
Look at Britt Bottoms.
Let's see, where's Britt Bottoms?
Oh, gosh.
When I got divorced, I went and bought a car, cut my hair, and got a tattoo. Talk about expensive.
Yeah, actually, that's not uncommon. This is going to get dark really fast, but I had a friend whose husband passed away, and I know that's different than divorce, but he passed away after they'd been married for 9 months, and it was a really sad way that he died. And when the insurance check came through, they were like, just a word of advice, don't make any big financial decisions for a year, because after something big and traumatic like that, it's so easy to just say, I don't care, what's the point? And just blow the money on whatever. So sorry, that's a little dark, but that is what they said.
Smash and Dash. That's a good name.
Nice.
Somebody says we do paintball. Tracy, you do paintball. That's how you sort things out.
Honey,
It's
run.
I'll give you 10 seconds, and then I'm opening fire. Just noticed the suitcase in the courtroom is Sarah Boone up next. Oh, my goodness. Kathy, that's actually the court recorder's suitcase, the stenographer.
Is that her typewriter thing? Because that is big.
There's a rage room in Greenville, North Carolina. I've never been.
That doesn't
There
surprise
we go.
me.
We have local competition.
Well, there's a lot of rage going on not in that room.
They take it to the streets, Anthony. They literally they take it to the streets in Greenville. I've seen people cut people off. No, never mind. Too soon.
Oh, yeah. Okay, yep. All right, that one, I deserved that.
I'm sorry.
It's a little soon, but
It's a little
definitely
wrong.
that was my fault.
That was just wrong.
I know. I had a situation on Saturday that I could not locate my son. He was super excited to take part in this competition that he does, Ninja Warrior what's it called? Ninja.
It's like American Ninja Warrior stuff.
Yeah.
It's jumping around like a monkey.
Yeah, it's crazy.
Maybe like swinging, and it's muscle and body control and
It's
obstacles and
amazing
weird
what he does.
contraptions.
And he got first place and he qualified,
He
right?
won.
So it was really awesome. But trying to find him, he was at another activity and they just said, hey, it's at this place.
They were
and
doing
gave
like
me...
a cleanup at like a lake or a
We
river.
have defense in the courtroom.
Yes, they're sort of coming up. They don't look
I'm
urgent
going to
though.
hang up now.
Okay, see ya.
Okay.
Thanks, Amber.
So I'm trying to find my son, and I the address I had was wrong by miles and miles and miles. And so when I got in there and I was like, hey, I'm late, I need my son, they were like, he's not here. He's probably at this other place that's way far away. And they said, just type it into your phone. Just put the address in your phone. And I was like,
Good idea.
I hate all of you because I don't have a phone.
Why
And
is that?
so I was like making my life difficult. So I was like, okay, fine, whatever. So I took her advice and she told me, she was like, oh, you go to the Ford dealership and you turn left and then your first right, you turn right. And then it's, just type it into your thing. I was like, okay, fine. I've got a TomTom in the car. I can probably type it in. And I get there and the TomTom is not in my car. And I'm so lost and I'm so upset that he's not going to get to this thing. And I was just really not smart. And I flipped a Yui in front of a huge garbage truck, thought I had enough space and time to get moving in front of it. I didn't. Had to swerve out of the way. He was swerving. We almost hit. He laid on his horn. It was my fault. I feel horrible about that situation. It was bad, 100% on me. And yeah, it was bad. It's too soon. It's not funny yet.
It's not funny. It's still raw.
It's going to be funny in a month or so. But right now, I just feel like it was just terrible decision on my part. So,
You don't have a phone. Can we talk about why you don't have a phone?
No.
Is that too much? We're done talking about things. Next topic. Let's see.
my husband won't buy me a phone. He's mean. Don't. It's because I'm cheap. I don't want to spend money on something that I don't use very often. I know. Yeah. I know. I need a phone. It would have solved that. So would the TomTom. But you know what, guys? Miraculously, and it was miraculous, I found him. And I found him on time. And we ran
got him to
back.
the competition on time, and he won.
Well, it wasn't on time. We had the time wrong, and so we were there
Late.
on accident. But that was on time. But it worked.
Yeah, so it was fun. All right. Martha's like, he has offered multiple times. Martha's like, I've been counting how many times that he has offered to buy you a phone.
I know. Every time I have a bruise, I'm like, Scott, hit me. Scott's like, it's not funny, Jen. This world we live in, it's not funny.
I've issued an ultimatum, which has obviously worked many times. Where I say, okay, now that's the last thing, right? Now we're going to get a phone. Now you can see why it's a necessity.
Okay,
and I've even gotten a confirmation, like, yeah. And where are we? We still don't have a phone.
I did though. Last time I got in an accident, which was years and years and years ago, I got in a wreck and it was really bad, and I didn't have a cell phone to call Scott, so I called him. I'm trying to fix this. I think I might actually be breaking it. Sorry. Anyway, I called him using somebody else's cell phone who just came by and was like, "Are you okay?" And I was
like
fine.
I would be if I had a phone.
So I called Scott, and as soon as I was on the phone with him, I just broke down and bawled. I was like, "Oh, I've been in an accident," and blah, blah, blah. And so then she left. Scott's on the middle of a lake fishing. He doesn't answer the phone at the time, just gets the message, freaks out, comes home, but he's far away. And anyway, the point is, at that point, I was like, yes, it would help if I had a phone. So I got a phone. I had one for a year, like never, ever used it, never gotten in an accident. So I was like, yeah, we're fine. I've clearly outgrown the need.
When I was in the middle of a lake fishing, I was over a school of massive crappie in a kayak.
Kidding me?
In 120 feet of water, trying to hold my place over this school of crappie. Excellent. Best crappie fishing of my life. And then I had to paddle into the wind. I think it was about 3/4 of a mile to get back to the truck.
Yeah.
To get home. So me being late that's why. I immediately left and headed home, but it was a long way.
Yeah. Well, normally I have a kid who has a phone on him, so it's very seldom that I'm without access to some phone. Yep.
uphill both ways.
Yep.
It was on Pineview Reservoir. It was beautiful in the Narrows. They're down by the dam.
And I was fine, guys. It's okay. You see how concerned he is here?
We're still talking about the fish. All right. Well, there has been a little movement here. I've seen that the defense lawyer was over there briefly, so we think that they may be nearby.
Domestic violence is not funny. I'm not trying to make fun of that. I just like making Scott uncomfortable in public situations, which maybe is not appropriate either, but it's way less of a problem than domestic violence is not funny.
Yeah. Oh, I think he was replying to something else.
Oh.
But let's see. How old were the kids when phones were allowed?
Okay, so that is not an age thing. It is a maturity thing. So they have to show that they are capable of maintaining things that require autonomy. You know, can you keep your room clean on your own? Are you capable of managing your time on your own? Do you do well in school on your own? Things that are age appropriate that they show that they can handle. Self-control, that's when I will say, okay, then you're ready to start taking on that next level of self-control.
I see Daybell is back in session. Thumbs up on the audio. Were you all good there? Anything you need me to pin, or are you good? Let's see. Oh, it has reactions still. I need to get rid of those reaction buttons. Sorry. Live reactions gone. Save. I wish I could change that setting. Okay. All right. Still on verdict watch. This jury is putting in an extra day. 13 hours in.
Wow. Probably not, Megan. I think you stick it on a scale. I doubt it.
Betsy Leak, welcome to the gallery. Love the green courthouse. Thank you. Okay. Get her phone on her fake birthday listed on her social media accounts. The cheapest one you can find. I remember her real birthday. So that's good. They're taking the judge's word from Friday to heart. Yes, they are. I think they're like, well, the judge says we have to try longer. Not harder, but just try longer. So I guess we have to sit here for longer and then tell him the same thing we told him before.
We're not working hard enough, guys. Let's put in a little more effort.
Warrior says, I thought it was brilliant when I came up with the Rage Smash idea during COVID, only to find out that it already existed. I was so
we've
mad.
done that so many times. Mrs. Ori isn't even her real name. That is hilarious. Greeners.
It's true. I wonder what insurance would be. I mean, honestly, in nowadays with, where everyone's so lawsuit happy,
yeah.
What would insurance be sending somebody in there? The waiver has got to be like 15 pages long. It's like, if you smash something with one of our tools and it breaks and it bounces off the wall and pokes you in the eye, you still agree not to sue.
Yeah.
Here's a good one. Winnaboo.
Do you like facial hair or not on Ari? I like him both. Both ways.
She likes both of me.
Both. All of his personalities.
I'm not brave enough to change my screen name.
I'm not smart enough.
I have to ask Adam. Adam or
Yeah, Adam has clearly figured it out. They wanted lunch on the court. I do wonder if they're like, because listening to it, he said you didn't do it long enough. He didn't say hard enough.
I got an update from Laura.
Let's hear it.
We'll recess at 12 noon till 1:30 p.m. for lunch, if no word from jury in the next 5 minutes. And it's just about been the 5 minutes. So I think they are going to lunch. How old is your sister's kid? Close in age to yours? I got a lot of sisters.
Are they talking to us?
I'm a recovery addict. I'm the
What?
Orange.
What?
Now, this is my channel. I do this thing on YouTube.
I was wondering what you were doing all the time. Which sister's kid?
My oldest
is
probably the ones that are closest.
We have lots and lots of siblings with lots and lots of kids, and they overlap our kids a lot. So, yes.
Yep. They make you wear PPE, which is personal protective equipment for those that aren't.
Didn't live through COVID.
Yeah.
I mean,
You're funny.
Constantly saying that.
I feel like the Marshmallow Man, but the waivers were crazy. I wonder. I mean, you got to protect your investment somehow. But who signs the bill on that? They're like, yeah, that's a good business plan. We'll go ahead and underwrite that.
Of course, what are they going to sue you for? All of our stuff just got smashed. Like we have no assets.
Open as an LLC. We are our own entity. We do have a home phone. It's a VoIP phone, so it's not like a traditional home phone with a landline. It's over the internet. Which you've heard about that a little bit because it's through Vonage, and they keep giving our phone number away.
Yes, we have it sometimes. Your wife's sister that she talked about before. Oh, Lance, guys, it's been more than a second. It's out of my head. I don't know. Your wife's sister. So my sister that I talked about. I don't know. I have a bunch.
I don't know. Let's pop in on Daybell really quickly, shall we?
Okay.
Let's see what's going on over there.
Your Honor, may I publish State's Exhibit 4?
Yes.
It says Colby. You said somebody was on the stand. I'm trying to see who this is. We just got it in the little box. We've got.
Mr. Ryan, do you recognize that individual?
Oh man.
What?
Yes. And if you need a drink of water,
that's the boy.
I don't know if there's tissues up there.
Yeah,
I'm good.
That was her son.
Who is that?
That is my brother, JJ.
Man, heartbreaking.
And what is your specific relation to JJ?
Well,
he is my adopted brother.
Okay. Anyway, that's going on. That's going to be a painful one. If you want to watch that going on over on the Top Mark Media channel right now, while we wait for this one to come back. So, can you imagine panic room, rage room mix up? Sir, stop breaking stuff.
That would make a really funny skit if you could do it right.
I'll share a secret. My husband started an axe throwing mobile thing. I'm terrified. Okay, Nosy Rosie, this is funny. Axe throwing is extremely popular, but mobile allows you to basically bring that to like a wedding or a corporate event. And so you show up and you just set up the cage and everyone can throw. I think that's a great model. It lowers your overhead by a ton, and probably makes it a little cheaper on the insurance as well. Man, that's awesome. They called the lawyers back so the jury could go to lunch. The jury is still deliberating. They're working through lunch, but the lawyers are taking a break. And so they're currently in the break for an hour and a half.
Man, I just have so much sympathy for this jury.
So how about we take a lunch break as well? Because we know that nothing's going to happen while everyone's out at lunch.
It's the best tool we have to make something happen.
Because we're already 5.5 hours into this stream, and we want to sort of end it at before 6, especially if a verdict comes in, because that causes problems for the channel.
Oh, I thought you said yesterday that your sister's kid had the same birthday. Okay. No, but it's something else, but I don't want to say it because I feel like I'm giving out too much personal information. Somebody else has the similar birthday or the same birthday.
Always wanted to open a bookstore with a bar. Usually it's like a coffee, a coffee place, and then with books. It's going to go down when you go. Hey, that's good. If it goes down, we'll come right back up. If it goes down, I'll just pop back up. And I've got Laura in court. She's going to give me the updates. They're not going to do anything without the Kellys there, and Laura's with the Kellys. So we're going to get notification. Can you leave the line feed up so leave the line feed up so while you're gone we can see if anything goes on. Becky, what I can do is I can
start a new one.
I have to start a new one. I can't leave it up over the break. I can bring it up soon. But here's the problem. If for some reason the pool cameraman decided to start playing music on his iPod while he's sitting in court by himself, I have to be here to immediately shut it down before I get a copyright strike. So I can't leave a feed up that I can't directly control without being here during that. But we'll keep watching it. We've got the live feed up from Chad Daybell over on Top Mark Media, and we'll be. I promise you, we'll just come right back as soon as the live starts. Does that work? Feed for this case is on the local news. It is.
I've got tub thumping in my head now. Stream gets knocked down and we get up again.
Intervener. Good job. I think that's it. Let's wrap it up. Let's go to lunch. I already had my lunch, but you guys deserve a lunch as well. So
You guys need to work harder. That's all I'm saying.
Creative Beat just got back. Any news from AZ? Here's where we are. The judge and the lawyers just agreed to go to lunch. The jury is still working. They have not heard anything from the jury this morning that we have heard of. And so the jury has been deliberating all morning long since 8:30. Since they worked through lunch before, we think they're working through lunch again. So we'll keep the counter going on the deliberation time. And we're over 13 hours of deliberation, which we started about 9.5 this morning. So we got 4 hours in. And we're going to take a lunch. You guys get to take lunch. We'll be back this afternoon with more Verdict Watch, maybe some more court hopping. We have that case up in Thurston, Washington, where we have a jury selection. Which, if you haven't seen Thurston, Washington jury selection yet, you haven't lived. It is so fun to actually see the jury and get to hear some of the questions and the back and forth. I think that's a lot of fun. I think that'll be a super fast trial. The opening's going to be 10 minutes or 15 minutes each. 15 minutes on voir dire for each jury. Openings are 10 minutes, closings 15. And it's like no witnesses. It's just defense, the only witness, one or two witnesses for the prosecution. It'll be really, really fast. I think it's a harassment case as well, which we've never followed. Okay. Just got back. Myra, we're going to take a lunch break, and we're going to have, I think, about an hour. If anything happens in court, we'll be back sooner. Is that fair? What time? It is 3:15 Eastern. We'll be back by 4:15 Eastern or sooner if anything happens in court. Obviously, if there's a question or any activity that our court watchers alert us to, we'll be back for that. I love having Mrs. Aria with me. Sorry to make you stand the whole time. Do you want to switch places next time?
Yeah, let's do that.
You sit here.
I bet they won't notice.
You work all the buttons.
Yeah, what could go wrong?
All right. Do you want to do the outro?
When you go home tonight, hug the people you love. Smile at those who look sad. I don't remember it. Be awesome.
How about you do your outro?
I can't remember your outro. I'm sorry.
Mrs. R.A. tells people that what you're doing is very important and it matters, and you're doing a better job than you think you are. For me, I'm going to say tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again, which is about 1 hour from now. With Verdict Watch continues, part 2. I guess part 4 is coming up. Part 4.
Because he's the guy.
Because he is the guy. I actually have a soundbite for that, but I can't find it. What's this one say?
I don't think that's him, Mark. I don't think that's him.
I haven't used that in forever. Where's that button hiding?
Oh boy.
There's a canine.
You guys, we'll see you after lunch. Have a good one.